Hello and welcome to lecture number 60 of topic 6, which is about freedoms with respect to Article 19. Now, why is this particularly important? It is important because we're going to be discussing this from the point of view of the mains, and we're going to specifically be focusing on films. Now, at the outset, we must understand that there has already been a previous year question on films. So the chances of a question again coming on specifically films and Article 19 seems very unlikely. And the question that was asked in the previous years was a part of a larger question in 2014, which was, what do you understand by the concept of freedom of speech and expression? Does it include hate speech? And why are films considered different from other forms of it? But films also become, or the conflict between freedom in films and Article 19 become a very important topic, not only from a polity point of view, but also gives you great examples in ethics to ponder upon. So at the outset, let's first understand how does it all work and in the context that it all works in. Now, when we're talking about films in general, we understand that films will relate to the word expression under Article 19, Clause 1, Clause A, because they are in a beyond verbal form, though it contains verbal delivery of dialogues, but what it also has is an audio-visual representation. And due to the audio-visual representation, it comes under the category of what is called an expression. Now, films will have two primary components. One, the people who are acting in the films, and two, the institutional setup behind the films, which include the directors or the producers or the making houses. Now, when we compare films to print media, or specifically news print media, we understand that in the case of newsprint media, the general discourse by the judiciary has always been in a positive direction. The judiciary has always worked very hard to increase the scope and to give more freedom and power to print news media. But that is not the case with films. When we look at judicial discourses in films, we will see that there have been differentiating and very fluctuating decisions on films, largely because films are driven on a case-by-case basis. And as a result of it, we can never have a uniformity as far as judicial decision-making is concerned. Now, when we look at the reasonable restrictions, of course, films may also rarely have an impact on the sovereignty and the security of the country if the films are showcasing something which is going to cause disharmony in society or may cause certain actions in society which may breach law and order. Films sometimes can also show us a conflict of friendly relations with foreign countries, which may affect friendly relations with foreign countries rather adversely if it is a film which has an issue which has a cross-border implication. But most importantly, the highest overlap of films will continue to be in the issues of public order, decency, or morality. Now, with respect to public order, decency, and morality, partially to do with obscenity, with violence, with objectification of women, to a degree of nudity, and all of those largely become question marks on public order, decency, and morality. Apart from that, sometimes films which have a documentary tinge to it or are portraying a certain incident that has happened can often lead to questions with respect to defamation, or can incite people to take up arms for some reasons or the other. Now, apart from this, if there are restrictions that are placed as far as filmmakers are concerned, or if there are sort of prohibitions that are made to a film, It also affects the freedom to make a film, which is also a right to have a profession of filmmaking, and it can be restricted in the interests of general public. So this is the larger ecosystem under which film censorship works. Now, we've already understood in the lecture on media policy that it is regulated by the Cinematograph Act. The Cinematograph Act also allows for the creation of censor board. We used to previously have a film certification appellate tribunal, which was abolished in 2021. The Film Certificate Appellate Tribunal was the appellate authority where decisions given by the censor board could be challenged, could be re-looked at, could be re-examined. But now it has all been put back within the government domain through an amendment that has happened to the Cinematograph Act, and also through a law which has abolished the tribunal in the first place. Now, the larger issue still remains is with respect to how we are dealing with the entire notion of film censorship. So we'll first understand certain judgments around it. After understanding the judgments, we will look at the institution of film censorship with some very, very exhaustive examples and a walkthrough of the major issues around film censorship to begin with. So let's start. When we look at important Supreme Court judgments, the first judgment or the first landmark judgment was actually from where a question was asked in the UPSC. When in 2014, they asked you a question which categorically read this particularly, that why are films on a slightly different plane from other forms of expression? The fact that films were different from the other forms of expression was discussed for the first time in the case of Abbas, which is essentially a 1970 case. So first, let us understand what the case was about, and then we can understand what happened and what did not happen. It is indeed a very, very interesting case. Abbas in this case was a journalist, a playwright, a writer, and a film producer. Abbas had produced a short film called A Tale of Four Cities, which was showcasing or depicting the contemporary realities of life in back in the day Bombay, Calcutta, Delhi and Madras. Now, what was interesting about the film was that the film had contrasted the luxurious lives of the rich with the perils of poverty. And he had sought what is called a U certificate. Now, fundamentally, our Censor Board of India awards 5 kinds of certificates. One is for universal, which means anybody can watch it. Second is A for adult, which means only people above the age of 18 can watch it. Then you have U/A, which is essentially where unrestricted viewing can happen, but you require parental guidance for people below the age of 12. And then we have S, which is a special class of rating which is given for, say, specialized people, that this movie can only be watched by doctors or scientists or researchers. And apart from this, the censor board can decide to not certify the film at all. Now, for granting a U certificate, the censor board recommended that it should be a certificate restricting only to people who are adults. Now, this was, of course, decided. This was also then recommended by a senior committee. And then the decision was appealed, and the central government had recommended that it will still be an adult certificate because there was a scene which was set in a red light area. So if you remove the red light area scene, then we can give you a universal certificate. Because according to the central government and the censor board, the scene was suggestively portraying immoral trafficking, prostitution, economic exploitation by pimps, and all of those. So the scene was, of course, considered unsuitable. So what fundamentally happened was they wanted a U certificate. They were being given A certificate. Now, for this, of course, a petition was filed in the Supreme Court saying that this person Abbas's right to freedom of speech has been curtailed. Now, very interestingly, the Supreme Court actually upheld the decision of the censor board and the central government, saying that the restrictions that were being placed on public exhibition for this film were actually valid, and the Supreme Court had rejected Abbas's request to make it a universal film. And after the film was denied an unrestricted viewing certificate, which is what the letter U stands for, he could only get a U certificate if he removed that scene which was unsuitable for children. And there is no way that the courts would even have allowed it. But what was interestingly held as a principle in this has been actually used in a lot of decisions in a lot of ways beyond it. Basically, the Supreme Court stated that films have to be treated differently from other forms of art and expression, as the motion picture has the ability to stir up emotions more deeply than any other form of art and censorship on films on any of the grounds mentioned under Article 19, because any of the grounds which are mentioned under Article 19 Clause 2 is justified. And that becomes very, very interesting. Now, having said that, this judgment, the initial one, had a very narrowed, a very restricted effect on how films and censorship were being viewed. A few years later, in 1996, the name of the film will sound very familiar to a lot of you. The case is called Bobby Art International versus Hoon. It's a 1996 judgment. This case is a very interesting one because Bobby Art International is a film production company, and they had made a film called Bandit Queen, which was based on the story of a village girl who was raped and brutalized, and then subsequently became a member of a violent criminal gang as a means to revenge herself upon society. This book, I remember, was written, this film was written on a book by somebody called Malasen. And of course, this film contained explicit scenes of rape and nudity. And therefore, in 1995, the censor board indicated that this film will only be given an adult certificate or an A certificate, largely because the scenes were unsuitable. Now, as a result, this became a question. Now, why? Is because the scenes were obviously very objectionable. But in a very surprising turn of events, what was disclosed by the Supreme Court was the intent and the context behind the scenes. Because the movie was about Bandit Queen, and the Bandit Queen became the Bandit Queen because of what she had gone through. And unless you could show what it had gone through, it would not do justice to the film. So initially what had happened was, when the censor board had given it an A certificate, that A certificate was of course questioned. And not only this, the film was severely restricted. Now in 1995, the film for the first time was released at a film festival. And then specifically, there was a gentleman called Ompal Singh Hoon, hence the name called Hoon, filed a petition in the Delhi High Court. He came from one of the communities that was portrayed in the film, saying that this A certificate should also be taken away and the film should be banned. Now, the Delhi High Court, of course, sided with Mr. Hoon. And then the Bombay Art International Production Company filed an appeal against the favorable judgment of Mr. Hoon. And that is when the Supreme Court reversed the Delhi High Court judgment and said that the screening of a film cannot be prohibited merely because it depicts obscene or graphic events. It was done because a true story was told, and the story would not be true if these events were not being disclosed in the film. So that became very, very important. Now, this judgment confirms that the freedom of expression and creative expression cannot be restricted simply because the content of that expression is obscene or even indecent or even immoral. Now, the Indian Supreme Court therefore emphasized that the importance of allowing such kind of a social commentary, such kind of commentary through artistic expression is very essential, because it will help the society understand what the society itself has done to people. And just because there is a perceived threat to the society's moral value system, that is not significant enough, or that is not just enough to, let us say, restrict the freedom of expression. So this became a reversal judgment. And then in 2018, a judgment which was very popularly known not because of the name of the case, but the name of the film that the case was about, Viacom 18 Media Private Limited versus India versus Union of India in 2018. Now let us understand what is this movie about. As you would have rightly guessed, this movie is about Padmavat. The movie is called Padmavat. Viacom 18 Media Private Limited were the producers of a film called Padmavat, which was a historical film starring two very well-known actors in the country. It was a historical film which was based on an epic poem called Padmavat, which was describing the valor of the 14th century Queen Padmavat of Chittor, which is in Rajasthan, of the high Rajput caste, and the obsession of the Muslim ruler Alauddin Khilji. Now the censor board had given the film a U/A certificate that anybody can watch this movie, but you require parental guidance if the child is watching below the age of 12. And it also requested it ordered, in fact not requested, certain minor edits that had to be done to the film. And one of the edits was that there has to be a specific disclaimer which has to be added in the film, that the film is based on the account of the poet Muhammadi Jayasi, and it is considered fiction and does not seek to represent a historically accurate account. Now, prior to the release of the film, there was massive public condemnation. There was a lot of protests, a little bit of violence also here or there. And there were a lot of threats by the groups of Rajputs in relations to verified concerns that Rajput queen was being portrayed as a dream sequence, displaying the romance between the queen of the kingdom and the invading Muslim ruler of the Delhi Sultanate, Alauddin Khilji. The producers obviously categorically denied it. Now, the film was given a UA clearance by the Central Board of Film Certification. But the states of Gujarat and Maharashtra issued notifications to suspend the film because of the threat to public order, which is also allowed. While the states of Madhya Pradesh and Haryana decided to completely ban the screening of the film. So as a result, this eventually reached the court. And the Supreme Court overturned these decisions by all the 4 states to ban the screening of the film. And therefore, the court reasoned that creative content was an inseparable part of the freedom of speech and expression. And though Article 19 Clause 1 was not an absolute right, and there were regulatory measures, and if the censor board thought the film was okay, the film was okay. And that makes its primary essence, that the censor board has been created by a parliamentary law, and if they deem fit for a film to be fit for public viewing, then it does not matter. And therefore, this case expands expression by even preventing prior censorship by state governments after a film has already received certification. Now, what is ironical is now that in 2021, once the Film Tribunal has been abolished and we have made amendments to the Cinematograph Act, now you can recall a film, you can stop a film from continuing if valid objections have received on the film by any member of society, which therefore, of course, makes it slightly more complicated. So this is the general understanding, the general sort of uh, uh, overview of the important judgments and the basic concepts with respect to films. Now, having said that, let us now understand a larger analytical context, some interesting instances. See, undoubtedly, media is an essential part of democracy because media shapes the way democracy looks at democratic institutions. And media, therefore, takes a lot of pride in creating or changing or portraying the views of the public at large. Now, in India, what has now happened is social media has taken over significantly from traditional media. But in this transition of traditional media and social media, cinema or films have proven to be a medium that has survived the test of time. That's what makes films incredibly important. Because as much as we see the internet, as much as we see a change in the way things are happening, but fundamentally, films have survived the test of time. Because watching a film is not about just watching a piece of art. It is also the experience, a sense of outing, a sense of recreation for a lot of families. Now, with global markets of America, China, France, that have now opened up for Indian cinema, there has of course been a steep increase in the right of in the rights of offbeat content which is often understood as sensitive or objectionable or controversial in many parts of the country. So therefore, it has to be looked at in that angle. And films, at the end of the day, are any other medium. And like any other medium, should not be treated above the law, and they're not treated above the law. But films have to specifically undergo, as we've understood so far, a process of certification. And this certification process is a legal process mandated by law and also through a statutory body, through the censor board or the Central Board for Film Certification in India. But this legal process has led to several instances of films being banned or restricted or edited or massive cuts being recommended. So the question is, does the law really intend to draw the line between what is moral and immoral? Or does the law largely seek to be an age-old process which is not changing to adapting times? Are we not more sensitive about the way films are being made? Right? Now, let's understand from a very introductory point of view. You may remember that cinema has been an integral point of a common man's life for a very long time. It was in 1913 when we started being exposed to cinema for the first time. And in fact, a lot has changed from the times where people used to wait for hours just to watch like a 1 minute clip on Doordarshan, which was the only TV channel, by the way, till 1991, to, dangals proud Olympic national moment, which was being played across 9,000 screens in China, which made Dangal such a successful movie in China. Now, according to statistics, India has the largest film industry in the world. And in terms of the number of films, we make anything between 1,500 to 2,000 films, which are produced every year in different languages. And these are produced in a diversity of content, produced in a diversity of languages, and they deal with a lot of sensitive cases, sensitive issues, objectionable questions, and so on and so forth. And that is the general context of it. Second, let's understand a little bit of history. As we started our introductory remarks on this, much before screen cinema could assert its authority, so to speak, in a traditional theater system which has sort of existed from the 20s and has 1920s and has sort of made a very significant role in building in an audience. It was in 1913 that India produced its first full feature-length film. In 1913, the film was called Raja Harishchandra. And this led to the first Censorship Act, or the first Cinematograph Act of 1918. So, very interestingly, the censor board came after the first film came. The censor boards never existed before films. And back in the day, in the British times, we had regional censor boards. We had censor boards in Bombay, Calcutta, Madras, and Rangoon at that time. And they had territorial jurisdiction around it. And therefore, you had the censor boards of that time used to publish a detailed list of, say, 43, 45 items, which were prohibited from being shown in films. And therefore, you had to deal with, say, editing a lot of kissing scenes, rebellion, portrayal of national leaders, the way it was being dealt, and all of those things. But in the 1940s, this very art and cinema played a very, very strong role in our, independence movement, in our national struggle, because the focus shifted from romanticism to patriotism and love for the country. And through that, cinema therefore became a very, very powerful medium of communicating what one needed to communicate. And then after independence, as we would know, we set up the Cinematograph Act in 1952. And this led to, of course, creating the Central Bureau of Film Certification of India, or the Censor Board. Now, the early years are often referred to as the golden years of Indian cinema, because India was doing very well at international film festivals. There was a Hindi movie at that time called Mother India, which was nominated for the Oscar Awards or the Academy Awards at that time for the best foreign language film. And Mother India essentially became the beginning of offbeat cinema in India that sort of came along. But it also parallelly saw a little bit of history of the censor board. See, till about 1933, it was called the Central Board for Film Censorship. Then it became, after 1983, the Censor Board for Film Certification. Now, this nomenclature change is not important for you to know. It is just something, the basic concept of the mentality or the policies to reflect. Now, the Censor Board, of course, has two powers. One, to certify a film, or refusal to certify a film. And ever since, I think in 1959 or 1960, where there was a Bengali film called Neel Akshar Nishchay, it was banned for about 2 months because of political disharmony. The censor board has been a very important cog for the increasing number of films that have faced problems for it to be released. And ever since, we have, of course, seen a lot of movies that have come about for a lot of reasons around it. So let's now quickly jump to contemporary times to just give you a context. So from the 1950s, we just fast forward and come to 2019 because details are not important for your exam. Otherwise, the history of censorship in itself is a very interesting academic subject from a legal perspective and a socio-political perspective. But having said that, I remember in 1919 there was a movie in 2019 there was a movie called Chidiya Khanna. Now Chidiya Khanna was essentially a movie about a life of a boy from Bihar and his dream of playing football, and it addressed a lot of social issues in that context pertaining to caste and everything else. And it was given a UA certificate, which was not unrestricted way. Now, this decision was then challenged before the Bombay High Court after, of course, the censor board had given its due call. And it was challenged by the Children's Free Society. They said that they wanted to, show the film in schools to children, but because there was a UA license and we could not give unrestricted viewing to people below the age of 12, so it could not be done. The Bombay High Court at that time had literally slammed the board, saying that it is just a certifying authority and not a censor board. And therefore, it has no intellectual morality or authority to decide what one wants to see. The court also then came very hard on the board for pretending that these serious issues don't exist, as it was shown in that movie called Chidiya Khanna. A little before 2019, I think in 2018, around the same time, this is a very popular movie called Yr, which is very popularly seen on TV these days. The censor board had asked the makers of Yr to get permission from the defense ministry, because indirectly the movie Yr was relating to the Adarsh housing scam of Bombay, wherein flats which were for war widows of the Kargil war had brought a lot of national shame to us, and it involved some very high profile people also. In fact, the movie was also very specially screened for officials and then was only granted a certificate after some recommendations were made by those officials. So as you can see, from a Chidiya Khanna to an Ayari, there is very different and a very fluctuating format of the way we look at it through the lens of the law. In 2016, there was a movie called The Jungle Book. Now, The Jungle Book is essentially about Mowgli. And there also, the censor board was essentially had given the movie a UA rating, despite the fact that it was based on something which was a pure children's classic. So this shows you the kind of fluctuating tendencies with three examples that I've given you: Chidiya Khanna, Ayari, and The Jungle Book. Now, fourth point. Films are no longer just instances of entertainment. In fact, films are a little more than that. And with the unbelievable amount of fandom, the promotions, and the business sort of that goes around films, it is safe to say that films are not just watched in India, they're also being closely watched by people all across the world. Which is why in the Abbas versus Union of India judgment of the 70s, the Supreme Court very clearly said that though films are a medium, they have to be treated differently from other forms of art and expression, because the motion picture, the film, has the ability to stir up emotions more deeply than any other form of art and censorship at that time. And the censorship on films has to necessarily be on any of the grounds that are mentioned in 19.2, otherwise it is not. And it is because the reach of a global medium called cinema has made films the carriers of social messaging. And it is a global phenomena that requires no language, which is why when we talk about films and when we talk about OTT, they have the same sort of fluidity to travel globally. And that makes it very, very interesting from a filmography point of view. Now, the censor board can certify, cannot certify, can suggest changes before they certify. And you will see again a few passes and a few misses when it comes to censor board. So, though the stand is sort of clear, which is taken by the censor board, that the film has obscene content which is excessive, and but it doesn't seem justifiable, then the film is going to be severely treated by the board. But a lot of films that have passed the censor board with a leniency certificate, with a better certificate, have also had objectionable content, which the board has sometimes allowed. For example, there was a movie called Mohenjo-daro. Mohenjo-daro was passed by the censor board with no cuts whatsoever, despite numerous intimate scenes, and there was a term that was used, un-Indian, uh, in the context of the movie, and I sort of taken a very stubborn stand, saying that this is okay. Similarly, Bollywood's adaptation of modern adaptation of Romeo and Juliet, the movie was called Ram Leela. A movie was shot in setting of violent times, but it also had a good number of kissing scenes, was surprisingly given a US certificate, whereas Shahid in 2013, which was the biopic of a lawyer and a human rights activist, had received sort of an A certificate despite the changes. And coincidentally, the real life of Shahid had defended the film Black Friday when it had released around the same time. So the way the censor board works in itself is, of course, a little bit of a problematic idea, right? But at the same time, cinema in itself has changed sort of discourses, and that became a very, very important part. Like, for example, in a documentary on the life of Amartya Sen, the censor board asked the makers of the documentary to beep the words cow, Hindu India, or Gujarat, because it was a reference to the Prime Minister's home state. This had happened in 2017. Now, similarly, there have been other issues with respect to cinema, that cinema has shown obscenity, has shown objectification of women, and that has led to apparently some negative connotations. There have also been statements that have made that rapes have increased because of films, because they arouse lustful thoughts, which in my view is a very compromised and very wrong statement to make, because the understanding of rape is never sexual urge. It is about male ego or male dominance or male superiority. Now, kissing scenes, for example, from 1929, which is essentially a throw of dice, or the movie was called Throw of Dice. Item songs became prominent in Bollywood from 1975. Were the cases of rapes high then? The answer is, of course, no. If the films had influenced people's thinking so much, then agriculture would have uplifted after a movie called Upkar in 1967. Army recruitment would have doubled up because of a movie called Border in 1997 or Lakshya in 2004. And youngsters would have shot down politicians after watching the movie called Rang De Basanti. And that shows you the kind of work and the kind of, sort of open-endedness movies in India have chosen to demonstrate. And on top of that, there has also been a larger issue of the judiciary versus the censor board. And there have been several cases of that. For example, there was a movie called Urta Punjab that, nowadays generations are very familiar with. Urta Punjab, which was a film which was submitted to the censor board, was asked to make close to 90 cuts in the film. And then it was reduced to say 40 cuts eventually after some negotiations. without the reference of the word Punjab or the state Punjab. Imagine Urta Punjab without the reference to Punjab. The board wanted the story to be played out in a dystopian, in a non-named land, and which was essentially the case of the land of Punjab. The studio, the production house of the movie, approached the Bombay High Court, and the Bombay High Court allowed the movie with just one cut to the movie. So therefore, we have seen a lot of confrontation also between the judiciary and the censor board. There are a lot of other movies also, but you don't have to remember them generally. So what are our key outcomes? Key outcome number one is the censor board does not treat all films equally because there are some contradictions in the way censorship has been given. Two, when it comes to cinema, it's for the people that they're made, and the people should be ultimately the best judges. So we must have a limited sort of censorship with, of course, some ground rules that cannot be broken. See, like films like, for example, 50 Shades of Grey, which was brought down by the board, but has received a warm welcome from audiences online, shows a certain, okayness to watch it. Third, censorship does not really make a huge difference to the context of the film. It just limits the movie watching experience, which also is also a very, very important element of it all. And fourth, when we compare the censor board to the censor boards outside the country, our censor board seems to be a fairly outdated one. Because if you compare the practices that happen, for example, censor boards across the world will look at films very differently. Like a censor board in a neighboring country like Pakistan is very strict with the respect of how the country is portrayed or Muslims are portrayed, which is why they've actually banned most of Indian films like Baby in 2015, Heather in 2014, and the list continues. As in comparison, in contrast, the United States and the UK have a slightly clear and a very direct system of rating films. What we have is a censor board in India is called the Motion Picture Association of America. And the Motion Picture Association of America, which is their version, has a 6-type rating system. You don't have to know the details, just to give you an understanding. G stands for general audience. PG stands for parental guidance because content may not be suitable. PG-13 is people below the age of 13 cannot watch. R is people above the age of 18 cannot watch. But if you're accompanied with an adult, then you can watch if the person is under 17. Then you have something called NC-17, that no child equal or below the age of 17 can watch. Then there is NR or UR, where it is only for very select viewers or select theatres. Similarly, the British Board for Film Classification, BBFC, also has a U, PG, 12A, 15R, R18, and so on and so forth, which could be played at licensed halls. They usually proceed on the basis of the version that is given to them, and they would rarely demand cuts, except for recommending certain cuts and rate films accordingly. Because if the film doesn't make those edits, then they will give a higher or a more difficult rating or a more strict rating. See, all censor boards across the world are very uncompromising when it comes to very strong sexual content or excessive violence or some form of regressive behavior. So all of these things therefore become very, very important in that sense. So what should we do? One, we should expand our rating system. This is extremely important. Two, we should have more public participation in this entire censorship process so that a common person also has a say in the entire ecosystem. And third, we should keep simple, because recensorship of adult films which are being played on television sounds logical because you would still not know what the kids are watching on TV. But when a legal adult is repurchasing a movie ticket, you expect the person to be treated like an adult, not a teenager. So uncensored adult content should actually only and only be for adults from how we can understand it to be, right? So these are some of our basic explanations. This is how it works. And our final conclusion is that the blame cannot be fully put on the censor board. In fact, they must only be given a lot lesser powers and have a more vibrant system so that we're able to keep the business of films and creativity going. Anything more than this, whether it's ethics or paper two, you don't need as far as films is concerned. Thank you. Hello and welcome to lecture number 6F, topic number 6, freedoms, of theme number 3, preamble, fundamental rights, directive principles, and fundamental duties. Now, in lecture number 6F, we're going to largely be covering the theme of dissent in one go. Unlike the previous subtopics under Article 19, when we look at dissent, we do it collectively in a singular lecture, largely because of how political and how open-ended this particular topic is. So we'll understand dissent as a function of Article 19 and to what extent is it particularly relevant for the mains, and a few anecdotes here or there as far as the pre is concerned. But as far as prelims is concerned, I will never ever think that dissent will ever be asked in any form as far as the prelims exam is concerned. Now, to begin with, let us first map out the concept of dissent, then understand the implications of it and the triggering factors why all of this has always come center stage in the country at different given points of time. So let's understand, how does the larger issue of dissent operate? So when we look at the notion of dissent, we understand it in two major forms. One is the manifestation of dissent, or the expression of dissent, or the execution of dissent. And when we look at it in terms of the execution side, we understand there are essentially two primary forms of dissent. One, of course, is the idea of a protest, and a more aggressive version of that is the idea of a strike. So protest and strike become the elements of execution of dissent. But when we look at it in terms of the limitations of dissent, or we look at it from an abuse point of view, we understand how dissent, if taken a step further, or if dissent crosses a line, then what are the ramifications involved? And these are usually where your contentious issues lie. They are the following. So, for example, you would always hear of something called sedition. We would often hear of something called hate speech. And over and above this, beyond sedition and hate speech, we would also hear of specific legislations, such as the Unlawful Activities Prevention Act, which can have a repercussion on limiting dissent or stopping activities which could abuse dissent. Now, Unlawful Activities Prevention Act has two implications. One, of course, is with respect to dissent, and the second is, of course, with respect to detention. So these are our two primary elements. Now, let us understand how all of this fits into the UPSC canvas of things. In this entire ecosystem, we have seen sedition to be the most popular in the news, closely followed by the Unlawful Activities Prevention Act. Whereas the question that the UPSC has asked has always been with respect to hate speech. This was a question which was asked in the year 2014, and I display the question before you. The question is, what do you understand by the concept of freedom of speech and expression? Does it cover hate speech also? And why do films, which is something that we've covered before, so does it cover hate speech also? Now, this in itself should give you a hint as to the kind of questions the UPSC has been asking and the limitations that the UPSC would have to ask these kind of questions. Now, when we go back to our mapping page, we will see that what is common to Sedition and the Unlawful Activities Prevention Act, it is that both Unlawful Activities Prevention Act and sedition are clearly mentioned in the law. These are provisions which are mentioned in the law. The Unlawful Activities Prevention Act is a law in itself, and the sedition is and the sedition provisions are categorically mentioned in the Indian Penal Code. It is hate speech which is a ramification. So sometimes hate speech could be merged with sedition. Sometimes hate speech could be merged with the Unlawful Activities Prevention Act. And this therefore becomes a larger question of how do we differentiate between the three? And is there a need to give more clarity to what is hate speech? Now, to begin with, let us first understand very simple meanings of these and how they have all become the center stage for a lot of the debate that has happened in the country from a political point of view and from a judicial or a legal point of view. To understand the primary meanings, it is this. Protest is simply an organized or even a semi-organized or even a non-organized or an unorganized form of a collective discontentment against an issue. And this discontentment could be in many forms. This could be in the forms of, let us say, a public gathering, sitting in a public place, and all of those things. What happens with protest, which is a little bit of a problem, is when protests take a slightly more destructive form, wherein public space or public utilities start getting hampered, start getting destructive. Just because a section of the population is protesting, it has an impact on the other section which has to commute and has to carry on with their daily activities. And second is, sometimes protests can take a violent form. And through the violent form, it can cause law and order problems or disruption to public order or peace in general. Now, protests are organized, which means there will be people who will be attending the protest and there will be people who would be communicating about what the issue is to the people who are attending the protest. So what happens many a times is that the protest in itself, sometimes what is being said in the course of a protest could be seditious in nature, could have a hate speech component, or might even be an issue of the violation of the Unlawful Activities Prevention Act. So this is why it becomes a slightly complicated web. Strike, on the other hand, is a disruption of goods or services in order to highlight discontentment or disagreement over an issue. Very simply. Now, when we look at Sedition, Hate Speech, or Unlawful Activities Prevention Act, we must understand that the basic difference between sedition and hate speech is this. Sedition is primarily against the government and might incite a degree of violence in the process. Hate speech can be against any particular community in general and may not necessarily incite a degree of violence. Unlawful Activities Prevention Act could be a combination of anything if it is affecting the security of the nation, the integrity of the nation, the territorial supremacy of the nation, the relationships that the nation has with other countries, and so on and so forth. So Unlawful Activities Prevention Act could be in any form, whereas sedition and hate speech is usually through verbal mediums, through digital mediums, through speeches, through recordings, etc., etc. But Unlawful Activities Prevention Act covers any form or any medium whatsoever. But sedition and hate speech will usually be either in an audio form or a visual form or a combination of both. Now, we start from one corner to understand what is the process behind it. And there have been a few triggering events which have brought this larger discussion right center stage in the country. The first and the most important one, because there has been a Supreme Court judgment on this, is the Leela Maidan case, which is when the anti-corruption movement was happening. That's the first one. The second one, which is the one which has been more political in nature, has been the CAA protests, which have led to larger questions on if you have a fundamental right to a protest, what are the limitations on it? And the third have been the farm law protests, where the farm laws have actually been taken back by the government, but the farm law protests, where you're again looking at disrupting, say, a national highway or disrupting, say, essential services to an extent. So the Leela Maidan case is a positive reinforcement, whereas the CAA protests or the farm law protest cases have been essentially to outline the limitations to the larger issue of dissent. This is the larger ecosystem under which dissent works and always will work. So we will now begin with protest, understand protest in a larger framework only to what is relevant for the exam, and pick up each of the following repercussions as we go ahead. To understand protests, let us first understand, where do you get the right to protest from? In one line, the right to protest has been declared an implied fundamental right under Article 19. Now, this right to protest, which is implied, has to be in a peaceful nature, and this has been done through a massively important judgment called the Leela case, the Leela Maidan case, which we will talk about right now in just a few minutes. But this is the basic introductory statement. But what under Article 19 allows you to protest in the first place? See, Article 19, Clause 1, Clause B, and Article 19, Clause 1, Clause C contain two provisions which translate into a protest. 19 Clause 1, Clause B says the citizens have the right to assemble peacefully without arms. And Article 19, Clause 1, Clause C says citizens have the right to form associations or unions. So unions or associations, and most recently cooperative societies. Now, what do people do when they assemble? what do people do when they make a union or an association? They project or state their demands or discontentment to something. So the word protest is not mentioned anywhere in the Constitution. The word protest is not mentioned anywhere under any law, but it is an implied fundamental right by the reading of a judgment called the Leela Maidan judgment. And this is the origin of it. But having said that, the reasonable restrictions to 19B and C, which is under Articles 19 Clause 3 and 19 Clause 4, would also therefore apply. So public order, decency, morality, sovereignty, security, territorial integrity, all of those will apply. And not only this, if it is against the interest of the section of the people, then also the protest can be restricted. Now, this is the larger ecosystem of it. How the laws have been made is that if you want to have a demonstration or a protest, which is in a public place, the laws of the country under CRPC and a bunch of other laws require you to take permission from the local administration to do the same. Now, that may not necessarily be very well implemented. And in most cases, just informing the local administration can also sometimes be fine. But the legal technicality of whether you have to inform or whether you have to take permission is a very complicated one, which is something which is beyond your UPSC syllabus. So that is something we will get down to later. But as far as our exam is concerned, we must need to understand what is the right to protest, how can it be used, what are the restrictions on it, and is the right to protest being dealt with in the right manner as far as our country is concerned. So that is our primary understanding. And to understand that in a primary manner, we must first begin by understanding what is largely called the Leela Maidan case. Then we will add the CAA Protest Case, which is the Amit Sahni case, or then we will also be looking at the other case, which is the Farm Law Protest Case, which also is a separate, the Mazdoor Kisan Shakti Sangh case. We look at both of these, but our primary understanding is with the Leela Maidan case. Now, the Leela Maidan case is officially called, in reference, the Leela Maidan incident. This case started to happen in 2012, and the final judgment of this was given now in 2022, almost 10 years later. Now let us understand what is the aspect of it. There have been several discussions on it as well. But let's understand this. In reference means it was a suo motu case. And this suo motu case means that the Supreme Court has the powers to take cases on its own. You don't have to necessarily file a case. The Supreme Court believes that under provisions of the Constitution, there are larger issues at stake. The Supreme Court can take cognizance of the matter. For example, during COVID, the Supreme Court had taken a suo motu case called the management of the oxygen situation in the country. Though suo motu cases taken up by the Supreme Court or even by extension the High Courts are very, very low, because suo motu is essentially the Supreme Court almost nearing to cross a line. But let's understand what is the case about. The facts are not important, but it will help you understand what happened. See, the government had imposed Section 144 of the CRPC, which is curfew, and wanted to prevent a crowd of protesters in the Leela Maidan, and it requested, and then this was followed by the evacuation of the protest that was happening at the Leela Maidan using some water guns, some tear gases, and it led to several injuries and also the death of one person. This protest was spearheaded by very prominent, I think, Baba Ramdev, for a protest against anti-corruption and black money and so on and so forth back in the day. Now, this case therefore discussed the imposition of Section 144 and looked at the procedural safeguards that should have been followed. And this case also, in a lot of detail, dealt with how curfew orders should be executed, but it also had a larger issue to do with from the aspect of what the protest is about. And therefore, the judgment becomes important. So, in fact, when we look at it from a protest point of view, this case actually gave a lot of statements tangentially which become important. It also spoke about privacy. It also spoke about the right to sleep. And therefore, it said that if you have any of these rights, you also have the right to protest. Now, as a result of this protest became a massively important one, because when in Ramlila Maidan in Delhi, Baba Ramdev was conducting this, and this protest was being attended by more than 1 lakh people. This had become a massive issue in the country. What basically had happened was, when Baba Ramdev led an anti-corruption rally at Ramlila Maidan, which was I think in February 2011, the sheer number of people who showed up was essentially a larger issue. A few months later, the Bharat Swabhiman Trust was also granted permission to rent the Maidan to hold a yoga training camp in June 2021. So around that time, Baba Ramdev had also announced publicly that he will go on to a fast to protest the government's inaction against black money, and therefore had obtained to conduct a protest at Jantar Mantar, not for to be attended by more than 200-300 people. So what happened was, instead of conducting the yoga camp, which was originally what the intent was for the second time, Baba Ramdev actually staged a protest in Ramlila Maidan, which included a hunger strike. It was attended by almost 50-60,000 people. I remember the case facts very clearly, because at about 11:30 p.m., a team of police personnel, which was led by the Joint Commissioner of Police at that time, met Baba Ramdev and informed him that the permission to hold camp has been withdrawn and he would have to be detained for it. And thereafter, the Central Reserve Police Force and the Rapid Action Force were called in at 12:30 a.m. in the morning to break up the protest and arrest Baba Ramdev. Which is why this case also spoke about if you have the right to sleep or not. If somebody is waking up at 12:30 a.m. in the morning, they're disrupting your right to sleep. It was also recorded on the fact sheets that the water cannons or tear gases, all of these are also being used, which was considered to be a larger problem. So the primary issue was, if you impose a curfew at the rally, does it violate the right to assembly, speech, expression, and life as under Article 19 and by extension Article 2021? Now, when the court ultimately gave a decision, the court looked at very technical discussions on very technical grounds. The court first started by understanding the reasonableness and the purpose of the restrictions that were being put in the present case. And does Article 19 Clause 2 allow for these restrictions to be put? The court finally held that the legislative determination of restrictions were final, they were conclusive, and they were not open to judicial review, which basically meant that if the law allows you to do something and the law has been rightly passed, has been duly passed, then we'll have to follow the law. It relied on an older judgment also, which is not in your syllabus. It's called the V.G. Rao case of 1952, but it's not something which you have to remember. Said that there cannot be there could be no general pattern of reasonableness which could be applicable to all cases, and therefore each of these have to be decided on a case-by-case basis. And as a result of this, the court then got on to the discussion of whether the right was being prohibited or whether the right was being restricted or limited. And therefore, the courts actually went into a lot of discussions in and around it. But the final understood, the conclusion was that the acts that were being used, the tear guns and water cannons and all of that, they were amounted to brutal abuse. They were wholly unjustified. And the actions of the police were certainly a violation of your fundamental rights. And to that, he also spoke of dignity, he also spoke of peace, sleep, and he also spoke of you have an inherent right to protest peacefully unless there is a law that specifically stops you from it. So this judgment fundamentally guarantees you the right to protest peacefully. And that's why it becomes important. But when we look at it in terms of the limitations, those limitations have to be understood in two cases. One is the CAA case, and the second is the farm law case. Because in both of these cases, the court has very firmly gotten into what was right, what was wrong, has gotten into certain limitations. So let's understand the farm law case. Let's first understand the CAA case. The CAA is something we've discussed before also. See, the movement against the central government's Citizenship Amendment Act of 2019 and the plan to initiate a national register of citizens was something that eventually translated into something called the Shaheen Bagh protests in Delhi, which is in a very, very important, it's in a very important junction, it's in a very important crossroads, which allow people from one part of Delhi to go to the other. Now, these Shaheen Bagh protests, as we understand them to be, were initiated by a group of women in the vicinity, which later swelled into a huge crowd that blocked the roads. There was a tent, there was a library, there was a large replica of India Gate, there was a map of India. It became a major infrastructure, a temporary one though, when the protests were happening. So at that time, a gentleman called Amit Sahni, who was a lawyer and an activist, approached the Delhi High Court in the month of January itself, 2020, complaining that the Shaheen Bagh protests had blocked several important roads, including the Okhla underpass, which is a part in Delhi, for about 30 days. So he requested the court to direct the Delhi police to resolve the blockage and ensure the smooth traffic of the police, of the traffic, of the people, of the police, of passengers, and all of that. The Delhi High Court, therefore, ordered the appropriate authorities to address these concerns of the petitioners and take unnecessary action that has to be taken. It also further ordered the authorities that these decisions should be taken in the larger public interest and they should not be detrimental to law and order. Now, the problem was this was not being implemented by the Delhi police. So Amit Sahni then again went on to the Supreme Court of India. Hence, the case is called the Amit Sahni versus Delhi Police Commissioner of Delhi case. So it's the Amit Sahni case versus Delhi Police Commissioner case. Now, why does this judgment become important? This judgment becomes important because through this, the court actually got into some fundamental questions of protest. See, one also has to understand the historical origin of it. The right to protest under a colonial rule versus the right to protest in a democracy. So Amit Sahni and his lawyers argued that the right to having a peaceful protest, irrespective of the number of people on the protest or the space that they occupied, they have the right to exercise it. And the government has the right to impose reasonable restrictions. But Amit Sahni's lawyers and Amit Sahni said that they were not causing any inconvenience. So when the protesters and the organizations of the protesters and their lawyers came in as parties to this case, they said we have the absolute right to protest. And as long as we are not violating the reasonable restrictions, there is nothing to complain about. Now, the court, while looking into this specific argument, accepted that India has gained its freedom through protest from the colonial rule. If there was no protest in the colonial rule, we perhaps would have not been free. However, it also very clearly cautioned that you can't compare colonial regime with the current form of democratic governance. You might disagree with the form of democratic governance, but you cannot question, you can't compare a democratic country with a colony in the first place. So, no doubt, under Article 19, 1A and 1B, you have the right to protest and dissent against the state, but they have to be respected and encouraged by the state for the healthy functioning of democracy. But they can be reasonably restricted, including the ones which are mentioned in 19.2, 3, 4, including public integrity, public order, sovereignty, and so on and so forth. Which then got into a finer discussion, which is, do citizens have an absolute right to protest? No questions asked. Now, a few years ago, in 1973, there was a very important judgment called the Himmat Lal Shah versus the Commissioner of Police. In that, the Supreme Court had very clearly held that the right to hold meetings on public streets or to discuss was subject to control of the appropriate authority or permissions or public order. And then the court looked at its own judgment in the Mazdoor Kisan Shakti Sangathan issue, where when we look, and these Mazdoor Kisan Shakti Sangathan judgment, which is of the 2018 judgment, in this case, again, both of these cases, Himmat Lal and the Mazdoor Kisan Shakti Sangathan case of 2018 is not important for you to remember. But in that case, the court had asked to consider the regulation of demonstrations at Jantar Mantar in New Delhi. Now, in order to strike a balance between the interests of the residents and public protest, they directed the police that you should have a mechanism to balance all of it. And if you have to balance all of it, you have to make sure that none of the parties are severely affected. So, for each fundamental right, be it an individual's fundamental right or the right of a class of people, it cannot exist ever in isolation. So it is not an absolute right. It will always be balanced with that of the other counterparts. And therefore, the court in its final judgment in October 2020, I remember clearly, concluded in a very crystal clear manner that democracy and dissent go hand in hand. Absolutely no doubts about it. But the demonstration of this dissent cannot occupy public ways and public spaces indefinitely if it is causing a detriment to the other citizens. So it is not an absolute right and can be restricted if it is causing further inconvenience to a lot of people. So the court ordered accordingly. When we look at it from the farm law case perspective, the court has almost followed a similar chain of command, has also looked at a very similar form of discussion of the same. See, when we look at farmers' protests and how the courts have gotten into it, this has been a constant sort of a to and fro, eventually leading to the government recalling it. So basically what had happened was, in September 2020, the parliament had passed 3 laws to liberalize the Indian agricultural sector. And the government generally argued that this will bring efficiency to agricultural markets, to increase farmer incomes, and so on and so forth. A very large section of farmers in India, specifically from the north, specifically from the state of Punjab, were certainly not convinced. They were of the view that these laws would allow private players somehow to dictate their prices, to dictate their ways of production, and ultimately affect their livelihoods. So ever since the bills were made public, the discussions had started to happen, the farmers in Delhi and Punjab started widespread protests against these farm laws. And that got massive media and political attention. These protests, the political and the media attention, I think lasted for over a year. And then, almost a year later, I think in November 2021, the Prime Minister then announced that the laws will be repealed because the negotiations between the government, the farmers, and the interested parties, that they were all to be failed. So this is the larger context to it. But In all of this, from August 2020 onwards, protesters started gathering around the outskirts of Delhi, trying to block the entry of any movement to Delhi, and the residents of several parts of Delhi NCR started filing PILs against these protests. The court, therefore, heard these matters, passed an order in December itself of 2020, saying that you have the right to protest, you can do so. But 26th January 2021, where the Republic Day protests happened because of this, and that was a traumatic one. A day before, the Delhi police had filed an application saying that we must stop a rally that's happening. The court said that if it's a peaceful protest, we can't get into it. As long as they're not stopping anything else from happening, there's not an issue. A few months later, before November 2021, in July 2021, the Kisan Mahapanchayat filed a petition saying that we want to protest in Jantar Mantar. Can you give us permission? The bodies are not, the government is not allowing us to do so. To which the court very clearly said that, boss, when your laws are under discussion, when you are already getting some form of negotiation opportunity with the government, why do you need to stage another protest? The laws are not being implemented. We anyways, in our earlier judgment, when we started hearing your case, we anyway stayed the implementation of the law. So what do you need the protest for? Which is why the larger issue of protest being an absolute right, when a legal remedy has already been sought, was being discussed. So all of this led to the same conclusion, that the right to protest will not stand much ground if legal remedy is being sought. So this takes care of the right to protest. Anything more than this is not relevant. The UPSC is not going to ask you. Now, from protests, we move to the next discussion, which is important, from the right to strike. Now, unlike protests, the right to strike per se, again, has no fundamental right perspectives. Karl Marx, in his famous speeches, used to often say that workers of the world may unite, and you have nothing left but to, lose your chains. So let's now understand the right to strike. The right to strike is not a fundamental right in India. It is, in fact, a statutory right under the Industrial Disputes Act, which a lot of people are unaware of. The right to strike has been recognized as an important right under the ILO conventions, under the Universal Declaration of Human Rights, under the International Covenants on Economic, Social, and Cultural Rights. But India has not given right to strike a status of that of a fundamental right. It is simply, clearly, a statutory right. Now, let us understand how are we still dealing with it. See, from a Constitution of India perspective, the right to strike originates to form associations or unions under Article 19, Clause 1C. And the purpose of forming associations and unions is to protest, and by extension to protest, it could be strike. Now, we generally have a very disruptive understanding of strike. But in the business of dissent, the word strike can have a very, very important usage, a very important terminology in its implementation. So that is something that we must understand under all circumstances. So how does that work? See, while Article 19 Clause 1 Clause C allows you to have unions or associations which you can use for strike, you will still be subjected to reasonable restrictions under Article 19 Clause 4. The Constitution of India undoubtedly has taken very good care of the citizens and their rights. And we have socio-economic legislations, religious legislations, legislations that protect the cultural and the political values of our country, but all of these come with a sense of responsibility. And this is one of the reasons why the right to strike has not been given a fundamental right status, because what you're essentially doing is a cessation of work or a disruption of work or a constant refusal to work or concerted refusal to work based on common understanding of people. Of course, when we look at essential services, they do not have the right to strike. The military can't go on strike. The doctors can't go on strike. Essential infrastructural services cannot go on strike. All of that is there. But this is not something which is in your syllabus. You don't have to worry too much about it. The right to strike, on the other hand, is largely for people who are employees in industries, so that they can negotiate with their managers, with their industry owners or senior management to get certain benefits that they're entitled to. Now, the judiciary in India has been a little divided when it comes to the right to strike. So Indian judiciary no doubt recognizes the right to strike as a legal right, as a statutory right. There's no problem. And right from the Trade Union Act of 1926 to the Industrial Disputes Act of 1947, you've been given a right to in a way strike. But the right to strike is an ancillary right that comes out of your freedom to dissent or your freedom to disagree. And the Supreme Court has always said that the right to strike is a weapon which is available for workers to force their to force their employer to listen to what their actual demands are and given to them if they're reasonable. And it should only be used in a case of emergency, should only be used in the case of an urgency. Now, I remember there was a case called Crompton Greaves versus its workmen, right? Crompton Greaves, which is a cement and another manufacturing company, its workmen, people who worked as laborers or employees. In this case, the Supreme Court had held that the right to strike is a legal weapon available for its workers, so thereby giving you a sense of right to strike. In another Indian Express case, not the same one that we've discussed under Article 19 before, peaceful strikes can be conducted to get the employers to agree to your demands. So, Crompton Greaves recognizes the right to strike. Then the Indian Express case, this is the Indian Express versus the T.M. Nagarajan case. It recognizes the right to peaceful strike. And then finally, the Supreme Court in the B.R. Singh versus Union of India said it is very important for trade unions to have a sufficient membership with their management. And if it requires a strike helps the propensity of liberty of its workers. So in the B.R. Singh versus Union of India case, the court says strike allows you to gain liberty of the workers. Now, anything beyond this is not to be done as far as the exam is concerned. So, in one shot, the execution that we needed to do has been covered as far as dissent is concerned. We will now move to Sedition, Hate Speech and Unlawful Activities Prevention Act as the extension to this continuous lecture in the second part. Thank you. Hello and welcome to lecture 6G. 6G covers in continuity the dissent theme of Article 19. And in the previous lecture, we covered protest and strikes as affirmations or executions of Article 19. But now we look at the conflicts or the limitations to Article 19 and dissent. And therefore, in these topics, in these particular themes, we should be covering sedition, hate speech, and a very limited understanding of the Unlawful Activities Prevention Act. Now, out of the three, as we understood before, only hate speech has been asked previously in the mains in a very simple form. Does hate speech come under Article 19 or not? And the simple reason behind this is because Sedition and Unlawful Activities Unlawful Activities Prevention Act both find legal recognition within themselves, with sedition being a part of the Indian Penal Code and UAPA being a law in itself. Hate speech is caught somewhere in the middle. So it could sometimes be looked at from a seditious point of view. It could sometimes be looked at from a UAPA point of view, or sometimes the same speech could be considered a combination of both. And we've understood also in the previous lecture that there are essentially very simple differences. Sedition is specifically against the government. Hate speech is against a particular community, and Unlawful Activities Prevention Act is larger. It is a combination of any of these and encompasses a little bit of overlap with something called preventive detention as well. Now, having said that, let us first start and understand the sedition law in India. And when we do that, you must know exactly how much of it is relevant for the exam. So when we are studying sedition for UPSC, the following questions must be very clearly answered. Question number 1, what is sedition? Question number 2, what is the primary timeline of sedition? How did it come into being? What are the major developments around it? Third, what is the current jurisprudence, which means the current legality of sedition? And fourth, how should sedition be relevant or be present in the future? Should we have a sedition law or not in the first place? Now, the fourth question is a question with respect to paper 4. It will never be asked in paper 2. They will never ask you, do you think we should continue with the sedition law in the country or not? The first 3 questions are questions of paper 2, which is where we need to know from a legal point of view the developments around it. Now, with that in mind, we will quickly understand in a very, very simple manner a timeline of sedition as to how it has worked and what are the different judicial pronouncements of it. And through a timeline in itself, we'll be able to understand most of how sedition worked. So, when we look at a timeline, our first major starting point is the year 1870. See, the Indian Penal Code, which was drafted by Thomas Macaulay in the year 1850, around 1800 to 1859, was passed and ready to be implemented in India in 1860. Now, the Indian Penal Code of 1860, which is even today the primary criminal law in the country, contains a provision of sedition. The provision of sedition was not in the original IPC of 1860. It was added later to the Indian Penal Code. And that is why it is called Section 124, capital letters A. So Section 124A was added to the Indian Penal Code, which criminalizes defection towards or dissatisfaction or disaffection. So the words that we use are disaffection towards the government established by law. Now, the degree of disaffection could vary, or sedition. So sedition is nothing but disaffection, simply put, disaffection towards the government established by law. Now, this provision with respect to sedition was drafted from a very historical point of view. It was introduced by a British politician and a lawyer, James Stephens, through an amendment in 1870. And there have been essentially two reasons why sedition exists in the Indian Penal Code. One set of scholars argue that the amendment was passed in response to the growing Wahhabi activities in the subcontinent. The Britishers, however, claim that there was a provision which was needed to account for the political conditions in India, language that may be tolerated in England, but it is unsafe to tolerate the same in India, because India could be a more sensitive form of an ecosystem. So these were the two primary sort of arguments that we heard about sedition in the first place. Now, India's first sedition case, which is very interesting, is concerning one of India's foremost freedom fighters. This happened in the year 1891. The case was called Queen Empress versus J.C. Bose or Jogendra Chandra Bose. So, Queen Empress versus J.C. Bose. Do we need to know this case? No, but it is good to have some historical contextual trivia. This was India's first case on sedition, which was back in 1891, heard at the Calcutta High Court. And this essentially was J.C. Bose was the proprietor, the manager, the editor of a Bengali magazine called Bangobasi, where all were tried for sedition for publishing an article criticizing the British government for their policies on age of consent, for sexual intercourse. And of course, while the trial was being held, the charges against J.C. Bose were ultimately dropped after they tendered an apology. But 1891 was India's first recorded case on sedition. We move slightly ahead to 1897 and 1908. Now, 1897 and 1908 have a little bit of Indian national movement seeds sown into them. So let's understand 1897 and 1908. This essentially is reminiscent of the fact that Bal Gangadhar Tilak was convicted of sedition. So Bal Gangadhar Tilak, as you would know, the key figure in the Indian independence movement, was convicted of sedition not just once, but twice. In 1897, Tilak was convicted for sedition by the Bombay High Court for his speeches that he made at a Shivaji festival that had allegedly, as per the British, prompted the murder of 2 British officials. The presiding judge at that time, when they were looking into the meaning of the word sedition, actually broadened the scope of disaffection and said disaffection also includes disloyalty. So it was no longer disaffection against the government established by law. It should also mean disaffection and disloyalty. Of course, the court cannot change the written word of the law. It can interpret it as we would understand it to be. But we were widening or broadening the scope of sedition. Now, in 1908, Tilak was convicted again for sedition by the same court for his writing in a publication which every UPSC aspirant knows about. Is called Cases, which was a Marathi newspaper that he had founded back in the day in 1881. So the idea here is Bal Gangadhar Tilak was convicted twice of sedition. And this became a turning point in the larger ecosystem. So Tilak convicted twice for sedition. Now, if you think this was not enough, in 1922, Mohandas Karamchand Gandhiji were convicted of sedition. So in 1992, Gandhi was charged with sedition and was tried at the Gujarat Sessions Court, I think in a place called Bhadra, for his politically sensitive articles in the Young India Journal. Both Gandhi and the journal, very interestingly, in this case, pled guilty. They said, yes, we are guilty of what we've written. And therefore, at the trial, Gandhi read out a statement detailing the history of his affection towards the British government. And of course, he referred to Section 124A as suppressing the liberty of citizens, stating that affection could not be manufactured. If it exists, it exists. And because of this, Gandhi was convicted and was sent to 6 years in prison because of the way the trial executed. So therefore, Gandhi was convicted of sedition in 1922. Now, the closer we come to independence, this also becomes a little more strenuous. Now, in the year 1942, this is around the time the Quit India movement was taking shape. In 1942, the Federal Court of India defined sedition, because at that time, because of the Government of India Act of 1857, if you remember, we've discussed this in our earlier themes, the Federal Court of India was established, which later, the Government of India Act of 1935 established the Federal Court of India, which later becomes the Supreme Court. The Federal Court of India defined sedition as leading to public disorder or reasonable anticipation or likelihood of a public disorder. So now disaffection, disloyalty, and public disorder, if any of these are components of certain speech or writing or so on and so forth, then it could be seditious. So the court essentially emphasized this, that sedition is going to lead to some form of resistance, recklessness, or lawlessness. Of course, much later, this decision was overruled in 1947, but in 1942, the government had taken a very, very stern view of what was sedition. So in 1942, the case was Majumdar versus the King Emperor. Where we further expanded and we looked at public order. If anything that you're saying is going to cause a harm to public order, then also it would be seditious in nature. This was eventually overruled in 1947. I do not clearly remember the judgment. I think it was again King Emperor versus Bhalirao, Sadashiv Narayan Bharila. But again, it doesn't matter beyond the point because now we're entering into our independence. So as you can see, the point of giving you a pre-independence history of sedition is to make you understand that sedition or the instances of sedition will always have a stronger role to play in a colonial regime. And in a colonial regime, the government will always believe that anything that is being said by a people of a certain class is fundamentally against the government because there is no democracy. So sedition in a colonial regime versus sedition in a democratic regime will have two very different interplays to begin with. From 1947 to 1948, now we established the Constituent Assembly and sedition gets debated. You would be surprised to know that the original draft of Article 19 actually contained the word sedition, but that was removed because of the diversity on what sedition could mean. And through an amendment, we did not eventually, when the final draft was adopted and enacted by the Constituent Assembly, the word sedition did not exist under Article 19, Clause 2. So under Article 19, Clause 2, sedition was one of the reasonable restrictions which was removed in the course of the debates of the Constituent Assembly. Now, in 1947, just in the first half of the year, while discussing your freedom of expression related debates, Vallabhbhai Patel had proposed an exception for seditious languages, that sedition must be an exception to the free speech. A lot of debate happened, and finally in 1948, according to a proposal by K.M. Munshi, it never saw the light of day because this had colonial origins and it has been used to stifle the Indian independence movement. So therefore, what happens is, between 1947 to 1948, the Constituent Assembly debates very heavily on sedition and Article 19, and primarily says we will not have the word sedition specifically as a reasonable restriction under Article 19. Now, as you can see, sedition in itself takes multiple forms. It is taking the form of something which is oral or verbal, and any other form which is written. So back in the day when there was no technology, it was essentially written. But today you also have online, you also have digital media. The sedition today will not only apply to verbal, but written as well as digital. Now, after 1948, everything that has happened has been largely because of the courts. Now, we have a very interesting journey of the jurisprudence on sedition, on the courts on sedition. So now when we look at sedition post-independence, we understand that we started with a high, then we had a low, then we had a high, and then we had a massive low, and we've been on a low ever since. So this has sort of been the graph when it comes to sedition. The case that we've started our freedom of speech discussion on is also a case which refers to 1915, the Romesh Thapar case. Because the Romesh Thapar case is essentially Article 19's case for Nanda Bharti, it has to be dealt accordingly. So Romesh Thapar versus State of Madras. You would remember we've discussed this in a fair amount of detail. With the editor of a journal in Bombay, and the State of Madras had prohibited his journal from being circulated in Madras. Now, in 1950, the Supreme Court had held that just because it was a leftist journal and you were banning it in Madras because of public safety, it was violating the fundamental right to free expression. And in this case itself, one of the judges actually mentioned in the judgment that there is a reason why sedition was deleted as a reasonable restriction from the original draft, is to precisely prevent these things from happening. So this is the first post-independence mention of the word sedition. Now, between 1950s to about 1962, there were two cases with respect to sedition, one in UP and one in Punjab, and this was with UP High Court and Punjab High Court. And because these are High Court cases, I don't particularly want you to worry about them for the purposes of the exam. In both of these, specifically the Punjab High Court had declared sedition to be unconstitutional. So Punjab High Court, after declaring sedition to be unconstitutional, essentially ensured that there cannot be any sedition-related criminal proceedings or FIRs in the state of Punjab. This was the high that we are talking about. And this becomes very important. Because when we look at the role of the judiciary between the 50s and 60s, they are extremely vocal and protective about this particular right. So in the state of Punjab, around that time, because sedition was declared unconstitutional, a police station could not initiate an FIR of Article 124A against somebody. But then we came to a certain law. The law is in 1962, where we look at the case of Kedarnath. So it is Kedarnath versus the state of Bihar. Now, this has been our case on sedition for years to come. There has not been any major change post the guidelines or the interpretations set in 1962. Now, in 1962, a 5-judge bench of the Supreme Court upheld the constitutional validity of Section 124A, and 2, it overruled the Punjab and the UP High Court judgments, ensuring that no, sedition will continue to remain constitutional. So the UP High Court judgment was a little unclear on that, but the Punjab High Court judgment was very clear, very precise, that sedition is unconstitutional, it cannot happen. Now, this judgment also interpreted Article 124A and therefore wanted to balance that, yes, we understand that sedition may be important to ensure that there is a larger utilitarian peace in society. So the constitutionality of it is relevant, but that does not mean that the government has a free hand to do whatever it feels like. So how does this work? The court undoubtedly conceded that while the criminalization of sedition had imposed a restriction on the freedom of right to speech, it was nevertheless an absolutely reasonable restriction within the meaning of Article 19.2. It may not necessarily have the mention under 19.2, but it could be derived from words such as sovereignty, safety, integrity, of India. However, just because the Supreme Court, through a 5-judge bench, a constitutional law bench, which is a minimum of 5 judges, is upholding sedition, it does not mean sedition could be implemented in the exact same manner as the government felt it to be. The Supreme Court categorically said that a criticism of the government will not be seditious in nature unless it specifically was a call for violence, unless it specifically enticed for violence. If that is not happening, then it is not sedition. So essentially through Kedarnath, what the Supreme Court did was, it is sedition only if it leads to inciting of violence or a direct call to violence. So therefore, the interpretation of sedition or a sedition act or a seditious act must lead to the incitement of violence became an interpretation of Article 124, Clause A. Now, for a very long time, for about more than 30 years, we did not see any major development as such. But then in the year 1995, there was a case called Balwant Singh versus State of Punjab. Not particularly important for you to remember, but this was a two-judge bench of the Supreme Court, which reaffirmed the decision, reconfirmed the decision, reiterated the decision of the Kedarnath judgment. Basically, what had happened was the petitioners in the Balwant Singh versus State of Punjab case, right, had reaffirmed their earlier. This had essentially said something in a very reaffirmatory manner, in a very, very insinuating manner. Essentially, what had happened was the Indira Gandhi assassination had taken place. And there were some incendiary slogans, some very provoking slogans that were raised by the petitioners or the people that represented the petitioners post the assassination of Indira Gandhi. And they were convicted of sedition by the lower courts. And then they went on appeal to the Supreme Court. The Supreme Court let them go free, acquitted them, because the Supreme Court said merely raising slogans without any other action that incites violence does not amount to sedition. So in a way, the principles laid down in the Kedarnath judgment therefore become implemented in the Balwant Singh versus State of Punjab judgment. So when we look at the Balwant Singh versus State of Punjab judgment, it essentially reaffirms what the case was all about, what Kedarnath was all about, very clearly saying that slogans per se are not seditious in nature unless there is a specific call for violence. And ever since, it has been more or less a similar story when it comes to sedition. Now, very recently, in 2021, there was a writ petition which was filed in the Supreme Court, because what happened in 2018 triggered the writ petition. In 2018, two senior journalists were charged with sedition for their posts on social media platforms criticizing government functionaries. Now, in 2021, they filed a writ petition in the Supreme Court challenging the validity of Section 124A. Now, they said that the case of Nanda Bharti, so the Kedarnath judgment is archaic in nature. The Kedarnath judgment has lost its relevance, and the current political system arguably is a larger issue. So, as a result, that petition still continues to be running. So, this 2021 petition that we're referring to is currently a pending petition and will continue to do so. But what also happened in 2021, especially around the pandemic, was that Vinod Dua, who was one of India's foremost journalists, of course, has passed away today, has passed away very recently, not today, was convicted, was charged with sedition because of a YouTube video that he had made criticizing the Prime Minister about how the COVID situation in the country was being managed. He went to the Supreme Court asking for the FIR to be quashed. And a two-judge bench of the Supreme Court quashed the FIR against Vinod Dua, didn't even let the FIR to continue. largely because it was not seditious in nature at all. But in this Vinod Dua case, Vinod Dua, being a journalist, he came to court with a solution. He said, journalists and sedition are often going to come to cross paths with each other, because it is one of the jobs of the journalists to evaluate the policies of the government. So therefore, if you have to charge a journalist with sedition, you have to make sure that there should be at least a screening committee for checking if the journalist has more than 10 years plus experience and you're charging the journalist with sedition. The issue should be left over to the screening committee, and thereafter, on a case-by-case basis, it should be decided. But this idea was rejected by the court. But in my opinion, I think it was a missed opportunity, because sedition and journalism will always go very closely hand in hand. So this largely becomes your fundamental your ecosystem of sedition. Now, apart from this, there have also been very politically surcharged cases. You would have heard of something called the Disha Ravi case. Now, this is not a Supreme Court case, which is why I don't think it's important. This was the toolkit case, the whole toolkit issue that came into being. Just to give you a little idea about it, this case, which is called the Disha Ravi versus Union of India case, which is a lower court case, was essentially a criminal case which was filed by the state against Disha Ravi, who at that time was a 22-year-old environmental activist. And she was arrested for her involvement in the circulation of a toolkit, a digital kit, which was created and shared during the farmers' protests of farmers' bills of 2020. And therefore, she was accused of several sections under the Indian Penal Code. For example, 123, wanting to provocate with the intention to cause a riot. That's 153, 153A, trying to promote enmity between two groups, and then 124A, sedition, and 120B, criminal conspiracy. And therefore, the case came before the court. Now, ultimately, the court granted her bail, all of that was taken care of. But this was one of those times in the country where you thought that was sedition being used in the right way or the wrong way. Arguments on both sides have a fair degree of substance to hold, and therefore we will not get into it, largely because of how political it is. So this is the larger ecosystem of how sedition works. Now, as we understand, sedition per se can exist in multiple forms, can exist in multiple mediums, and therefore it becomes an important part of our learning curve. Now, having said that, what becomes our concluding element on sedition? Our concluding element on sedition, or our key remarks on sedition, are the following. If at all there is going to be a question in the exam. 1, sedition can be derived as a reasonable restriction from the existing conditions met under Article 19, Clause 2. Second, sedition per se may not be the actual problem, but the politicization or the enforcement of it might be. Third, therefore, we must apply and reform the law to only serve the original purpose of enacting enmity amongst the state and not to serve vested interests. As long as you know these 3 points, you know a broad idea about what happened, sedition is taken care of. Now, from sedition, we move to a larger issue of hate speech, because hate speech, unlike sedition, does not find a specific mention anywhere under any criminal law. So multiple laws could be used to take action with respect to hate speech. So let's begin with hate speech. Hate speech is functionally different from sedition or UAPA, primarily because it is not defined anywhere under any Indian law. So what happens is we use the existing laws and the terms that are used in the existing laws to categorize speeches which are hateful in nature. This could be the Indian Penal Code. It could be, say, prevention of atrocities against the SC/ST Act. There could be every such law, even for that matter, the Unlawful Activities Prevention Act. And this is primarily where the issue lies. Now, let us understand why has hate speech very recently, in the last year or two, been important. The current case that we are referring to, the most recent one, is the Qurban Ali versus Union of India case. So it was essentially a PIL. The case, as I said, is Qurban Ali versus Union of India. Now, under Qurban Ali versus Union of India, this was essentially a public interest litigation, and what it is and how does it work, we'll talk about it in a while. But it was essentially where there was a Dharm Sansad, which was organized at Haridwar, and it was organized by an organization called the Hindu Yuva Vahini, and it was also done in Delhi. And several speeches were made which were extremely hurtful against the Muslim community. So as a result of which, it was requested that several FIRs must be filed against the people who make those speeches, because these speeches almost openly called for the genocide of Muslims. Now, these FIRs would have to be on grounds of criminal conspiracy, intention to cause riot, 153, 153A, 120B, 124A. Because you do not have a specific provision in the Indian Penal Code with respect to hate speech. Of course, the court pondered about it and of course said that the police must take appropriate action and get the people to task. But the court also pondered about why we do not have enough laws on hate speech. So what happens is, in the Indian Penal Code, IPC provision with respect to criminal conspiracy, sedition, inciting enmity between classes of people, blasphemy, these are the primary elements to furnish a base, an issue of hate speech. The legal definition of hate speech, however, does not exist in Indian law. And what ends up happening is, because of this, because of the lack of a legal definition, we aren't able to identify and differentiate the difference between a politically charged speech, which could be seditious in nature, or a hateful speech, and its relationship with Article 19, freedom of speech and expression. Now, the Law Commission in 2017, through its 267th report, this is important as a way forward. The Law Commission in 2017, through its 267th report, had recommended that we must have separate offenses for hate speech in the country. This could be done through a separate law or could be done by adding such sections in the Indian Penal Code. And the Parliamentary Committee on Criminal Reform has also been contemplating the same. So this is why hate speech sort of becomes important. But hate speech has already been asked in 2014 in the mains exam. The chances of it being asked again are next to zero. Also, at the same time, you may use it as an ethical dilemma problem, but not much. Now, as we were discussing, that the inability or the lack of legal definition makes us very difficult to differentiate between a speech which is political in nature and the speech which is particularly hateful against a community in nature. But generally, hate speeches are seen in the context of campaigns or elections or political speeches. Now, this is also why 2014, when the UPSC had asked you a question on does hate speech come under freedom of speech and expression, because that's also election year. Now, why is this particularly important? Why does this, relevant today? See, let's get this right. Our subtopic in hate speech therefore becomes hate speech and elections. See, election seasons in India, no matter when they happen, are usually marked with frantic campaigning, slogans that capture the popular imagination, extraordinary religious and caste-based polarization, all of those things. Now, every election, there will be reports about candidates making inflammatory speeches against religious minorities. Now, what happens is, when we look at elections and hate speech, there are ordinary criminal laws, such as criminal conspiracy, enmity, blasphemy, sedition. They, of course, deal with elements of hate speech. We also have specialized criminal laws, such as Prevention of Atrocities Against SC/ST Act. But what makes it specifically interesting with elections is that Section 123(3)(a) of the Representation of People's Act of 1951 deals specifically with hate speech in the context of electoral campaigns and identifies hate speech as a corrupt practice. So this particular section deals with hate speeches in elections and identifies it as a corrupt practice. This, therefore, is reflective of the legislative intent that the propensity of hate speech is always higher when it comes to elections. And not only this, when the Election Commission of India releases its model code of conduct, it also forbids political parties or candidates to engage in any activity which is promoting hatred between communities. And the Supreme Court has engaged extensively with the question of whether caste and communal appeals can be made by candidates during elections. In fact, in the context of hate speech in election campaigns, the Supreme Court has delivered two prominent decisions. They're collectively called as the Hindutva judgments that sort of appear, but not very clearly, to narrow the factors leading to disqualification under 123(3)(a) of the Representation of People's Act. Now, the two cases are these. The first case is, now, again, very minor cases. You don't have to, Supreme Court cases, but I don't think you need to remember them much. But the first case is the Ramesh Yashwant Prabhu versus Kunte case of 1995, or the Prabhu versus Kunte case of 1995, if you want to keep it simple. In this case, the Supreme Court had upheld the disqualification of a Shiv Sena candidate who had made derogatory references to Muslims while contesting assembly elections. Now, the court, of course, said that mere references in election campaigns, including the word Hindutva, would not sort of constitute it, but it has to go beyond just a reference. It has to be a call to action, so to speak. So it is why we often say judgment was not very clear. Second, in 1996, just a year later, in the Joshi versus Patil case, I think Manohar Joshi versus Bhaurao Patil, 1996, held that a political candidate who says a Hindu state should be established in the hope of his campaign did not violate Section 123(3)(a) because it merely represented a hope. It did not represent a specific action to execute that hope. And more recently, several lawyers and several activists have filed several petitions in the court, asking the court to take sort of stringent action against people who use hate speeches in political campaigns, because most of the hate speeches in political campaigns are against religious minorities. A few of them are against caste minorities. Now, in the 2014 Lok Sabha elections, the Supreme Court had dismissed two PILs, asking the court to issue directions in hate speech during elections. That was largely because the Supreme Court did not want to get into the legislative domain, violating separation of power. In a completely different PIL, which was filed around the same period, the court directed the Law Commission to look into hate speeches which were being made by politicians. And it made recommendations to the Parliament on strengthening the power of the Election Commission to curb hate speech and all of that. However, the court also reiterated or also restated that the existing laws which cover the question of hate speech in elections must be further concised or made more precise. The court very clearly said that I will only give you directions where there are no clear provisions in the law. There is nothing more clear than Section 123(3)(a) of the Representation of People's Act. Now, you're not taking an action on it is your fault, but the law exists. Similarly, in 2019, the court had also reprimanded or scolded the Election Commission for not taking action against candidates who are indulging in hate speech during UP elections. The commission said we have very limited powers, we can't do much around it. So the idea is that the Supreme Court does not appear to be very actively involved in responses to hate speeches. And there have been judgments which have been very fluctuating in nature. And the problem is with hate speech and elections, the election regulator needs to be given more powers, functional independence, and autonomy to take strict action. Because the Election Commission has very limited powers when it comes to issues of hate speech. The court says there is already a law which gives you the power to take the action that you have to. So the implementation deficit cannot be billed to the Supreme Court. And given the fact that in 2022, we're going to have several state and municipal elections, especially in the second half of 2022. When we look at the hijab ban issue, which has been a major polarizing factor in the country, communal issues, even in 2022, continue to be the forefront of electoral politics this year. And therefore, the issue of hate speech will continue to remain. But honestly, anything more than that does not become important. So what does your opinion on hate speech become? What is your conclusion on hate speech? One, more specific powers to ECI. Two, the Supreme Court has taken you could say a softer stand, but you could say a passive stand, as Section 123(3)(a) of Representation of People Act already exists. And third, there must be some amount of self-regulation by the parties themselves when it comes to hate speeches during elections. So this is largely how it works. Now, apart from this, there have been a few cases here or there about hate speech, which have not particularly been very relevant in terms of the UPSC. But for example, there was a case called Devgan versus Union of India in 2020, which had nothing to do with elections. It was about a TV journalist called Amish Devgan, who made a derogatory statement against a Muslim saint. And the Supreme Court did not grant relief to the journalist and said criminal proceedings must continue. So there have been several such cases like that. But again, similarly, there was a Hitesh Verma versus State of Uttarakhand case. Here also, the Supreme Court dismissed the investigation under SC/ST Act, saying that insulting or intimidating somebody under the SC/ST Act cannot be considered an offense unless it is on the account of the victim being an SC/ST. So this was again with respect to hate speech and SC/ST. But these are the two parallel cases that have sort of happened and have taken shape in the country. But for UPSC, anything beyond this and hate speech is not important. It is only going to be a waste of time just because it is politically controversial. Now comes the third element, which is the Unlawful Activities Prevention Act. Now, as I said, it has two major implications. One, of course, with respect to Article 19. The second is with respect to preventive detention and 14 and so on and so forth. And when we discuss the Unlawful Activities Prevention Act, firstly, to ask Unlawful Activities Prevention Act in Article 19 is extremely unlikely. But to just give you a basic understanding of what it is. See, the Unlawful Activities Prevention Act is a very recent law, but it is also a continuing law. We've had the Unlawful Activities Prevention Act since 1967. And the most important amendment that has happened in recent times has been in the year 2019. And this has given extraordinary powers to the agencies who have powers under the Unlawful Activities Prevention Act. So the 2019 amendment allows organizations to be categorized as terrorists, and not only just organizations, but individuals can also be categorized as terrorists if the government believes that the individual is involved in terrorism. And once the person has been categorized, so there is a schedule to this act called Schedule 4. The person's name will be added to the schedule. Now, this 2019 amendment has been challenged in two cases. One is the Sajal Avasthi case. The second is the Association for the Protection of Civil Rights case. But Sajal Avasthi's case is the larger petition, and the rest of them have been merged into the larger one. The argument for both of these cases, the Sajal Avasthi case and the Association for Protection of these cases, are pending cases. So the primary arguments for the Sajal Avasthi case, and this is pending right now, which is why I do not think it is going to be particularly important. But the primary essence of this, of the Sajal Avasthi case, is that an individual may be identified as a terrorist without any judicial scrutiny, even before the commencement of a trial. And thus, you would violate 14, 19, and 21. So it has the Holy Trinity angle to it. And therefore, if a person is being classified as a terrorist just because the person is having a certain opinion or a certain view, which may or may not be affecting the security of the country, it becomes extremely difficult. Now, UAPA also allows the government to preventively detain somebody or to keep them in custody. And you will see that these kind of terrorist activities were previously dealt with, say, the the Terrorist and Destructive Act (TADA) of 1987 and the Prevention of Terrorism Act (POTA). And of course, over the years, there have been a several number of cases challenging TADA and POTA as well. Now, when we do preventive detention in one part, from the Kartar Singh case to the A.K. Gopalan case, we'll of course be looking into it in a lot more detail. But as far as Article 19 in UAPA is concerned, we have to do it with a very, very small degree of importance, because otherwise it makes no sense. UAPA could largely be an issue of preventive detention, perhaps, but certainly not something which is particularly relevant for Article 19. There have been several unreasonable restrictions, and there have been questions on Article 19 because of it, but are they going to specifically affect? Not really. But to just give you a little bit more of context, see, the Constitution of India, as it stood in 1950, there have been several amendments post 1950, 1951 onwards. In fact, 19 Clause 2 was added in 1951 itself. And ever since, there has always been some limitation to the freedoms by the Parliament. The first amendment that happened in 1951 did several other things, but it also inserted Article 19 Clause 2, which gave reasonable restrictions to the freedom of speech and expression, and to add the word public order as one of the major grounds for abridging fundamental rights. Now, the Evolution of Unlawful Activities Prevention Act is looked at from the larger context of this, of public order of Article 19 and UAPA, because Article 19 does give you the fundamental freedoms of expression, assembly, and association. Now, the 16th Amendment in 1963 was one of our primary milestones, because the 16th Amendment in 1963 was the next major challenge to the freedoms of fundamental right, because reasonable restrictions in the interest of sovereignty and integrity were also added to Article 19 Clause 2. Now, the reason this was added to 19 Clause 2 in 1963 was because of the Indian Army's defeat in the Indochina War and the threats that were being posed locally by the DMK contesting elections in Tamil Nadu, with secession from India being a part of the manifesto. It was in this background that on one hand you were amending the Constitution, and on the other hand you were also enacting the original Unlawful Activities Prevention Act of 1967 after the 1963 amendment. None of this is really important for the exam, so just for you to understand the context behind it. And that the Unlawful Activities Prevention Act of 1967 was therefore enacted to give the state the power to declare associations who wanted to get away from the state as unlawful. And therefore, it gave the powers to the central government to impose all India bans on associations. Now, the process of banning an association would simply be done by the government announcing them as unlawful under Section 3 of the Act. Thus, the original 1967 Act did have provisions for setting up of a tribunal or having an institution to hear an appeal from an organization being banned. But none of this really was implemented in the right manner, which is also why you will see organizations like SIMI, the Students Islamic Movement of India, in Aligarh, which is also banned. Now, to the 2019 amendment we've sort of spoken about. But then when we look at the 2004 amendment, there was a massive public outcry against the Prevention of Terrorism Act, and because of which the government repealed it. But on one hand, when they repealed the Prevention of Terrorism Act in 2004, they also majorly amended the UAPA Act at the same time. The repeal of POTA was, of course, was an electoral promise also. And the amended Unlawful Activities Prevention Act in 2004, as one of the first major amendments, made a very important change to the definition of what is an unlawful activity. It included the definition of a terrorist act, a terrorist organization, and these two were taken from the repealed POTA Act. And it also included the concept of a terrorist gang. And you had several new concepts or sections such as punishment for terror activities, forfeiture of the proceeds of terrorism, terror organization financing. They were all heavily borrowed from the POTA Act, which was being repealed. So very interestingly, you would repeal one act, take the provisions of it, and add it to an existing law called the Unlawful Activities Prevention Act. In fact, the schedule to the POTA Act of Terrorist Organizations was directly cut, copy, pasted to the Unlawful Activities Prevention Act verbatim. And the sunset clause or the ending clause of the anti-terror acts such as, TADA or POTA was also sort of done away with. Now, the idea is this sort of sets the tone for what happened in 2008 and then 2009 and 2012. In 2008, another amendment was moved because of the 2008 Bombay attacks. More provisions with respect to portal, very similar to POTA and TATA, were added, such as maximum police custody, arrest without a charge sheet, restrictions on bail. All of those were added in 2012, in 2008. In 2012, the already vague definition of what is a terrorist act would also include anything which would affect the country's economic security as well. Now, the fundamental question still remains, what is a crime and who is a criminal? See, like the TADA and POTA, UAPA also criminalizes ideology and association. So, by the virtue of declaring an organization unlawful or a terrorist banning it, these acts have also essentially criminalized their ideologies. So even if somebody has a literature or a book or a text in their possession, it is understood to have a common ideology, which is why sometimes it could be planted, sometimes it could be a bias, and unlawful arrests or immoral arrests could take place. And as a result of this, the Unlawful Activities Prevention Act has always been a matter of dispute and debate. And ever since, there has been a larger issue with Unlawful Activities Prevention Act, because by criminalizing the possession of literature or attending, let us say, a talk, that in itself could lead to a violation of Article 19 and actions under Unlawful Activities Prevention Act. So this is the larger context. This is how it is to be done. Anything beyond this for Article 19 as a whole, I don't think is particularly relevant. They've already asked questions in 2022, in 23, 24. I do think it's going to be highly unlikely to be an Article 19-centric question unless something major happens, which we will, of course, keep updating whenever the time is right. Thank you. Hello and welcome to lecture number 7A of topic number 7, which is life and liberties. This is a part of theme number 3, which is Preamble, Fundamental Rights, Directive Principles of State Policy, and Fundamental Duty. Now, lecture number 7A, or topic number 7, fundamentally deals with life and liberties from the perspective of the mains exam. And this becomes particularly difficult to comprehend, not because the issues are complex, it's because there is no start and an end point. Literally everything under the sun could be encompassed under Article 21, which is the right to life and liberty. And that becomes slightly complex. And that becomes slightly difficult to comprehend. So therefore, What we need to do with respect to topic number 7 is to identify a very clear boundary on the basis of what the previous year questions have been asking and figuring out how much of depth do we need to get into as far as life and liberties is concerned. We must also understand that life and liberties, like Article 14, will also give rise to a lot of constitutional jurisprudence, a lot of very essential theories and concepts, which are also important from a larger perspective of the evolution of the Constitution. So keeping these thoughts in mind, let us first understand what the UPSC has asked with respect to life and liberties in the larger context in the mains exam. So let's look at them. Now, like Article 19, we will see two kinds of questions with respect to 21 and in and around it, 20, 20, and 22. The first is a question which is core or singularly focused on 21. And the second is where 21 becomes one of the arguments, may not be the primary one, but is certainly an important one to understand a larger issue. So when we start from understanding what the questions have been, the first conclusion that we will get is that there are actually more 19 questions than 21 questions. And the reason behind that is because 19 translates into more distinct issues as opposed to Article 21. So let us first understand the kind of questions that have been asked. So the first question is directly from 2015 onwards. Anything before that does not particularly deal with 21 per se. But 2015 is where it begins. Discuss the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided for in the directive principles of state policy. Now, uniform civil code is essentially a combination of religious rights and the provision in the directive principles which requests the state to do something. But when we legally analyze the bottlenecks or the objections to uniform civil code, we will look at the larger issues of 14, 19, and 21 in addition to 25. So does the uniform civil code hamper our notions of equality? Does it hamper our notions of speech and expression? And marriage is a form of expression. Property is a form of expression. Adoption is a form of expression. And by fundamentally regulating marriages in the first place, you are looking at Article 21 because marriage is an instrument of actually Article 21. In one of the prelims previous year questions, this was actually being asked that the right to marry is a fundamental right under what? It is fundamentally or largely an instrument of Article 21 because the right to marry also means within itself the choice to marry. And the choice is essentially about having the liberty to make that choice. And therefore, it is a question of Article 21. So, in the Uniform Civil Code question, this falls under the second category, where 21 could be one of the arguments, but not the primary essence of it. Then the second question in 2015 was a question which was primarily focusing on 21 in itself. Does the right to clean environment entail legal regulation on the burning of crackers during Diwali? Discuss in the light of Article 21 of the Constitution and the judgments of the Apex Court in this regard. Now, you must always wonder to begin with, if 21 is such an all-encompassing right, why don't we begin with 21? Why does 21 come after 14 and 19? It's because 14 and 19 could collectively also lead to 21. 14 and 19 are more specific. So you're building a bottom to top approach, which is why the makers of the Constitution also wanted to keep 21 after 14 and 19 per se. But when we look at the 2015 question on environment, what do we understand? We understand that the question here is about how we have used Article 21 to expand our environmental rights jurisprudence, and that has been correlated to a Supreme Court judgment which has been massively in the news. It doesn't matter what the name of the judgment is, but that was essentially a question. So, for example, in this question itself, you have the right to life and liberty. Burning of firecrackers causes pollution, and pollution decreases the quality of your life. So there is a clear relationship between the burning of firecrackers and Article 21. But at the same time, the manufacturing of firecrackers within itself is an occupation, it's a business, and it is a trade. So under Article 19, Clause 1, Clause G, people have the right to have businesses which manufacture firecrackers. Now, they could be heavily regulated businesses, but they are businesses which are per se legal in the country. So when you ban firecrackers, you're essentially putting Article 21 above Article 19. So there is a cross comparison between the two. That is the essence of the 2015 question. So therefore, when you want the right to a clean environment, it is essentially at the cost of banning crackers. Is this fundamentally the right thing to do? So that is the question. Now, of course, the answer is a very obvious one, that 21 becomes an all-encompassing right. And if there is a larger threat to environment, there's a larger threat to life, then the freedom to occupation does not hold the kind of ground it would, because if people don't have the ability to live, then the occupation becomes secondary to life in the first place. But this is, again, a 2015 question where slightly there is an interference of Article 19 and several other provisions. But the primary sense is the Supreme Court giving you a judgment on rights of people versus crackers versus Diwali in the larger context of Article 21. Now, the reason this question was asked in 2015, both of these questions that were asked in 2015 marks a decadal anniversary of the Shah Banu case. That is why Uniform Civil Code was asked, because it was in the Shah Banu case where Uniform Civil Code was actually discussed by the judiciary in a fair amount of detail. The reason in 2015 this question was asked again is, with respect to the environment, is because the judgment had come out, which goes back to our original thesis, that if the judgment of the Supreme Court has come, then we have to evaluate its impact. If the judgment has not come and the issue is pending and it's a major important issue relevant for the exam, then we have to figure out whether there is a violation or not in the first place, as we saw in 2013 with respect to the Section 66A question, because the Sharia single judgment had not come until then. So therefore, both of these questions have a very strong context to current affairs. Both of these questions have been asked because of developments that happened 6 months before the mains that year. And this was so major in the news that even if you wanted to, you could not have missed it per se. So these are the two questions. Now, apart from that, when we move to the next of the questions, we look at 2017, where we look at examining the scope of fundamental rights in the light of the latest judgment of the Supreme Court on the right to privacy, so the 15 mark. Now, privacy was identified by the Supreme Court under the Putto Swami judgment, which is essentially the Adhar case, to also include right to privacy as an implied fundamental right. In fact, in the last 10 years or so, this has been a major interpretation which has changed the discourse of rights jurisprudence in the country. So when the court has delivered such a landmark judgment on the right to privacy, Then again, our standard thesis holds true, where the exam is asking you, now that the court has delivered right to privacy as an implied fundamental right under Article 21, what is again the scope or the impact of it? Where all can we apply right to privacy to? Can we apply it to gender? Can we apply it to sexuality? Can we apply it to identity? Can we apply it to abortion? Can we apply it to sex determination? Can we apply it to digital privacy? Can we apply it to body privacy? Can we apply it to marital rape? The scope of privacy, therefore, then becomes a more important issue, because we are now coming from a point of assumption that the right to privacy is a fundamental right, but going beyond the right to privacy as to where can it be implemented to is something that we have to discuss. So that is in 2017. Now, when we look at the rest of the questions, when we look at the questions that have been asked post 2017, you will not really see a question per se with respect to Article 21. You will see a question with respect to constitutional morality, and that constitutional morality that we are referring to, that provision that we are referring to, is when we're talking about constitutional morality, we're talking about judgments around constitutional morality. When we're talking about issues of constitutional morality, the fact that we have the right to life and liberty also is a moral determination that whatever is in the nature of freedom or in the nature of liberty is also moral. So when we look at the Sabrimala judgment or several other cases where constitutional morality has been discussed, we might use Article 21 as one of the arguments, but not a primary argument nonetheless. So having said that, we've really not seen many questions. And it was in 2022, this year, wherein we again saw a question which emanates out of 21, but 21 is just the background of it. The most significant development or achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Now, this question starts with the fact that the right to a clean environment, the right to safe drinking water, the right to a safe environment is a fundamental right under Article 21. So anything which violates the environment violates a fundamental right for which the Supreme Court can directly be accessed. So when we look at the 2022 question and we see a word called constitutionalization of environmental problems, what does this mean? It first means giving them a presence in the nature of rights. Second, looking at a constitutional mechanism, looking at a redressal body to look at solving environmental cases. So therefore, when tribunals exist because of the Constitution, and under tribunals, you have a very specific tribunal called the National Green Tribunal, that itself in itself is an implication or an adaptation of constitutionalization of environmental problems. And third is when the Supreme Court has on several occasions delivered judgments to protect the habitat and the ecosystem of special areas identified in the Constitution. So it could be the tribal areas, it could be through environmental impact assessments and necessitating those. So these are the three pillars to answering this question that was asked in 2022, out of which rights is one, and the right that comes closest to environment is actually 21. And if you notice, this question in 2022 and the earlier question with respect to right to clean environment is essentially from the same larger school of thought, which is environment. And they've already asked us two questions on the right to environment. Now, this is where we are today in 2022. Therefore, how do we figure out how much of this do we need to study? What should our syllabus plan be? What should be the circumference for us to study Article 21? and certain related provisions around it. So first things first, let's understand this. When we look at Article 21 to be studied for the mains, the first layer are direct issues primarily or only concerning Article 21. What would they be? One, life, and the opposite of life is death. So, euthanasia, the concept of a living will. And third, the way we look at suicide. So, euthanasia, living will, and suicide are direct implications of what are called life. Now, what is interesting about Article 21, and this is also one of the reasons why you will see very few questions on Article 21, is because there are going to be some correlated issues with Article 21 as the backbone. We've done a few of these issues under Article 19, but there is a certain order of things. One, privacy becomes primarily an issue of Article 21, with certain interlinkages to Article 19 and to an extent to Article 14 as well. Two, we look at gender and Article 21. So this could include homosexuality, transgender rights, LGBTQIA as a whole, the advancement of the recognition of homosexuality in the country, and so on and so forth. And once we figure this part out, then we look at the other themes of Article 21, which is we look at environment, because that has been majorly asked before also, and therefore must always have few classic environmental cases ready, because we'll be using them in multiple places and not just with respect to Article 21. So privacy, gender, and environment, they become primary issues with respect to Article 21. Now, there are also several issues which come out of 21, and they're identified in several other rights, such as your criminal justice rights, so your preventive detention rights. Now, those kind of issues with respect to preventive detention, which ultimately affects your life only. Arrest and detention is a compromise on your life and liberty. Our Constitution deals with specific fundamental rights around 20 and 22 for the same. We'll do them separately in the subtopics, in the next topics. But preventive detention also has a bearing on Article 21. So that becomes an important topic. But once we've been able to do this, we will understand the jurisprudence or the constitutional theory that comes out of Article 21. Now, there are several things that we have to understand here. The first is the text of Article 21 within itself talks about procedure established by law. So procedure established by law and its journey from procedure established by law to due process of law is very, very important. And through this journey, we will understand the relationship between 14, 19, and 21 eventually. And this will, of course, have to be dealt with in a separate topic that I've already identified before. And because of this, we will then look at it from a comparative point of view as to how procedure established by law and due process of law are treated in the different parts of the world. Now, there has been a question comparing secularism between India and France. There has been a question comparing equality between India and the US. So can there be a question comparing liberty rights in India versus anywhere else? The answer is no. Because liberty or life and liberty per se does not have constitutionalization of theories around it. Secularism has multiple ways of going about it, multiple systematic arrangements of going about it. Similarly, beyond secularism, we often see equality, affirmative action and non-affirmative action, and reservation and passive and active equality. All of those definitely come as notions of equality. But with respect to Article 21, do we need to know how countries all across the world, through similar constitutions or different constitutions or different countries, how do they deal with life and liberty? The answer is no, because it is too open-ended and there are no theories per se. The only theories that we come out, which we do from a comparative point of view, is the journey of procedure established by law to due process of law, and 14, 19, and 21, and a comparison of all of this ecosystem of due process of law, which is a constitutional theory. So we will compare due process of law in India versus the US versus the UK. We will not compare 21 between India, US, UK, and France. That is an academic call I can make because I've studied the syllabus and I've studied the pattern in a great amount of detail to make the circumference clear for you. So if at any given point of time, there has to be a question, it has to be a question from any of these areas in the exam and nothing else. They've already asked privacy. They've already asked environment. The only thing that they're left with is now to ask gender, which also could now be an application of privacy. So that is that. So with this in mind, this is the layout. This is how we're going to study it in separate lectoral formats. And Article 21, therefore, has to be done with a very, very clear and a very, very fine degree of caution to begin with. So we start with the first sub lecture under Article 21, which is our first theme. This is our second theme. This is our third sub theme or subtopic, whatever you'd like to call it. And we'll finish them up one by one in subsequent lectures. Thank you. Hello and welcome to lecture number 7B, topic number 7, life and liberties. Under lecture number 7B, we're going to be discussing the direct issues arising out of the word life under Article 21. Now, there are only a bare minimum number of issues that come out of the word life. And interestingly, with the word liberty, what usually ends up happening is it has a very close consonance with freedoms under Article 19, which, as we understood, become conjoint issues with a fair degree of focus on Article 21 as the backbone. Now, when we discuss right to life, when we discuss the core elements of right to life, we must understand the actual relevance of it. Because what we've understood is the kind of questions the UPSC is asking in the mains, especially from rights issues, will have some underlying contemporary context, or they will always end up having a thematic sort of an importance through the ages. Issues that come out of life don't fit into that bill, which basically means we only do them to just the right amount of necessity, because not only are they relevant for paper 2, they also are fantastic examples of paper 4. So what are the issues that we are referring to? We are dominantly referring to the following issues. The first is the issue of euthanasia. The second is the issue of attempt to suicide. And the third is the larger issue of, let us say, living wills, which have recently been coined or recognized by India through the Supreme Court. Now, when we look at it again from a relevancy point of view, what are the kind of questions that could be asked? We simply need to know what they are, what is the different form, what is the law of the country on the same, a general comparison of how it works everywhere else in the world, and we can use it as examples in paper 4 as well, in addition to a substantive question on paper 2. Now, before we begin with this topic, I must also make a very strong statement, and that is, because we are talking about issues around death, around the ending of a person's life, these might be triggering in nature to some of you who are watching the lecture. So if you are somebody who is undergoing a mental health crisis, or who is undergoing a degree of not being in a good mental space, then my recommendation would be to think twice before you watch this lecture, or consult somebody before you start watching the lecture, because this is stuff that may affect you in more ways than you can think. So let's begin. When we look at it from a life expectancy point of view, when we look at it from a life point of view, what we're essentially referring to, and we'll do it in a simple chart form, what we're essentially referring to is the process of ending a life, or the instance of death. Now, this instance of death can happen for 3 reasons. And each of these 3 reasons are going to have a completely different set of circumstances. The first is when we're looking at the instance of murder. Now, when we talk about murder, it is essentially a form of somebody killing somebody, and the person who's getting killed did not want to get killed. The person has been killed. And murder is clearly illegal in India. It is also called homicide. Homicide meaning killing of a human being by another human being. And under the Indian Penal Code, it is absolutely illegal. Now, murder also is external in nature, where a person A is killing a person B. Now, the law, the Indian Penal Code, under sections 299, 300, 302, etc., looks at the multiple ramifications of murder, looks at what is called culpable homicide amounting to murder, not amounting to murder, the different degrees of homicide, the criminology behind it, the punishments behind it, and so on and so forth. But this is not in our UPSC syllabus, so we don't have to worry about it. It is the other two that may have some relevance. The first of them, for example, is euthanasia. Now, when we refer to euthanasia, what does it mean? Euthanasia means, or in general, the principle of euthanasia is the practice of intentionally ending a life in order to relieve pain and suffering. That is the general umbrella definition of euthanasia. The practice of intentionally ending a life to relieve pain and suffering. So, identify the keywords. Intentionally ending a life to relieve pain and suffering. Now, this we have 2 forms, or there are 2 ways to look at it. The first way to look at it is on the basis of consent, or on the basis of the status of the patient. So, status of the patient or the consent of the patient. And second is the form or the method in which it is usually executed. Now, the primary underlying understanding is, when we talk about euthanasia, we say it's about intentionally ending a life. What is absolutely crucial is that there are medical reasons for the same, and there is a medical professional who is involved in the process. So that's what makes it particularly a special case. Now, when we talk about status and consent, what do we understand out of here? We understand that there are going to be two scenarios. Scenario number one, where the patient is understanding and the patient is himself or herself requesting for the same. The patient is giving consent on their own. This is called voluntary euthanasia. In the case that the patient is unable to give consent, the patient is unable to communicate, the patient, let us say, is in an absolutely vegetative state. In such a scenario, it is the relative of the patients, the family of the patients, children, the spouses, whoever, they will request for what is called involuntary euthanasia. Sorry, request for something called non-voluntary euthanasia. So it is voluntary or non-voluntary euthanasia, right? Because here, again, the patient is incapacitated to give consent. Now, apart from this, there are two kinds of methods that we look at. One is that the patient is under life support, and to end the patient's life, you have to withdraw life support. So that is called passive euthanasia. And the second is that you have to insert something onto the patient, insert a medicine into the patient, insert a chemical formula into the patient in the form of a lethal injection. And only when you do that, that is when the patient loses their life. So that is called active euthanasia. So this is the general layout. These are the general forms of it. Now, something very close to euthanasia, but in a different sense of it altogether, is something called attempt to suicide. Now, attempt to suicide also comes from the larger umbrella of suicide. So while one is murder, the second is euthanasia, the third is suicide. Now, what is common to suicide and euthanasia? Suicide is also intentionally ending a person's life to relieve pain and suffering without any medical compulsions whatsoever or without any medical help whatsoever. Euthanasia is also externally executed. There is somebody else who's playing a role. But suicide is dominantly self-inflicted, that the person is committing suicide of their own, on their own. Now, there are two very simple possibilities of suicide. One is, suppose a person X has committed suicide and has been successful. So the person, of course, is no longer alive. What if a person tries to commit suicide and does not die? Then it comes under the larger domain. It comes under the larger domain of what is called attempt to suicide. Comes under the larger domain of attempt to suicide. Now, attempt to suicide was previously illegal in the country, but today has attempt to suicide was criminal, it was illegal. So if somebody tried to commit suicide, then they would be considered a criminal under law. But having said that, because of the Mental Health Care Act, we have been able to eliminate the possibility of criminalization of attempt to suicide, and attempt to suicide is no longer a criminal offense in it. Largely because if a person is already in a terrible mental space that the person wants to end their lives, above that, if they're unsuccessful, subject them to jail time, subject them to prosecution, it could further deteriorate their mental space, and they need the kind of counseling to feel better and to get better on a daily basis. So that is something that we must understand and begin with. Now, as we were discussing, whether it is suicide or euthanasia, there is a common point of intentionally ending one's own life, which is also why you will see that in both of these cases, the Supreme Court has played an extremely role. And this can be used as examples of judicial, you could say, review or to an extent activism, where the judiciary has really put forth a new era of how we look at the concept of life and death. So this also becomes an example in a judicial review, judicial activism kind of questions. Now, having said that, in both of these cases, we have seen an incremental increase in the liberal approach of the court. The courts originally had a very conservative approach, so therefore now they are legal. But slowly, as we come closer to 2022 and beyond, we will see that the courts have become far more open-minded, far more liberal. But the initial judgments for both of them are actually the same, because intentionally ending someone's life is common to both euthanasia and suicide. And Section 309 of the Indian Penal Code deals with this. This Section 309 still is a part of the Indian Penal Code, but because of the Mental Health Care Act, what has now happened is that a provision of the Mental Health Care Act now overrides the provision of Section 309, thereby making attempt to suicide completely decriminalized. Now, having said that, there is one layer of suicide, which is this. The second layer of suicide is either somebody commits suicide on their own accord, or secondly, they commit suicide because somebody has asked them to, because somebody is provoking them to, because somebody is pushing them to. And for that, in our criminal law, we have something called abetment to suicide, which is very much an illegal instance. It is a crime. And suppose there is a person Y constantly pushes X in one way or the other, makes the life of X so miserable that X contemplates suicide, then therefore the person Y could be charged with abetment to suicide if the need may be. So this is largely how this works in the larger ecosystem. This is largely how it works in this sort of paraphernalia. Now, having said that, we again come back to how much do we really need to know as far as our exams are concerned. The answer to that question is a fairly simple one. We simply need to know the journey of euthanasia from the legal point of view. We look at some primary arguments for and against it, and a simple understanding of what attempt to suicide is. Anything more than that is particularly not important as far as the exam is concerned. So let us now begin, and now let us understand how this works. When we start understanding euthanasia, we must understand that voluntary euthanasia is now somewhat in a gray area kind of legal because of the concept of living will. Non-voluntary euthanasia is, there have been two cases around it. Passive euthanasia, which is withholding the treatment, is also somewhat legal because of living will. But active euthanasia is absolutely a question mark as far as India is concerned. The law is not clear on this. We do not deal with it, which is why one of our fundamental issues with euthanasia is because the Supreme Court has kept on giving guidelines on it. We do not have a dedicated law or a policy or a set of guidelines issued by elected representatives with respect to euthanasia. So let us now start understanding what euthanasia is, what is the general outcome of it, and so on and so forth. So as of now, we understand that the most recent development has been that passive euthanasia is now a legal reality in the country. Now let's start. Why are we even getting into whether euthanasia is allowed or not. Because when we talk about Article 21, which refers to the life and liberty, we also understand that life should also mean the right to die with dignity. And dignity is something which is enshrined not only implicitly in our fundamental rights, it is also enshrined as a very important objective in our preamble as well. So, the Supreme Court has declared the right to die with dignity as a fundamental right implied under Article 21 in the common cause judgment, which allows for living wills and so on and so forth. So this is called the common cause versus Union of India judgment. Now, this judgment, which was passed in 2018, allows for passive euthanasia, and through this judgment, the court has fundamentally declared that you have the right to die with dignity. Like how we have the right to privacy under Article 21, we also have the right to die with dignity. Now, having said that, let's understand what are the basic provisions, what is it that we are referring to, and so on and so forth. See, the story to euthanasia, the story to attempt to suicide, any of this actually starts with a case called Gyan Kaur versus State of Punjab. Now, this is a 1994 judgment, and in this judgment, the Supreme Court had very clearly established that both assisted suicide as well as euthanasia are illegal. Now, you're hearing the term assisted suicide for the first time. Let us understand what assisted suicide means. See, it is very similar to euthanasia, but there's a slight difference. Assisted suicide is a part of a larger discussion called assisted dying. It includes physician-assisted suicide or voluntary active euthanasia. So assisted suicide is also the same thing as voluntary euthanasia, where the person is requesting for it. And physician-assisted suicide is essentially when the physician is involved in administering an injection or withdrawing treatment. So both of these were essentially declared illegal in the Gyan Kaur versus the State of Punjab judgment in 1994. Now, in this judgment, the court had also categorically said, it was a 5-judge bench, that the right to life did not include the right to die, and therefore we shall not be going forward with this. Because this is a 5-judge bench, so we start our journey from here. However, before Gyan Kaur, there was a Rathinam judgment. The Rathinam versus Union of India judgment had a more liberal approach of the court, wherein they struck down 309 as attempt to suicide as unconstitutional. But this was overruled in the Gyan Kumar case, in the Gyan Kaur case. So it also overruled a previous Supreme Court judgment, which was called the P. Rathinam judgment, which had struck down, had decriminalized the attempt to suicide, because whether it is euthanasia or attempt to suicide, it's fundamentally ending someone's life. You could do it yourself, you could have someone else medically assist you for it, and so on and so forth. Now, in the Gyan Kaur case, the Supreme Court, Apex Court, had held that Article 21 speaks of life with dignity, and only those aspects of life which could be made more dignified could be read into this article. And therefore, right to die, by principle, brings a lack of dignity to right to life, so we are not going to understand it and not going to allow it. However, we saw a massive shift a few years later in an extremely important judgment called the Aruna Shanbog judgment. Now, in the Aruna Shanbog judgment versus Union of India in 2011, the Supreme Court gave an agreement or a nod to the concept of something called passive euthanasia. Now we know what passive euthanasia is. Passive euthanasia is a form wherein we're withholding, or we are stopping, or we are not continuing with life supporting equipment or life supporting treatment. Now this is an extremely important case, a very sensitive case also. So Aruna Shambhag had been in a vegetative state in India since I think 1973. And on her behalf, a social activist, a journalist, a writer called Pinky Virani had filed a writ petition claiming that her right to life, as guaranteed by the Constitution, had been violated. Now, the Supreme Court made a very clear opinion that such a decision regarding the death of an individual could not solely be left to the discretion of the parents' relatives or the next friend, which could in this case be the nursing staff in the case of Chambag. There has to be a more process and a system-driven approach to solve the problem of abuse of passive euthanasia, because at the end of the day, you're withdrawing some amount of treatment. So when this case was being discussed, the center, which was of course arguing the other side, very clearly said that the recognition of something like this could be very counterproductive, could be used for falsifications in property, for vested interests, and so on and so forth. And at that time also, the center had very clearly opposed the idea of a living will. And what is living will? We'll talk about it. And said that when the person is giving a consent to remove life support or anything of that sort, the person is not in a state to do so, is not in the right mental space to do so. Now, one could say that the lack of social awareness at that time, or generally the lack of understanding what people go through around that time, could have prompted like this. But we are now coming to some very important terms: a living will, active and passive. See, active euthanasia differs from passive euthanasia in that in active euthanasia, death is given or is possible through a specific act. For example, you're given an overdose of painkillers or like a lethal injection. In passive euthanasia, death is medically brought about by omission, which means that you will not have any medical intervention to save a person's life. In Western countries, we also have a system called DNR, do not resuscitate, which if a patient signs a DNR order or do not resuscitate order, then if the patient is let's say has gone into a surgery and the patient is collapsing or sinking, then in that scenario, a DNR order will prevent the doctors operating on the patient to revive or to save the patient. See, euthanasia is often regarded as the only viable option when all other life intervention and all other ways to save lives have failed. And terminality seems to be a very possible outcome. Now, this is what we've been understanding so far. The term that we are now introducing is the concept of a living will. So what is a living will? A living will is a written document that allows patients to give instructions in advance about the medical treatment that has to be administered when the person is terminally ill or no longer able to express informed consent. And these instructions could be withdrawing life support, or once the medical board around the patient has said that there are no medical options that are left. So basically, a living will is a form of what is called voluntary euthanasia in the possibility of something going wrong in the future. Of course, the government had opposed it, saying that there might be possible misuse. But up until Aruna Shambhag, the concept of living will and all of those, which are forms of active euthanasia, forms of voluntary euthanasia, do not exist in the country. So again, just to give a little bit of understanding, living will is nothing but a document which is written, of course, in nature, which allows a patient to determine medical treatments or the lack of it. This could include withdrawing life support system. Now, we finally have a judgment, which is called the common cause judgment, which therefore now allows for what is called a living will. So, the common cause judgment versus Union of India, 2018, allows for setting up of living wills. They have to be done through multiple boards. There are procedures. The DM also has to verify and be registered and kept with the district magistrate. There are a lot of procedures involved, but these procedures don't have to be done for your exam. Similarly, the procedures for passive euthanasia don't have to be done for your exam. You just need to know this is what the system is. So a living will, when a person writes a document, you must understand it becomes active and it becomes voluntary in nature. So through living wills, we have sort of, in a very, very minor, in a very, very limited manner, looked at voluntary, active, and of course passive was always there, forms of euthanasia. So this is that. Now, when we look at the rest of the world and we see how it works, we must understand that there are several countries. I think you start with Netherlands. Netherlands was the first country to ever legalize euthanasia and assisted suicide in April 2002. And they had, of course, given very strict guidelines that the patient must be suffering in unbearable pain, the illness must be incurable, and the demand for euthanasia or assisted suicide must be done in full consciousness by the patient. After Netherlands, Belgium also followed with the law in 2002 itself, allowing for or legalizing euthanasia. In the Belgian law, while assisted suicide is not particularly mentioned in the law, doctors can help the patients to end their lives when they express unsufferable pain or an inability to continue any further. When we look at it in the US, which we often compare our laws to, euthanasia dominantly remains illegal in the US, but in the 5 states in the country of the US, doctors are allowed to administer lethal doses of medicines or lethal injections to terminally ill. In 2015 also, I think about 300, 400 cases were actively recorded and reported in the US. So this is that. Now, euthanasia does not necessarily have a clear black and white answer, because there are a few things which are in support of euthanasia. There are a few arguments which are against it. When we look at arguments in favor of euthanasia, we understand that they're primarily based on empathy and morality, that you want to relieve somebody of their pain, especially when there is no scope of improvement. Second, the right to die forms an extremely important part of the fundamental right. guaranteed under Article 21. Thirdly, when we look at self-determination, human beings should have the right to be able to decide when and how they want to die. We may not have a choice in our birth, but we certainly should have a choice in our death. Fourth, euthanasia gives a person a sense of control over their final days. And ultimately, a more philosophical argument in favor of euthanasia is that it is an ultimately private matter. And any intervention by the state could essentially be encroachment in the private space of a person. Now, with the fact that privacy is now a fundamental right, if tomorrow somebody challenges the current system of euthanasia on the grounds of right to privacy, we might see a more heightened form of euthanasia in the country. But as many as there are arguments in support of euthanasia, there are also arguments which go dead against it. First, when we look at the basic difference between active and passive euthanasia, the difference between active and passive euthanasia is morally very, very significant, because withdrawing life support and administering a lethal injection has a very different involvement of the doctor. You may have to withdraw life treatment simply because the patient may not be able to afford medical care. But inserting a lethal injection could have drastic consequences. Second, when we look at it again from a moral philosophical point of view, if we have heightened cases of euthanasia, the way the society looks at in terms of the value of human life, that in itself becomes questionable. Third, it does not take into account any unexpected results or a medical miracle or a sudden survival of any sort. And fourth, if euthanasia had become so rampant, then will the research industry, will the pharmaceuticals, will the medical scientists all across the world, will they spend so much of time, energy, and resources trying to solve problems for the terminally ill, trying to discover a cure for the cancer, trying to discover a cure for diseases which are going to essentially be fatal? Fifth, we are assuming that people are in pain. And yes, people are in pain when they're about to die in these circumstances. But not all deaths are painful. We have a separate branch in medicine which is called palliative care. And palliative care ensures that you're able to take care of people who are suffering from terminally ill diseases. The sixth point is that in a country, especially like India, where oversight and implementation have been standard issues, no matter what the case might be, regulation of euthanasia and ensuring that the process is not misused is always going to be a continuous challenge. And that is why it becomes very difficult to be very sure how is it not going to be used by children of dying parents or old parents who just want to grab their property. And lastly, there is no room for changing one's decision beyond a certain point, even if one wants to change their mind. It is not something that can be reversed. Death cannot be reversed. So that is why euthanasia becomes a slightly complicated problem. Now, having said that, how do we go about it? We have to first ensure that we should have a dedicated, a clear law on euthanasia. We can't keep relying on the courts to tell us on a case-by-case basis or a type-by-type cases. So we must, at all circumstances, have a dedicated law passed by the parliament. Two, while we have a constitutional right to refuse medical treatment, we may not just have the infrastructure for it, the mechanisms for it, the enforcement agencies for it. So while it might make sense, but we have to be very sure that the abuse of euthanasia does not necessarily become a reality. So this is the larger discussion on euthanasia and living wills. And you don't need to know anything beyond this as far as the exam is concerned. Now, from here, we move to the next element under a direct implication of life, which is the attempt to suicide. Now, we understand that fundamentally, attempt to suicide has been decriminalized. But let's understand what happened. Why is this such an issue? See, almost every year, easily more than 1 lakh cases of suicide are reported as per the National Crime Records Bureau data. And especially post the pandemic, the instances of suicide have also taken newer heights. Now, the question here is, can somebody take their own life? Is suicide an act of self-destruction, or is it an act of self-killing? Does right to life also more primarily include the right to die? The right to die with dignity is what euthanasia takes care of. But if you have the right to live, you also have the right to die. Now, how we look at this is essentially the era that we live in. We understand that the Indian Penal Code, which is our primary criminal law, was enacted in the year 1860. And the law in itself is an ever-evolving, very dynamic concept. And law in India has always been subjected to change in societal beliefs. So, for example, when we look at decriminalization of 377, we'll discuss gender and orientation in the next subtheme. We understand that at the core of it all, what we're looking at is a change of the pace in which society is moving. Decriminalization of society would have not worked in the 60s or 70s, but it certainly works now, today. So now when we look at how we refer to suicide or we understand suicide, it becomes a very, very different set of systems or a very different set of explanations. See, the start to attempt to suicide starts with something called Section 309 of the Indian Penal Code, which says if a person tries to commit suicide or does anything in the attempt to suicide, that is a crime would be punishable under this section, which is why Section 309 not only is about attempt to suicide, it also has implications on euthanasia. Because if a patient is requesting euthanasia, in a way, that is also attempt to suicide. But the difference is that is for medical reasons and this is not. And the punishment here is, I think, around about 1 year or a fine or both. And it was originally a cognizable offense, where a person could be arrested for attempt to suicide without an arrest warrant. It was a bailable offense, which means you could get bail out of it. And it was a non-compoundable offense, which means you cannot have an out-of-court settlement for it. But for attempt suicide to be true, there are essentially two components of it. One is that the person should have been unsuccessful in committing suicide, because if the person is successful, then there is no point. Second, this must be intentional. It cannot be something which was accidental or there was a mistake. It must be a very clear indication to a person to end a person's life. In fact, when we look at where Section 309 is placed in the Indian Penal Code, if I remember correctly, it is in chapter number 16 of the Indian Penal Code. it is placed under the chapter which looks at offenses against the human body, except that 309 is the only offense which looks at offense against the same human body. Murder, rape, all these are offenses against another human body. Whereas attempt to suicide is an offense against self-destruction, right? Now, the reason why 309 existed is to minimize suicides in the country, because it is the fundamental duty of the state to protect citizens from any harm whatsoever. But when we look at the sort of timeline of how all of this has worked, it's a very simple one. One, we start with the original discussion, just to give you a broad timeline. The story starts in 1970, where the 42nd Law Commission says we must delete the offense of attempt to suicide. So the 42nd Law Commission of India recommends the deletion of Section 309. That, of course, is not implemented. Because when we look at it in 1978 to 1979, the government had actually accepted the suggestion, and around the same time the government changed and the bill eventually lapsed in the Lok Sabha. So there was a failed attempt in 1978 to solve this issue. Then in 1985, a very small judgment, the Delhi High Court judgment of the state versus Sanjay Kumar Bhatia, the Supreme Court, the Delhi High Court said that Section 309 is unworthy of human society. In 1987, the Bombay High Court, in the Maruti case, said Section 309 violates 14 and 21 because you're treating people differently just because somebody has right to commit suicide, and it is a violation of right to life. Now, both the Delhi and the Bombay High Courts were of the same view that Section 309 is wrong. But in 1988, the Andhra Pradesh High Court had said that no, right to life does not include the right to right. The right to die does not include the right to life. The Andhra Pradesh case, I think, was Chenna Jagdishwar versus State of Andhra Pradesh. All of this you don't have to memorize. This is just to give you an understanding of how things were. So in 1988, the Andhra Pradesh High Court said that no, right 309 is completely okay. It does not include the right to life. Now, in 1994, the P. Ratnam case, the court again upheld the view of the Delhi and the Bombay High Court and declared Section 309 as completely unconstitutional. So P. Ratnam becomes the first case of the Supreme Court where 309 becomes unconstitutional. Just 1 more year later, 1994 itself, 25, the Gyan case happens, where the Supreme Court reverses it through a 5-judge bench and says that 309 is in fact constitutional. This is the journey. Now, in 1997, the 156th Law Commission said we must keep Section 309. In 2008, the Law Commission changed its stand. So in 2008, the 210th Law Commission said we must remove 309. So as you can see, there has been a lot of fluctuation. But in 2011, in the Aruna Shamba judgment, the Supreme Court recommended to the Parliament that we must consider decriminalization of Section 309 because the Supreme Court thought it would be a violation of separation of powers if they did so. And the case was not about 309 anyway. In 2013, the mental health care bill was introduced. And now we had a more legislative action or of affirmative legislative action, which eventually was passed in 2017 as the Mental Health Care Act. And the Mental Health Care Act clearly, very, very clearly, in the section, I think 115, very clearly says that any person who tries to commit suicide will not be tried under 309 and would in fact be given adequate treatment from the government so that the person is in a better space. So this is the journey of attempt to suicide. Now, attempt to suicide is still a little more complicated because even if attempt to suicide is decriminalized, the abetment of suicide is still completely illegal, and it should be illegal because you are provoking somebody to end their life. But apart from this, there are also several medical, legal, and forensic issues that arise out of attempt to suicide, but they are not relevant for you in general studies preparation. This is more than enough for us to sail through what we needed to understand as far as attempt to suicide is concerned. But our direct implications of right to life, murder, euthanasia, and suicide are done. Anything more than this, from a pure 21 perspective, is not important. What we now do in the next lecture is we pick up liberty, which has a close association with 19, and we look at gender, we look at privacy, we look at environment, we look at a lot of other issues before we move to the constitutional jurisprudence arising out of Article 21. Thank you. See you in the next lecture. Hello and welcome to lecture number 7C of topic number 7 for the mains, life and liberties. And we are going to be talking about privacy as far as the mains exam is concerned. Now, before we begin privacy, we do understand a few conditions attached with privacy. The first condition is that a question on privacy very categorically has already been asked in the exam. This was post the Putto Swami judgment. The question was, given the fact that the fundamental right to privacy has been recognized, what comes after? Now that question though may have been asked, but should still be prepared because it could be used in many different forms in many different places. So that's something that we must understand. I'll take you to the question directly. So you can see the question here. Examine the scope of fundamental rights in the light of the latest judgment of the Supreme Court on the right to privacy. Now, that question is an evergreen question in another form, in another wording. The question can come up again, especially when we are so stuck as a country to solving the data privacy problem. Now, having said that, let us understand to begin with, when we're looking at privacy, what does privacy start with and what does privacy end with? So what should be the flow of our lecture to get it right as far as the mains exam is concerned? So when we start with privacy, we first understand the evolution of privacy through various Supreme Court judgments. Then we take a magnifying glass and figure out the Putto Swami judgment, which truly gave life by making privacy an implied fundamental right under Article 21. Once we've understood this, we then look at the implications of the right to privacy, and this has to be done in a thematic manner. We will look at it from a technology point of view, from a gender point of view, from a information point of view, from a body point of view. Now, why is this important? Because, for example, when we look at the implications of privacy on gender and identity and orientation, this automatically covers our small topic on LGBTQIA or say women rights with specific reference to paper 2, with specific reference to polity. Because now that privacy is a fundamental right, anything that happens to LGBTQIA or homosexuality or transgender rights or anything will always be looked at from the view of privacy. Because at the end of the day, it is a matter of choice. And that, of course, then translates into Article 19 as well. Because right to privacy, no doubt, is primarily under Article 21, but also can have implications to 19 and some other areas in Part 3 as well. So this is the purpose of lecture number 70. So let's first begin with the evolution of the right to privacy through understanding our judgments and so on and so forth. So our first area of discussion becomes the evolution of privacy in India. Now, to begin with, we must understand that privacy, up until the Putto Swami judgment, was very basic in nature. It was about surveillance, it was about arbitrary state action, it was about the state preventing people to have access to a few rights when they were in detention. So up until Putto Swami, privacy and arrest, privacy and detention, privacy and the role of the state was very, very rudimentary in nature. It is only after Putto Swami that we truly understand that privacy has a far more overarching impact because of digitization, because of Adhar, because of technology. So sometimes it takes a government policy of Adhar to then be examined by the Supreme Court, to then look at the larger question of privacy. Otherwise, our understanding of privacy in India for a very long time was always very, very conservative, was very narrow, was very tangible. And that is demonstrated, that is seen when we look at the evolution of privacy under the Indian ecosystem. We start with our Constituent Assembly debates, which debated privacy around 1948. This is the first attempt in any manner to protect the privacy of an individual against unreasonable state interference, as we were talking about it. Why? Because we are waking up from a colonial regime. We have fought a colonial regime, and we are now here fighting ourselves to become independent. Now, a common principle of administration or a common policy that the Britishers had implemented in India were unlawful search and seizures, were unlawful police visits. So fundamentally, primarily, when you are being searched for no reason of yours, when your property or your assets or your belongings are being seized for no reason, which was lawful at the time, then that at a very, very basic atomic level is an issue of privacy. If somebody just walks into your house without any reasonable restriction, without any reasonable reason, without any just cause, they're essentially violating your privacy. They're essentially violating your personal space, which is your house. So that is exactly what was being discussed in the Constituent Assembly. And this also sort of sets the tone for how privacy is looked at up until 2017, because we looked at privacy in terms of police action, in terms of state action, in terms of arrests and detention privileges. So a member of the Constituent Assembly, Mr. Syed Karimuddin, had moved an amendment to the Constitution, very specifically saying that we must have a specific right in the Constitution to protect individuals from unreasonable search and seizures. Now, this unreasonable search and seizures is something which is mentioned both in the American Constitution and the Irish Constitution as well. However, this amendment did not go through. Dr. B.R. Ambedkar, while delivering his speech on the discussion of that proposed amendment, said that we don't need to mention it in the Constitution. We don't need to make it a fundamental right. Your right, individuals should be protected against unlawful search and seizures. But we already have a law called the Criminal Procedure Code, which already provides the citizens or the people of the country the same privilege. He said, no doubt, what you're suggesting is useful. And we understand that this should be beyond parliamentary action, which means that the parliament tomorrow cannot wake up and say, oh, we don't want this right. We can just remove a section of the CRPC and says, well, citizens don't have the right to unlawful search and seizure. But he also said there are very easy ways to make reasonable restrictions around it. So if the parliament has to, they will find a way. They will look at some or the other manner in going about it. But there is no purpose of putting it directly under Part 3 of the Constitution, which is fundamental rights. So therefore, before the final draft came out, you would see that the right to privacy does not find a definite and a clear, explicit place in the Constitution. So what are the 2-3 points that we must remember? The first is, we were looking at a specific right with respect to unreasonable search and seizures. This was a proposed amendment. And this proposed amendment did not go through. And we were looking at privacy through the lens of arbitrary police action. Through arbitrary police action. Now, let us continue. When we move to the next set of arguments, when we move to the next set of discussions, let's go ahead. The second major theme that we are trying to refer to, the second major development that we are trying to refer to, is a Supreme Court judgment in 1954 called MP Sharma versus Satish Chandra. So the MP Sharma versus Satish Chandra case, which is one of India's first privacy-related cases. Now, as we can understand, what is this case about? This case related to the search and the seizure of documents of some Dalmia group of companies because of certain investigations that were launched into the way the company was conducting its affairs. Now, once an FIR was filed, the district magistrate of that area gave powers or gave orders or issued warrants for searches to be conducted on the company's premises to get some documents or some files. Now, a writ petition was filed before the Supreme Court, where the constitutional validity of those searches, which was authorized by the DM of that district, were being questioned. They said that the fact that you're trying to do this is a violation of Article 19, Clause 1, Clause F, and Article 20, Clause 3. And 20, Clause 3, as we understand, is nothing but the fundamental right against self-incrimination, which is you cannot force yourself to give evidence or witnesses against yourself unless it's done through a legal sense of it all. See, the MP Sharma case is a significant case. It's because there were 8 judges on the Supreme Court bench, and they clearly held that the drafters of the Constitution did not intend to subject the power of search, the power of seizure, to a fundamental right to privacy. They said that we understand that the 4th Amendment to the US Constitution is a far more liberal and a powerful amendment. And no doubt, they give you privacy the way they do. But the Constitution of India does not have that language similar to that of the US. and there was no reason to take the US concept of privacy and apply it in search and seizures. In very simple terms, what the court in 1954 said is that don't equate the power of search and seizure to a fundamental right to privacy in the first place. It has no relation at all. So this was a little bit of a setback to, of course, Indian jurisprudence. So the only point that you must need to know from here is that privacy and search and seizure are not correlated, and we must keep ourselves away from how the US looks at it. The third case, which is a fairly popular one, is in 1962. The case is called Kharak Singh versus the state of UP in 1962. Let's understand that. In this case, the right to privacy was invoked to challenge the surveillance of an accused person by the police. This accused person was Kharak Singh. Kharak Singh was arrested for dacoity, but was later released because of the lack of evidence. However, the police in Uttar Pradesh was always suspicious about Kharak Singh and his activities, and they were only waiting to catch him red-handed. So if you were waiting to catch somebody red-handed, you would naturally want to put them under surveillance. So the UP police regulations, which is a manual which exists in the UP, every state has their own, allowed or gave the powers to UP police to conduct surveillance on Kharak Singh. At that time, surveillance would mean physical surveillance, checks, home visits. We didn't have telecom and technology back then the way we do now. Now, Kharak Singh, a dacoit, challenged the constitutional validity, the very constitutional validity of this chapter number 20, and the powers it was conferring on the police officials as it violated the rights of our fundamental in nature. Said that the fact that the police has the powers to conduct surveillance is in itself is violating my freedom to movement. And if it is violating my freedom to movement, it is also violating my right to life, because my privacy, of course, is an issue. So what was the UP police doing? The UP police used to show up at Kharak Singh's house at 1 o'clock in the morning, at 2 o'clock in the morning, at 11 o'clock at night, and just generally check if he was doing okay or not. Now, this was not an 8-judge bench, this was a 6-judge bench. And in this, the Supreme Court very categorically held that the domiciliary visits, the house visits that were done by the officials of the UP police were unconstitutional. They cannot do it, but the general provisions of surveillance are okay. You may want to do it for extreme reasons. But most importantly, despite saying that these harsh, unreasonable visits at someone's house at 1 a.m. in the morning just because you think he's a dacoit and he's up to something, that is wrong. That is unconstitutional. We will not allow that. But the rest of the regulations which allow you to do whatever you have to do, that's completely okay. Now, having said that, the court still was this close, because you are now saying that the reason police can't come to your house is because you have a right to privacy, because you have a right to your private life, you have a right to your private time. So if that is the case, then the Supreme Court should have said the right to privacy is a guaranteed right under the Constitution, but it did not. So here, despite getting so close, the Supreme Court still said that privacy is not a fundamental right under the Constitution. This is the case, which is why you would often hear of a saying that says Khadak Singh ki Khadak se Khadak thi hit kiya. It comes from the same judgment, actually. Now, in 1975, there was another very small case, a similar case, but with a sort of congruous outcome. It was called Govind versus the state of MP in 1975. So Govind versus the state of MP in 1975. What happens in this case? Like how in Kharak Singh, we had UP police regulations. In Govind Singh's case, as you could know, we have MP's police regulations, which also gave MP police similar powers of surveillance, including domiciliary visits, and so on and so forth. Now, let's understand this. Govind had alleged false sort of accusations brought against him on the basis of which he was put under surveillance. So he had a problem with the fundamental reason why surveillance was being put on him. The court dismissed the petition and said, while we understand that, Mr. Govind, you are troubled, but you must understand that the MP police has the right to do what they have to do. And the Supreme Court gave a warning to MP police to not cross a line, to be civil about it, to be cooperative about it. But you have the right to conduct surveillance. It is still not a violation of privacy. So again, a similar case with respect to Kharak Singh, that privacy is not a fundamental right. So as you can see, in both of these, in all of these three cases, we've looked at privacy primarily as a tool which affects surveillance, which affects unreasonable search and seizures. But then suddenly, because of Adhar, because of digitization, the jump from 1975 to 2017 is extraordinary, which is when we see Justice Retired K.S. Putto Swami versus Union of India in 2017. So we call the judgment as the Putto Swami versus Union of India. This is the privacy judgment. It was delivered in 2017, I think in the month of August. It was a 9-judge bench finally, and had delivered a unanimous verdict called the privacy verdict, or the Adhar verdict, or the fundamental right of the century verdict, saying the Constitution of India guarantees each person, each individual, a fundamental right to privacy. Though it was a unanimous judgment, but 6 of the 9 judges gave their own reasoning for the same. And of course, you had a common judgment for the remainder. So the idea here is that the judgment in itself becomes an important turning point in Indian legal history. Now, the Putto Swami judgment within itself is an example of judicial review, almost hindering on judicial activism. It's almost about the courts reviewing certain actions of the legislature. Should they have done this in the first place or not? That is not a question of debate. So this is what happened. So in the Justice Putto Swami case, we now say that privacy is a fundamental right, primarily under Article 21. In the prelims, if they ask you, it's always 21, even if 19 is there. It also has implications to Articles 14 and 19, etc. But Article 21 is where privacy originates from. So now that we understand this, it therefore becomes important for us to understand that the right to privacy judgment, how did it come about? What happened? What was the origin of it? And why are we referring to it? See, the Putto Swami case didn't set out to get the courts to look at privacy. It was on a completely different direction with respect to the Adhar Act. So let's quickly understand what was the Putto Swami judgment originally about. So let's understand this. So the judgment is called Justice K.S. Putto Swami versus Union of India in 2017. This judgment primarily looked at the constitutionality of the Adhar Act, which then led to the discourse on privacy. There have been questions from here, both in the mains and the pre also, where what can be done, what cannot be done. Now, this judgment essentially has three basic questions to look into. Out of the three questions, it is only two questions which pertain to right to equality. So the three questions that this judgment wants to get into are, first, the amendment that was made to the Adhar Act was done in the form of a money bill. Was the parliament competent to make this a money bill and pass it? Should it have been a financial bill? Should it have been a financial two bill, or whatever it is? But was the parliament competent or right in passing Adhar as a money bill? That was the first question. The second question that we look into is, while making an Adhar card, we have to provide for a biometric data. Now, that biometric data includes our fingerprints and includes our eye scan data. And that has to be maintained by the Unique Identification Authority of India. Does that biometric data violate the right to privacy? So, the biometric data provided, does it violate privacy or not? And third, if you are going to make Adhar compulsory for getting subsidies and benefits under a section, I think section 7 of the Adhar Act, does it violate the right to equality and dignity? That only those who have Adhar card will get benefits out of a government scheme. The people who don't have Adhar cards are therefore not allowed to get benefits or subsidies. So you're essentially discriminating against people on the basis of somebody having an Adhar card or not, which cannot be a valid way to look at Article 14, because you cannot discriminate on the people just because they don't have an identification document. So that's the basic idea. So the third issue was the issue of Adhar being compulsory or not. Now, out of these issues, as we can understand, the first issue does not concern us, though is an important issue, because here the speaker had given a certificate making the Adhar bill a money bill, which means that the Lok Sabha can override the Rajya Sabha and it gets passed in a faster and non-controversial manner. The Supreme Court did give a judgment on this, but that's not something that we have to be particularly worried about. The prelims, the year the judgment came out after that, has already asked a question on what is Adhar compulsorily for. It is this question which ultimately leads to the larger problem of privacy. So this is why the entire case is about. These are the three issues that the case is about. Now let's understand what happened in the case. Why does the case come here? Let's start from the very beginning. See, the year was 2011. In 2011, the central government initiated a new identity document that identity document was called the Adhar card, and it established a new agency called the Unique Identification Authority of India to issue the card. So our basic timeline is very, very clear. Our basic timeline is that this starts in 2011. In 2011, we introduced two things. One, Adhar, and the second is the Unique Identification Authority of India to implement it. Now, Adhar is a 12-digit unique identity number. The government intended for Adhar to be the primary identity number for all legal Indian residents. If you're an illegal migrant, then of course you're not entitled to it. Which also makes us understand that Adhar was never a proof of citizenship. It still is not a proof of citizenship. The government made Adhar available to every legal resident free of cost. In order to apply for the card, in order to get the card, a resident must submit their biometric data, which includes their fingerprints and scans. And the Unique Identification Authority is responsible for storing that data in a centralized database. The Unique Identification Authority of India, therefore, becomes this organization who is responsible not only for processing this entire database, but also storing all of the data in a centralized database. This became a key essential ingredient of the entire ecosystem. Now, after a while, in due course of events, the government progressively made Adhar card mandatory for a number of welfare schemes. These included food schemes such as the public distribution system, the midday meal, which becomes the Poshan Abhiyan later on, guaranteed wage labor under Mahatma Gandhi National Rural Employment Guarantee Act, and so on and so forth. And therefore, this gets now challenged in the Supreme Court by someone called Justice K.S. Putto Swami, who is a retired judge of the Karnataka High Court. And he claims that Adhar infringes upon the fundamental rights guaranteed by the Constitution. And his objections were primarily two-dimensional. The first was the government did not put adequate privacy safeguards, and any private entity may request for an authentication from Adhar for any reason subject to UIDAI regulations. There were no checks or balances on the power of the government to use the biometric data that was being collected. The second dimension of his arguments were entitlements or benefits that are granted to individuals by the state's social sector schemes, such as midday meal, etc., are themselves a fundamental right, and they cannot be limited for any reason, including the reason that you do not have an Adhar card when you are applying for these benefits. So it was on the basis of this that the judgment was understood. Now that we understand it, let's understand the legal journey of this judgment. So ultimately, it came to a 9-judge bench. Now you must understand that this case is getting into specific questions such as, was the Adhar Act a valid law? Second, does biometrics violate privacy? Third, can you make Adhar compulsory? The underlying issue for all of this became, is privacy a fundamental right or not? That's something that the court understood and made an issue as a formal legal issue in the judgment itself. So that is how it works. Now, the judgment came eventually in 2017, but The case was filed in 2012. Now, in 2015, a 3-judge bench of the Supreme Court passed an order saying that it should be referred to a larger bench on the question of right to privacy. And therefore, the larger bench was first a five-judge bench, but then from a 5-judge bench, it was then referred to a 9-judge bench. So the right to privacy question had to be dealt with a larger bench. The rest of the questions could be dealt by a smaller bench. That is an internal process. The Supreme Court is more than welcome to do so. And this was largely how it ran. Now that we are clear with this, let us now understand what the judgments were. Very specifically, on the question on whether the Parliament was competent or not. The Supreme Court clearly held that the Adhar Act was constitutionally valid. There was absolutely no problem with it. And the Adhar Act had no constitutional impropriety of any kind. That's the first question that has been answered. Second, it also ruled that the Act was empowering the disadvantaged sections of society by giving them access to fundamental benefits, to fundamental entitlements, such as your state subsidies. And therefore, the Act was essentially trying to improve the benefit delivery system. So there's nothing wrong with it. 2, and this was the questionable part, the objectionable part, or the critical part, or the not so white in the black-white area of the Supreme Court, where the court said the Act was competently passed by the Parliament. Whether it should have been a financial bill because money is going to be involved and because you're going to set up a registry and you're setting up UIDI and it's about welfare benefits. We understand all of that. But if the speaker has decided it is a money bill, it is a money bill. We have no business to get into it. So even though it was passed as a money bill, there's nothing wrong. The Parliament was absolutely competent to do this in its own right. Third, it also held that the Adhar Act did not violate the principles or the articles of 14, 15, 19, and 21, primarily 21. So there was no violation of fundamental rights as well. The rights that we looked into were 14, 15, 19, and 21. Later on, a review petition was also filed by Shanta Sinha, which did not flow a very high. But all of this then led to a larger question on the right to privacy, which was looked at by a 9-judge bench. And that 9-judge bench of the Supreme Court now gets into the larger question of whether this is privacy or not. Now let's understand the arguments that were being made. Some of the finest judges the country has ever seen sat on this bench. At that time, of course, Justice J.S. Kedar was the former Chief Justice of India. The former Chief Justice of India, J.S. Kedar, was heading the bench. You had Justice Chamleshwar, Bobde, Chandrachud, Abdul Nazir, Fali Nariman, F.S. Nariman, Agarwal, Sapre, and I think Kaul. The names of the judges are not important. Now let's understand what did the petitioners argue. Now you must understand by this time, it was not just Putto Swami. It now became a larger set of petitioners because people started bringing in, their points of view. They started attaching their objections to the Adhar Act. So now it was no longer just Justice Putto Swami. It was the Center for Civil Society, it was Matthew Thomas, it was Om Bhatkare, it was Shanta Sinha, there was another judge called Justice Bhai-Reddy, there was Rajiv Chandrasekhar, there was the Begar Foundation, there was the Swatantrata Foundation. All of them had sort of come together and were now actively pursuing this case before the 9-judge bench of the Supreme Court. Now, on the right to privacy question, which is the bigger question, which comes out of these 3 questions, which is the right to privacy. Now, the right to privacy question had a different set of arguments. The petitioners that were arguing, the people who had filed the case that were arguing, said the fact that you have no privacy safeguards for the biometric data that you're collecting, it in itself is a question on privacy. And while answering the previous questions, the court had already gotten into these agreements. Now, Kapil Sibal, who was actually arguing this case on behalf of Justice Putto, said, right to privacy is not merely the right to be left alone, but it is also about including one's own physical being, thoughts, interpersonal relationships, private communication, information, and data. So it is from here where surveillance and body privacy and everything else comes to life. And therefore, when you're looking at physical being, thoughts, orientation, interpersonal relationships, private communication, information, data, it is an intrinsic part of the right to life and personal liberty, which is guaranteed under Article 21 of the Constitution of India. Now, to this, the government argued that no doubt we understand right to privacy is important, but the Constitution nowhere explicitly mentions the right to privacy, and it was never an absolute right, and it could only be looked at from a very, very limited point of view. Of course, the bigger question becomes, why does it matter? It matters because this judgment leads to substantial developments with respect to self-determination, homosexuality, adultery, religion, marriage, freedom of choice, everything that you can think around. It's not just about digital rights, it's not just about welfare benefits. Prior to Putto Swami, right to privacy was never recognized as a fundamental right. Whether it was the MP Sharma case, which involved questions of police powers, whether it was the Karak Singh case, which was about state surveillance, and both of these, whether it was about self-incrimination or state surveillance, both of these cases did not recognize privacy as an absolute right. And in both of these instances, the court held that the invasion of an individual's privacy is not an infringement of, or not an infringement or a violation of fundamental rights. So the judgment of Putto Swami has emerged from a case which was challenging the constitutionality of collecting sensitive information, which gave specific focus to digital privacy. And the court then understood that we need to have a constitutional meaning to individual liberty in an interconnected world. That's what makes this judgment so special. So what did the court finally decide? What is important for us in the exam? That the sanctity of privacy lies in its functional relationship with dignity. So when we say we have a right to privacy is correlative to dignity, which of course finds origin in Article 21. And not only that, it is also inalienable to human existence. You cannot curtail it. It is something that human beings are born with. It's almost a natural right. It's almost a human right. And therefore, the bench then recognized the right to privacy to be a fundamental right under Article 21 of the Constitution. And then the court also said that it is the duty of the government, it's the duty of the state to protect the individual's right to privacy, to protect the individuality of an individual, and of course, directed the government to set up a robust regime and all of that. And if at all you are restricting privacy, it must be done in a lawful manner, in a reasonable manner. Now, this recognition of the right to privacy can go a very long way in a lot of other areas. And this recognition of right to privacy has tremendously helped in the Navteej Singh Johar case, wherein homosexuality was decriminalized. Now we're looking at granting homosexuality or people who are gay to be legally married to each other. This was also applied to Joseph Shine versus Union of India, which decriminalized adultery. And the decisions that the Supreme Court gave, both in Navteej Singh Johar and Joseph Shine, were because of the privacy judgment. So it therefore became a catalyst for a lot of the other things. And despite so many years, we still don't have a data protection bill. I don't know when it's going to be finally tabled in the parliament. We're going to have a new version, whatever the case might be. Until we have a data protection bill formally in the parliament, it is not relevant for us to get into the details of it. But frankly, this is enough for us to understand the importance of the right to privacy. Now that we understand the importance of it, now that we understand that this is how it's going to function, this is what it is meant by, we can now get into the implications of it. We don't have to worry about specific questions on whether Adhar is compulsory for X or Y or Z. It has been asked before. One does not have to waste our time on it. We just have to look at the larger issues that we are dealing with when it comes to right to privacy. So when we look at the implications of right to privacy, or now that privacy has become important, we should now look at the kinds of privacy that sort of exist before us. The first set of privacy that we refer to is called informational privacy. This is, of course, the most technologically related part. It is concerned with data protection, data encryption, data security, secrecy, anonymity, adherence to fair information. We'll come to all of that. The second is with respect to physical privacy, a person's being. The third that we refer to are the autonomy that people can take with respect to the decisions that they have to. Fourth, we refer to something called proprietary privacy. So there are essentially 4 forms of privacy. Now let us understand, what do these forms exist in today and what are we doing about it? When we refer to informational privacy in its simplest form, it refers to 1, data protection, for which we aren't doing anything about it at the moment. We've tried a data protection bill. It has been lapsed. We're looking at another one. Let us see when that happens. 2, we're also looking at something called the anonymity or the right to be forgotten. So anonymity plus the right to be forgotten. If you have the right to express, you have the right to be present online, you also have the right to be forgotten. Now, it becomes a very, very important case. Now, we have a case for this in 2021. It was called the X versus YouTube case. The X versus YouTube case of 2021 deals with the right to be forgotten, the only case that you really have to particularly know about. Now, in this case, very specifically, what happened? This person X, whose name has been officially withheld, was a well-known actor in the Indian television and film industry, more specifically in Bengali films. She was approached by a renowned Indian film producer, the Ram Gopal Film Studios, to film a web series, and was promised a lead role. On this basis, she participated in the creation of a web series demo or a trailer, which included explicit scenes of complete frontal nudity, which are also called sweet videos. Now, the project was, of course, later shelved, which means the series were never produced. Now, later what happened was, this person X discovered that the producer had uploaded these demo videos to his YouTube channel and website. She immediately reached out to the producer, requesting him to remove the videos. And he immediately complied and he removed them. But despite the removal of the content by the producer, and without the consent of this person X, several handful of people, including a list of some specific websites, had already uploaded the video everywhere else on the internet. And some of these websites were also pornographic websites. And these are also, some of them were added, they were edited, some of these basic videos were edited to add obscene, objectionable commentary, some vulgar dialogues, and so and so. So then these videos started circulating the internet, and the plaintiff then had to constantly face harassment by anonymous callers. Now this person X then applied anonymously to the court, asking the court to stop the publication of this, to stop the streaming of this in any form whatsoever. Now, the answer to this judgment was a very, very simple one. This was a Delhi High Court case, and this was because of right to privacy. The Delhi High Court held that the person has a right to privacy under Article 21, and if you have the right to express under Article 19, you have the right to participate in a cinematic form of expression under Article 19. You also have the right coexistent with Article 21, and you also have the right to be forgotten from the internet, to be completely deleted from the internet. This was a Delhi High Court judgment, which is why it does not get the kind of attention that it should, but it became an important judgment nonetheless. Anything more than this is particularly not relevant as far as an exam is concerned. So that is that. In addition to this, a minor case called Rout versus State of Orissa. I don't think this is a case that we have to get into a lot of details about, but this is also about the right to be forgotten. This is a case of Orissa in 2020, where a young man called Subhranshu Rout had visited his classmate. The name of the classmate was Rupali Amanta, and he raped her. Now, Rout warned Amanta not to disclose to the family or the police, or he would kill her, and he would release the clippings of the rape on social media. He later created a fake Facebook profile in her name and uploaded videos of the incident. After the police had intervened, he of course deleted the content on Facebook. And he was then, of course, charged with various offenses under the Indian Penal Code, including rape for 376, distribution of obscene content in 292, forgery because he created an account in someone's name called 465, forgery to harm reputation under 489, outraging a woman's modesty under 509. Apart from this, you also had IT-related offenses under the IT Act, so computer-related offenses under 66, identity theft under 66C, publishing obscenity under 67, publishing sexually explicit content under 67A. Now, all of this happened. You don't have to worry about the technical details of it. He, of course, then applied for bail in the High Court of Orissa, which is at Cuttack. Now, the High Court of Orissa, again, very clearly stressed that we need to have a legislative recognition for the right to be forgotten, and of course refused bail to the petitioner in that case. Now, we all know that we need to have legislative recognition, and Orissa High Court is saying so. It just reaffirms our belief, but that is the larger case. Now, apart from this, we also see surveillance to be an important ingredient of the right to privacy. Now, there is a reason I am particularly very careful about surveillance, is because it is controversial and it involves an act of the government, so it cannot be asked in the exam. The UPSC is never going to analyze surveillance in the context of right to privacy because it involves government action. Having said that, there have been a few issues around which surveillance has sort of come to light. The first issue is with the Pegasus issue, which was an Israeli software, which was alleged to be used by the permission of the government to look into the activities of several lawyers, activists, politicians, etc., etc., etc. Now, the case was heard by the Supreme Court, and the Supreme Court appointed a committee. We haven't seen any major progress on that front. So one of the elements of surveillance is the Pegasus case. Now, apart from this also, surveillance and privacy have always had a fair degree of contemporary relevance in India, especially when we looked at certain COVID apps wherein certain data had to be given, or any of the government apps for public health emergencies, or traveler, or the Arogya Setu app, and so on and so forth. So all of this has been a part of the privacy issue, because Arogya Setu's privacy policy was questioned, because you would essentially look at tracking user data and so on and so forth. So do we need to do this as far as the exam is concerned? No. We just need to know that there has been a Pegasus issue. There have been several government apps that we have questioned or have been questioned, such as the Arogya Setu Act and so on and so forth, with respect to, privacy and violating privacy and so on and so forth. So all of this, of course, leads to a larger question on what is more important, a public health emergency versus an individual privacy, and that's an ethics question. It is an example you can write in ethics, but the UPSC in paper 2 in polity is never going to ask you, do you think individual privacy over public health, what is important, simply because of how controversial this is, and we do not have any clarity on all of this. Apart from this, as we've discussed under Article 19 in the IT Rules Act, when we look at the new IT rules, will now can ask social media companies to disclose the originator of the originator of information, the originator of the first message that has been sent, which is also being questioned on grounds of privacy. But none of this has come to a legal conclusion. And because it has not come to a legal conclusion as far as, now as this time is concerned. So therefore, it does not really matter. If at all there are conclusions to this, I will add another lecture to this and cover this up. So that is that. Now, when we look at it from a physical point of view, we of course here look at it from a very, very bare essential, which is, say, seizures, or say unlawful seizures, or arbitrary state practices, or solitude, or ambush journalism, or any of those things. Now, we haven't really gotten into all of this. We have not come into any court judgments. No guidelines have been issued. For example, roadside sobriety testing. Physical is something very specific to the body, so it becomes very important. Then here we've seen absolutely no progress whatsoever. So let us see if it turns out to be something eventually. From a decisional point of view, we have seen a little bit of progress. We could have heard of issues of transgender rights, which in the Nalsa case have been recognized. So the Nalsa case is before Putto Swami. So now if we are able to give more protection and more empowerment to transgenders to make certain more specific decisions about who they are, why they are, and what they want to, this can happen because of the privacy judgment. As it is, transgenders are vulnerable sections, which will be covered in the vulnerable sections to social issues and social justice. In polity, paper 2, specifically with polity, it goes beyond the realm of the syllabus to teach you what transgenders are. If you don't know what they are, you can read about it. You can have a look at the website also. Second, you also look at LGBTQIA. Transgenders is a part of LGBTQIA, but specifically lesbian, gay, bisexual, transgenders, queer, intersex, asexual, plus. Now, Navdeep Singh Johar's case got it's a post-privacy case, so it got the power to make homosexuality no longer a criminalized offense. It decriminalized Section 377 because of this. Now, if we're looking at ensuring that people who are homosexuals are also able to marry, enter into a civil union, that could be looked at from a privacy point of view. Who a person wants to get married to is a matter of absolute privacy. Now, third, the larger issue of, let us say, marital rape, or, for example, relaxing certain abortion laws. These could also be implications of it. You just need to mention these two as a concept, but in your polity syllabus or in your entire UPSC syllabus, you don't need to know the details of marital rape or abortion unless they have been in the news 6 months before your mains exam. So if that is the case, we'll provide you appropriately. Now, apart from that, When you look at proprietary privacy, which is essentially identity theft, which is with respect to, say, financial data or personal data, or essentially identity theft, we still have a long way to go. Something came up a few years ago with respect to DNA profiling, but that again is something that has not taken into a lot of shape. The DNA profiling bill has been passed, and we're fine on that front. So this is how we are essentially running privacy as it is in the country. These are the implications on gender. Do we expect a specific question on gender and fundamental rights? No. Simply because the law only recognizes the dignity of genders. Apart from that, it is a more socialistic, a more scheme-driven, a more ecosystem benefit. So it's never just about the rights. That is why it will never come here. Similarly, when we look at, say, issues of marriage and abortion, these are larger issues of empowerment of women, not legally, not legal-centric issues per se. So that is why you will not see these questions in the polity section. But environment has a jurisprudential angle. Environment, for example, has an angle which requires you to understand the principles of environmental protection, polluters pay principle, cautionary principle, and so on and so forth. That is why the UPSC will ask you a question on environment. Will never ask you a question on LGBTQIA per se with respect to fundamental rights. It is a larger discussion. It is very important for us to know generally, but for polity paper 2, you don't have to. So this is the overall ecosystem. We don't need anything more than this. From an international point of view, we've thankfully had the GDPR in the European Union, which is a guiding light on how privacy regulations should be. The UDHR, the Universal Declaration of Human Rights, which goes back to the mid-90s, also recognizes the right to privacy. So, of course, there are some keys that we can take inspiration from, why are they important, and so on and so forth. But anything beyond that is particularly not relevant as far as the exam is concerned. So, when we started out our discussion on right to privacy, we understood the evolution, the judgment, the implications, a broad understanding of the thematic implementation of the right to privacy. Anything more than this, whether it is the IT rules, I'm saying this again and again because now the tougher parts of polity are over. Now we have to start holding back. Up until now, up until 21, we had to be outward looking. Now we have to be inward looking. We have to start saying no to topics for us to know this is exactly what needs to be done as far as the exam is concerned. So this now closes your larger discussion of privacy as far as Article 21 is concerned, right? So that is that. Thank you. We now move to environmental jurisprudence under fundamental rights. Hello and welcome to lecture number 7D of topic number 7, life and liberties. And in this particular topic, we're going to be referring to environment's correlation, or how preamble, rights, directive principles, and duties have an intersection in the way we look at environment. Now, to begin with, we must understand that this is going to be an extremely exhaustive lecture. And to curtail the circumference of this lecture, we'll have to take certain judgment calls. Those judgment calls can only be taken if we look at previous year questions that have been asked pertaining to environment in the prelims and the mains exam. So if you look at the prelims exam in the last 10 years, there has only been one question with respect to environment in the year 2012, wherein the question was the right to environment and certain statement with respect to the National Green Tribunal. This question could have been very easily answered because it was a self-explanatory question. It essentially had certain provisions, procedural provisions with respect to the National Green Tribunal, which you could have eliminated if you generally understood how tribunals function. So keep that in mind. As far as the means is concerned, there have been several instances where questions based on environment or a specific development in environment policy has been the focus of the mains exam. in the year 2015, due to an important contemporary development of the Supreme Court banning crackers during Diwali, there was a question with respect to the same. Does the right to clean environment entail legal regulation on burning crackers during Diwali? Now, this question has to be discussed in the light of Article 21 of the Indian Constitution and the judgments of the Apex Court in this regard. Now, this question not only is about the right to environment, which has been derived out of Article 21, it also has an intersection of the right to environment with the right to freedom of trade, which is essentially the manufacturing of crackers. So there seems to be a conflict which also has to be addressed in this particular question. Now, when we look at a question in 2021 with respect to constitutional morality, which says it is rooted in Constitution itself and is founded on essential facets. Now, we haven't particularly applied constitutional morality to environment, but the Constitution has provisions with respect to environment, and they could be applied to environmental questions, to environmental issues from a constitutional morality perspective. We've of course looked at what the Constitution tells us about the environment, but it has not taken the shape of constitutional morality yet. But in a question like this, in the way forward, you could write that the principles of constitutional morality would also be used to answer questions, to address questions with respect to the environment. Then in 2022, there was the most brilliant question with respect to the environment. The most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court, wherein you're essentially being asked a combination of the Constitution and the Supreme Court as to pay the way forward to look at a better way to address environmental concerns. Now, when we look at these questions, what do we understand? We understand that environmental policy in general is an extremely exhaustive subject in itself. And through our UPSC syllabus, it gets used in multiple places, whether it is the core subject of environment or disaster management or even ethics from an essay perspective. It also has a very strong presence in social issues and vulnerable sections also, because environmental factors play a very strong role in the placement of certain communities, in the placement of certain people within a society. So we've got to keep that in mind. So before we begin and we understand what exactly do we need to study in this lecture, let us first draw what is called an overall mind map. You see, what ends up happening here is when we look at environment as a whole, when we look at environment as a larger concept, what do we understand out of it? Environmental policy will consist of 4 major pillars. The first pillar is what the Constitution refers to with respect to environment. The second is what are the kind of laws that we have for environmental protection. The third is what are the organizations, the agencies that we have to enforce environmental protection. Now, some of these agencies, as we would understand them to be, some of them may be backed by law and could be called statutory bodies, and some of them may not be backed by law. They may be backed by an executive order, so they're called non-statutory bodies. And fourth, of course, is the role of the courts. Now, within the role of the courts, we understand that there is the formal integrated independent judicial system, the Supreme Court and the High Court, which plays a certain role. And then we also have established something called the National Green Tribunal. Now, what is the difference between what the Supreme Court and the High Court does and what the National Green Tribunal do? See, the Supreme Court and the High Court interpret rights pertaining to the environment arising out of Article 21. They also give you environmental legal doctrines, environmental principles, environmental theories that have to be applied to real cases. And the National Green Tribunal very specifically looks at specific issues in the environment and gives specific orders to implement those issues. That's the basic sort of difference that has happened. Now, to reiterate this, the Supreme Court and the High Courts, they look at interpretation, they look at certain doctrines, and they may also look at specific issues. But the National Green Tribunal primarily focuses on issues such as pollution of a specific river, issues with environmental clearances and impact assessments, the usage of diesel and therefore its impact on vehicular air pollution, and so on and so forth. See, the NGT in itself has certain efficiencies issues that we discussed when we discussed tribunals. NGT in itself, by being a tribunal, is also a question on separation of powers. And the NGT has also been given suo motu powers, which in itself is a larger issue of the way the judiciary functions. But none of these things are the focus of what we are here studying in this lecture. So when we study environmental jurisprudence, when we study environmental policy, when we study environmental rights issues, when we study environment's intersection, we primarily look at the Constitution and how the courts have essentially interpreted the Constitution. This leads to the constitutionalization of environment. Now, the constitutionalization would have been done by the amendments to the Constitution also, and mostly with respect to what is called your courts through their judgments. Now, the laws and the organizations, the Central Pollution Control Board, etc., they play an enforcement sort of a role. And when we do environmental governance in governance, we cover the laws and the agencies also. But we are here looking at it from a completely jurisprudential angle. A jurisprudential angle is an angle wherein you're understanding the evolution of environmental jurisprudence, that how are we looking at the integration of environment. Now, in our Constitution, there are essentially three different ways where we look at environmental rights or environmental protection. The first set of ways that our Constitution looks into are the Preamble, the fundamental rights, directive principles, and fundamental duties. Now, how does the Preamble look into the issue of environment? The Preamble contains two words. One, dignity of an individual, and two, socialism. When we talk about the dignity of an individual, we talk about living with dignity. And living with dignity also means living in a healthy way. And if the environment that you are in is compromising the dignity with which you live, then your dignity as an individual is compromised, thereby questioning the very ideas and the vision that has been set out by the Preamble. To give you a practical example, if there are people who are forced to live near open gutters and sewers, making them subject to not only diseases, but a very, very unpleasant way of life, that in itself is, of course, a question on dignity. And when we add socialism to dignity in the Preamble, what do we understand? We understand that it is the government's responsibility to be the mainframe, to be the spinal cord, to be the flag bearer, the torch bearer for environmental protection. So when we look at it from a preambular point of view, we understand that it is essentially to do with dignity, and it has something to do with socialism. Just this much is more than enough to set context in your answers. Now, let's spend some time on understanding fundamental rights. See, first things first, explicitly in the text of the Constitution, we do not have the right to environment. The right to environment has been evolved to be a right by the judgments and by the actions of the Supreme Court, like how it happened in the case of privacy. The word privacy does not find any mention anywhere in the Constitution, but the Supreme Court identifies privacy to be an essential component of life and mostly liberty. So similarly, when we look at environment, the role of the Supreme Court with evolving environmental rights and the role of the Supreme Court with evolving privacy is quite similar, yet quite different. How is it similar? The onus of the courts has been more, and the courts have played a larger role in both these cases. One could say that if it weren't for the Supreme Court, then neither the right to privacy nor the right to environment today would have been identified as implied fundamental rights. This is the first and the most important part. Second, in both of these cases, the Supreme Court has sort of played an evolutionary role. But the difference is, with respect to privacy, the Supreme Court generally held a very conservative stand up until very recently, until the Putto Swami judgment. But with respect to environmental rights, we have seen a constant increment in the way the Supreme Court has addressed environmental rights to be included in our constitutional discourse. Third, how privacy also has an intersection with Article 19 and Article 14, as we'd understood. For example, privacy is a question of liberty, and surveillance can lead to the loss of journalistic integrity, which is an issue of Article 19. And treating people differently on the basis of who needs to be placed under surveillance and who doesn't is also a question of Article 14. So what do we understand? We understand that privacy also has intersections to 19, 21, and 14, 19, and 21. So does the right to environment. So for example, if the courts are banning a certain activity, or the parliament is banning a certain occupation to save the environment, it is fundamentally altering the right of a person to continue in that occupation. And the fact that you're treating that occupation differently than other occupations could be an issue of Article 14. So, like privacy, environment also has a multi-rights approach, 14, 19, and 21. And like privacy, the epicenter for environment is Article 21. And that's the basic set of understanding with the way the Constitution deals with the rights pertaining to environment. Now, when we study this, we will study two things. One, we will understand the implied rights. And second, we will understand the application of these implied rights. Then when we look at directive principles, Articles 47, 48, and 48A, they have essentially been the backbone in the directive principles department, clearly instructing the government of the day to take all necessary action. Now, let us quickly look at what Articles 47, 48, and 48A are. They're actually fairly simple. Article 47, in its essence, says the duty of the state to raise the level of nutrition and the standard of living and to improve public health. Public health is largely dependent on environment, right? For example, if we are saying that in a given society, in a given community, there is a very high degree of airborne or waterborne diseases, that also has a lot to do with air pollution or water pollution in and around it. So if you want to improve public health, you will have to improve the state of the environment as we understand it to be. So that becomes our first intersection. Then comes Article 48. Article 48 deals with organization of agriculture and animal husbandry. Now, agriculture and animal husbandry could have a negative impact on the environment if sustainable methods are not used. So to modernize and to use scientific techniques to upgrade agriculture and animal husbandry is also a very strong way to upgrade the impact of what it can have on the environment. And then comes Article 48A, the protection and improvement of environment and safeguarding of forests and wildlife. This is a clear, direct, explicit addition, which is the government of the day, the institutions of the state of the day have to necessarily make efforts to make the environment better. So these will also play a very strong role in the kind of laws and the kind of policies that the government is going to make. The courts have also understood these directive principles, have referred to them. But we know that directive principles are not legally enforceable in a court of law. So the courts have never been bound by directive principles, but they have used directive principles. And through this, as a subsidiary argument, as an additional argument, have evolved the larger rights around environment. Then, when we look at fundamental rights, we understand fundamental duties. We understand Article 51AG to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. This is to also place an onus of responsibility for citizens not only to take individual actions, community actions, because environment can never be the sole responsibility of the state or any other stakeholder. Environment is always a collaborative sector. No matter how many Swachh Bharat Abhiyans, no matter how many cleanliness campaigns, no matter how many recycling dustbins we put on the streets, if people choose to litter on the road, they will choose to litter on the road. If people tend to throw garbage and rubbish in the rivers and lakes, no matter how expensive and how modern and how brilliant your lake cleaning and your river cleaning campaigns and programs might be, the people have to stop polluting the environment. That is the crux of it all. So with all of these, we understand that very interestingly, it is actually the application of what is called directive principles of state policy and, say, fundamental duties have both led to or have nudged the court in evolving what is of course called your environmental rights. Now, when we do talk about environmental rights, and we must, what is most important? What is important here is to understand that we're looking at two kinds of rights. One is that we're looking at setting up several implied fundamental rights. It starts with the right to environment. Then it moves into a lot of other areas, maybe just out of 21, but sometimes also out of 14 and 19. Second is when you look at specific instances which may violate a right to environment. For example, issues with noise pollution. Noise pollution is an element of environmental pollution because of, say, playing loudspeakers. So if the courts are hearing a case and then they say that, all right, you cannot have loudspeakers after 10 p.m., that's also having an environmental angle to it. So there are, in fact, a lot of decisions that are actually taken. Nothing to do with the courts and constitution at the moment. But if you think about it, and if you think about it carefully and closely enough, you would understand in a very simple manner that, for example, we are right now in the EV phase. That in itself is a problem to begin with, right? Because we have a lot of roadblocks ahead. We really need to get to them, but we still don't have it. The whole idea of electric vehicles has an environmental angle to begin with. Of course, there are issues with the kind of batteries they use, but that's something that your automobile, your infrastructure topics and chapters should cover for you. The second pillar of the Constitution is with Schedules 5, Schedule 6, and certain special states that are identified from Article 371 onwards. The reasons for identifying Schedule 5, Schedule 6, or special states is to also protect the natural habitat of certain indigenous communities who are dependent on the ecological habitat for their survival because of how environmentally or ecologically sensitive they are. So there is also an environmental angle on that front. And thirdly, through local self-government, the 73rd Amendment, through the Constitution, and of course, the states would have supplemented the same with certain more specific programs. The local panchayats, the local bodies have been empowered to take measures, to take actions on soil preservation, on water management, on forestry, on protection and promotion of the environment and ecology in general. So therefore, we are able to understand this in the context of it all. And therefore, this becomes a primary focus of what we're going to be studying today. Now, the Constitution becomes the backbone. The courts will now use constitutional provisions and more specifically provisions with respect to preamble, fundamental rights, directive principles, and duties, and will therefore then create what is called environmental jurisprudence. Just wanted to set some context to this. All of this happens, and a major factor in the way we started to look at environment in our country is because of the Stockholm Convention or the Stockholm Conference of 1974. The Stockholm Convention of 1974 really kickstarted and catalyzed the way nations all across the world looked at environment. In fact, the amendment of Article 48A was made 2 years after the Stockholm Convention because the government was, of course, inspired and was, of course, supposed to add it in a way that it had some symbolic value. So one could say that the Stockholm Convention is the Universal Declaration of Human Rights equivalent of environment. Now, to get a more introductory context, right, and then we'll move to our primary discussions, is that one, immediately after post-independence, we did not have a major focus. We were not very centric on environmental policy. And the major turning point was, of course, the Bhopal gas tragedy, which as a nation we have failed and we still continue to regret. The reason up until, say, the third or the fourth 5-year plan, we were not focusing on environment at all is because we had larger industrial concerns to worry about. We needed to set up heavy and basic industries. We needed to have markets. We needed to have a robust economic system. And this is a classic ethical conflict between sustainability and growth, because high growth may not necessarily be environmentally sustainable. Now, as I was telling you, the 74 Stockholm Convention has played a remarkable role in shaping our policies. For example, the insertion of our Directive Principle 48A. And the next sort of context we need to have is that the courts have then evolved to interpret Article 21 to include the right to a healthy environment. So what is it that we're going to do now? We have to study two specific portions. One, we have to understand the evolution of environmental rights. And second, we have to understand the evolution of environmental principles as set out by the court. How Kesavananda Bharati is the soul of amendment to the Constitution and basic structure. The MC Mehta case is the Kesavananda Bharati of environmental law. So we will see that this case will have an impact on environmental rights and also will have an impact on certain environmental principles. So let us first start by understanding some of our basic environmental rights as they're important. When we do talk about the fundamental rights pertaining to the environment, or where do they come from, we will have to do them in a very simple manner. And then we'll, of course, move to the doctrines that are evolved by the courts. Our first topic, therefore, becomes the evolution of rights pertaining to the environment. We understand that Part 3 of the Constitution provides 6 fundamental rights ranging from Article 12 to 35 that are essentially essential to develop the overall personality of every individual and preserving human dignity. These rights, as we understand under fundamental rights, are justiciable in nature, and they, of course, allow every person, whoever the right is available for, to directly approach the Supreme Court or the High Court to essentially make certain challenges over environmental concerns. But the epicenter of all of this is always going to be Article 21, wherein we're looking at the right to life and to live in a healthy environment. So, the right to life, and from here, the right to live in a healthy environment. So the right to live in a healthy environment comes from the right to life component of Article 21. Now let's understand this. The article explicitly does not mention environment as a part of protection of life and personal liberty. But by different case laws decided by different courts in the country, we have seen that there's a very wide interpretation of Article 21, which is included, of course, through the courts. The most important case with respect to this is the Rural Litigation and Environment Kendra Dehradun versus the state of UP, 1985. It's a very important case and has to be known under all circumstances. Why is this case important? Why does it make a lot of difference? See, you must understand, this case is when we essentially set out the identification of the right to environment. The right to live in a healthy environment as a part of Article 21 was recognized for the first time in the case of Rural Litigation Kendra versus State of UP. No doubt about it. And this becomes the beginning of environmental jurisprudence. This case is popularly called the Dehradun Quarrying Case, which I will tell you as to why is it called the Dehradun Quarrying Case. In the exam, you can also call it the Dehradun Quarrying Case, and that's not a problem because it will have a lot of resemblance in case you cannot remember the full name, but popularly called the Dehradun Quarrying Case. It is the first case of its kind in India involving issues relating to environmental and ecological balance, in which the Supreme Court directed to stop illegal mining under the Environmental Protection Act of 1986. See, we have several laws with respect to the environment. The Water Prevention Air Control Act 1974, the Air Prevention of Pollution Act 1971, then the Environmental Protection Act of 1986, the Forest Dwellers Act. There are several laws. That exist in the country, the Air Act of 1981, and so on and so forth. The courts have used these laws applied them to fundamental rights, and then made a decision to not allow something. That is the beauty of it, which is why I wanted to bring you back to the laws. These have to be done in data proprietary when you study environment policy as a part of environment or environmental governance. But we're talking about the Dehradun quarrying case. So in the Dehradun quarrying case, you essentially stopped illegal mining. That becomes very, very important as a identifying factor. Now, these unauthorized operation of limestone quarries in the Mussoorie Hill Range had caused a hazardous effect on the healthy environment along, and it also was affecting the perennial water springs that existed in Mussoorie at that time. So the Supreme Court, when it was deciding on the writ petition that was filed before it, it highlighted the importance of maintaining a proper balance between economic development and ecological protection. And the court observed that any kind of development or any kind of infrastructural growth that takes place by destroying the environment, the lives of the people residing around the area, should always be considered as a problematic area. So that's the first part that becomes important. This is an important case. Now, the second case is a case of 1996. We'll come to MC Mehta also, because MC Mehta also has rights and environmental principles or doctrines. The second case that we refer to is the case called the Indian Council for Enviro Legal Action versus Union of India. So the case is Indian Council for Enviro Legal Action versus Union of India of 1996. Now, this is a case which emanates out of Rajasthan. In this case, the court looked into the conditions of the Bichri village in the Udaipur district of Rajasthan, and the facts are not important. It was in such a bad shape because of several chemical plants which were there in the Bichri village in the Udaipur district. Chemicals like the H acid, sulfuric acid, oleum and all were all in the chemical plant which was around. It was the untreated sort of toxic water that led to massive groundwater pollution, contaminating the soil and making it absolutely unfit for the purpose of cultivation. In this particular case, the Supreme Court also looked at the Environment Protection Act of 1986, which is one of the laws which was existing by that time, which provides that the government must take necessary measures to protect the environment, I think under Section 3 and 5 of the Environment Protection Act. And because of this, the court then ordered the government to adopt all necessary steps to treat chemical industries separately from other industries, give a very clear update and supervision from very close quarters, and ensure that they don't pollute or harm the environment. The court also further suggested setting up of environmental courts to ensure, say, specific attention to environmental matters or to provide justice to the aggrieved party. So this could also be looked at as the birthplace of why the National Green Tribunals would make sense eventually, though they've been there. So it suggested the setting up of special courts and a special treatment of chemical plants, both of which are affecting the right to live in a healthy environment. Right? Now, apart from them, there are also certain implications with respect to Article 19, the major ones. Let's understand with respect to Article 19, where is the conflict, where is the problem, and how do we solve it? Article 19 refers to the freedom of speech and expression. Article 19, Clause 1, Clause A refers to speech and expression of any kind, and it is only for the citizens of India. How is this freedom associated with environmental matters can be understood through a case of 1999. That case is called the Maulana Mufti Sayyid Ahmad versus the state of Bengal. So it's a long case, but I'll still tell you what it is. You don't have to remember the whole name. Just a little bit is fine. And it's not even a Supreme Court case, but it's an important case. Maulana Mufti Sayyid and others versus the state of West Bengal, 1999. See, this is actually a noise pollution case. Understand what it is. Maulana Mufti Sayyid and Muhammad Noor Rahman Barkati, if I remember the names of the petitioners right, had prayed before the Calcutta High Court to not apply the environmental protection rules under the Environmental Protection Act at the time of the call of the Azan, saying that it would violate 14 and 25. Azan, of course, is a Muslim prayer which is being spoken at, which is delivered at a certain time during the day. In taking into account the secularism angle and the equality angle, that why should Azans only be stopped? Why couldn't it be anything else? And this has been an issue even today. The High Court observed that the using of loudspeakers or microphones cannot be considered as an integral part of the Azan prayer because noise leads to noise pollution. See, with a firm view that no one can claim absolute right by suspending someone else's right, the court held that, okay, microphones in itself are major sources of noise pollution, which in itself is a violation of Article 19, Clause 1, Clause A, and therefore it makes it a little difficult for captive listeners and non-captive listeners. And of course, this petition was then dismissed by the Calcutta High Court. So you must understand that the relationship Article 19 has with the environment essentially has a negative relationship, because right to environment can have a restrictive application of Article 19. This could also be true in the case of, let us say, firecrackers. When the Supreme Court bans it, it affects the people who are in the firecracker business. So this is essentially, of course, with respect to Article 19. Now, apart from this, there is, of course, an implication of Article 14 as well. There's a very important one of it. Now, let us look at Article 14 from a jurisprudential angle. This has to be done in minimal detail because this can get a little too technical and we don't have to get into it too much. So let us now look at it from an Article 14 right to equality perspective. Then we will, of course, look at certain specific environmental rights that have been evolved. So Article 14 of the Indian Constitution, as we know, guarantees right to equality to anyone and everyone in the country, irrespective of whether they're a citizen or not. The application of Article 14 to environmental jurisprudence is actually a very, very narrow one. And there is probably one case that we should know, and let's understand what that case is. The case is called the Sushila Sawmill versus State of Orissa in 1995. Sushila Sawmill versus the State of Orissa of 1995. Now, even for the mains, I'm only giving you that much information that you need to write. Anything more than that is not necessarily essentially required. So what is this case about? The Orissa Sawmills and Sawpits Act of 1991. There's a law called this. was enacted to regulate the establishment and the operation of sawmills, sawpits, and the trade of sawing to protect and conserve forest and environment and all related matters. The case of Sushila sawmill in state of Orissa surrounds this legislation as it appears before the Supreme Court because of a very simple reason. It is treating one particular kind of an industry very differently. The general argument was that the Sushila sawmill, which belonged to a certain private individual, was shut down with immediate effect because it was appearing to destroy the forest areas in and around it within a reasonable location of it. The Sushila sawmill representatives very clearly contended before the court, saying that the legislation, the Sawmills Act, does not impose a complete ban on mills. And if you're using that law to ban a bill to ban a mill entirely, you're violating my rights to work, and more importantly, you're treating me differently. The Orissa sawmill says you should be regulating them, operating them. You could restrict a few parts with the way sawmills function, but to completely ban something is a problem because it's also a violation of the fundamental right to carry on trade and business. And of course, treating this petitioner's mill differently from all other mills is a violation of Article 14 because it was a government order. Now, the observations that were made by the Supreme Court while dismissing this, while saying none of this makes sense, and the Supreme Court upheld the order of banning the sawmill entirely, was that forest preservation is a matter of public interest. And it would also be a rare case if a complete ban is being proposed by the legislature. The purpose of this Act of 1991 was to impose a complete ban on sawing operations within the prohibited areas. So the legislation is very clear with its intention because that intention comes from public interest. So you have no ground. Second, the court looked into the Sushila mill and said, you're in the prohibited area. Therefore, you come under the legislative mandate of the Sawmill Act, and therefore you would be considered as a class separate from all other classes because you're in a prohibited area with very clear proximity to forest areas. So therefore, you again don't have a chance. So again, Article 14 in itself may have a positive, but mostly has a negative relation with respect to environment because of the actions that are taken. So 14, 19 and 21 is largely how all of this runs with respect to primary fundamental rights. Now, apart from this, there have also been several other cases, there have been several other issues that have happened where we've looked at, say, the right to livelihood, which is also nothing but an extension of, say, Article 19 and so on and so forth. Now that we've understood this in its entirety, understanding how it works, let us get into the next stage of it all. Identifying the doctrines and the principles that have been identified and evolved by the courts of our country. When we look at the doctrines of environmental protection, or we look at the principles of environmental protection, this ultimately is an exhaustive role of the judiciary. Let's understand this. Our next topic, therefore, becomes environmental doctrines or principles evolved by the judiciary. See, the first part that we need to understand is public interest litigations have been the primary factor for the judiciary to understand to evolve, and to come up with certain principles that have been groundbreaking. Now, public interest litigations in itself is an issue that we have to discuss in the way the courts function and whether they're right, are they wrong, are they frivolous, are they not, do they burden, do they not burden, are they legitimate, and so on and so forth. But public interest litigations have played a very important role in evolving environmental principles. That in itself is non-negotiable. In fact, PILs have proven to be game changers in the field of environmental law. It has expanded the horizon of social justice, I'd like to call it. It has encouraged individuals, NGOs, organizations which have been affected by a particular activity, everything. And there are a large number of Supreme Court sort of created environmental principles that become important. Now, the judgments through which these principles have come out are many. For example, the 1980 case of the Municipal Council Ratlam versus Varicha. No, that case is not important. But in this case, we looked at the right to environment also includes the right to a wholesome environment. So just very small interpretations, and then we look at principles. So for example, in the Ratlam, Municipal Council Ratlam case, you don't need to know the whole name, 1980, the right to wholesome environment was also identified to be a part of right to life. This essentially was one of the first cases where the ambit of environmental protection was expanded. In this case, if I remember the facts correctly, was filed by the residents of the municipality of Ratlam, that the Ratlam municipality is not constructing proper drains, resulting in stench and stink caused by human excretion in and around. And it therefore acknowledges the effects of poor deteriorating environment and therefore compel the judiciary to compel the municipality to build better sanitation facilities. Second, we've already discussed this case, the rural litigation case of 989, wherein you wanted to stop limestone quarrying. This, of course, reflected the right to live in a healthy environment. And then, when we look at, say, specifically the right to air or the right to water, there have been several cases also. So, for example, F.K. Hussain versus Union of India in 1990. In this, we've looked at the right to health to be a part of right to life, and the right to clean water and air are a right to health. So in that way, the right to clean water plus air. So these become our primary set of principles. Now, let's look at the doctrines that we're talking about, the system, the pillars that we're creating. Very important, we start with the first one. The first pillar is intergenerational equity. This principle has been established by the Supreme Court. According to this principle, the state is obliged to conserve and use environment and its natural resources for the benefit of the present as well as the future generations, very similar to sustainable development. It states that every generation holds the earth in a common manner, and therefore it should be used for the benefits of all generations. This intergenerational equity is the principal foundation of what is called sustainable development. The right to a clean environment is not only an individual right, It is also a collective right available to individuals, people, society, communities in the present and future generations equally. So the principle of intergenerational equity becomes very, very important. This is under the G. Sundarajan case versus Union of India in 2013. Now, see, just to give you a closing statement. Supreme Court in the intergenerational equity case said that sustainable development and corporate social responsibility are inseparable twins, by the way. The reason you want companies to spend a portion of their profits on spending it to make society better and running businesses in a way that they are sustainable over a longer time without damaging the environment too much is nothing but the principle of intergenerational equity, which not only, in my opinion, is human-centric, it's also eco-centric, right? Now, the second one, the polluter pays principle. Very popular case, but we should know it. Polluter pays. This has been used massively. This principle was first actually introduced in the year 1972 by the Organization of Economic Cooperation and Development. And this has sort of been a standard environmental policy for many, many years and generations to come. It states that the polluter should bear the cost of damage caused by it to the natural environment. Very simple. And this particular principle was done through a case called the Vellore Citizens Forum Limited, Vellore Citizens Forum versus Union of India in 1996. The facts of the case are not important, it will burden your memory unnecessary, but it is an important case, which is Vellore Citizens Forum versus Union of India, 1996. So it's Vellore Citizens Welfare Forum, but I think this is more than enough for you to write in the exam. Case is, it's very simple. Third is the precautionary principle. When we look at the precautionary principle, what does it mean? The precautionary principle, I think, was adopted in the Rio Declaration of 1992. It's one of the 15, I think it's the 15th principle of the Rio Declaration of 1992. It states that even if there is no scientific evidence, measures must always be taken to anticipate and prevent the causes of environmental degradation. So even if there are certain parts of the world who don't believe that the polar ice caps are melting, who believe that climate change is not real, you will still prepare for climate change even if you don't think climate change is real. It makes it the social responsibility of the state to protect the public from any plausible risk whatsoever. It is the responsibility of the government to take any action necessary, however possible it might be, to do this in a certain way. And this was done through the AP Pollution Control Board versus Naidu in 1999. You may not remember it, but you should just know the principle. The Andhra Pradesh Pollution Control Board versus Naidu in 1999. The fourth principle, the public trust doctrine. This doctrine is the essence of it all, the MC Mehta case. See, the public trust doctrine, as we understand it to be, states that resources like water, air, sea, and forest have a great importance to the general public, and it would be unjustified to make it the subject of private ownership. It poses a massive duty on the state to protect such resources for the benefit of all and not to the permit of any commercial use of it. Very simply put, that the government has to protect the resources that are available in a way that it is publicly used. The public trust doctrine is air, sea, water, forest, for example, are public goods. So even there is a commercialization of water, it cannot be against the public consumption. You cannot make drinking water so compulsory and so expensive that the average person cannot drink clean drinking water. The public trust doctrine puts environment as a public good. And good environment must be available for everybody, and everybody should protect good environment. And the public at large is the beneficiary of it. The state is the trustee under whose legal duty you have to protect it and take care of all of these resources. And this is the MC Mehta case. The MC Mehta versus Nath in 1997. Now, let's understand very broadly what this case is about, and then we'll, of course, get into the details of it. See, in the MC Mehta case, what had essentially happened was an attempt was made to divert the flow of a river to support commercial activities of a motel or a hotel or a motel. It was then held that the government is the trustee of all natural resources, and this cannot be done to, and this cannot be permitted for commercial purposes. So that is something that happened. Now you must understand, MC Mehta versus Nath of 1997 and MC Mehta versus Union of India of 1986 are two completely different cases. So this case, which becomes a bedrock of public trust doctrine, is not the original MC Mehta we're talking about. Remember, there are two MC Mehtas. One is the 1997 one, which is the public trust doctrine one. The other one is the MC Mehta versus Union of India, which is called the Shriram gas leak case, which I'm going to come to. Fifth, the last principle is the sustainable development principle, which flows from the intergenerational equity principle. When we look at the sustainable development principle, it was, of course, first introduced in the Stockholm Conference of 1972, and it largely held that the states should strike a balance between development and environment. In India, we very vehemently looked at that principle in a case called State of Himachal Pradesh versus Ganesh Wood Products. Now, what is this case about? I'll just tell you, but just we know the principle. It's not a big deal, but we must know that it is one of the principles which has been identified and defined by the Supreme Court of the country. State of Himachal Pradesh versus Ganesh Wood Products of 1995. In this case, the Supreme Court had invalidated a forest-based industry, recognizing the principle of intergenerational equity, saying that you cannot chop so much wood that there is no wood for the rest of the generations to come, which is why you will now see several kinds of wood are just not allowed to be cut for any purposes whatsoever. And that's important. Now, these are your principles, and only one part is left. The part is the MC Mehta versus Union of India case of 1986. That one case, if not discussed, then leaves environmental jurisprudence incomplete. So, MC Mehta versus Union of India of 1986, this is also popularly called the Shriram gas leak case. Now, this is a landmark judgment in the field of environmental activism. The Supreme Court, in this case, has tried to reinstate the faith of the public in the justice machinery And to rectify the mistake that was done a year ago in 1985 in the Bhopal gas tragedy case, where adequate measures and compensation was not taken care of. The facts are not important, but the facts help you understand and recall the case better. So, Shriram Food and Fertilizer Industry was a subsidiary of, was a sub organization under a larger organization called the Delhi Cloth Mills Limited. It was a privately owned company which was engaged in the manufacturing of caustic chlorine and oleum gas. MC Mehta was a lawyer and a social activist who filed a writ petition for the closure of the Shriram Food and Fertilizer Industry, as it was situated in a very densely populated area of Delhi. While the petition was still pending, the case was still going on, the end of 1985, around the 4th or the 5th of December, if I remember the dates right, because this was a major issue back in the day, a major leakage of petroleum gas happened from one of the units of the Shriram Food and Fertilizer Industry in the heart of the city of Delhi, which resulted in one death and several major health issues. Immediately, 2 orders were issued to shut down the plant in December itself under the Factories Act of 1948 by the Inspector of Factories. Shriram Industries responded to the writ petition saying that you have to take back those 2 orders and you should allow for the opening of its plant, at least its caustic chlorine manufacturing plant, which helps you manufacture glycerine, soap, hard oil, etc. Now, on behalf of the victims of the gas leak, the Delhi Legal Aid and Advice Board and the Delhi Bar Association, the Royal Association of the Delhi courts that we're all a part of, filed a compensation that the gas leak victims have to be given, along with the original petition of MC Mehta. MC Mehta had originally filed to get this shut down. Gas leak happens, industry gets shut down, industry says we should not be shut down, and parallelly, the organizations representing the victims of the gas leak say we also want compensation. So this was the facts of the case. Several issues were identified. First issue was, should you be allowed to restart your manufacturing of caustic chlorine and oleum, which is a health hazard, and it could be a violation of Article 21. Second, how do you measure the liability of an enterprise? Or how do you say this is what you're liable for if you're in the business of something which is inherently dangerous or is inherently detrimental to society? Third, if you are manufacturing chemicals which were of public interest, can Shriram Industry be a state under Article 12 to make it liable under 21, essentially? And fourth, can you claim compensation under Article 21 from Shriram Industries? So these 4 issues, I'll reiterate them for you, became the crux of it all. Anything more than this is not important. The first issue is, should they be allowed to restart operations of a health hazard product? 2, how does one measure the liability of it? 3, does it come under state because it is producing a chemical which is of public interest, so many people use it and the government is not doing it? And fourth, can compensation be claimed if they were considered to be the state? Now, the Supreme Court simply did not get into this, and we will not get into this. This is not our place to be in. It's not a matter of adjudication. They directed the organization representing the gas leak victims, to file a comprehensive action on behalf of all of those who have claimed to have suffered from this incident before an appropriate court, and then you can look at a compensation, but not a matter of the Supreme Court. It also stated that the amount of compensation should be equal to the magnitude of harm which is caused to society. It cannot be a ballpark figure, and should also be correlated to the capacity of the Shriram industry so as to have a deterrent effect, which is essentially a punishment work. Bigger the harm, more should be the compensation, and it should be hard hitting so that Shriram industry does not do this ever again. And while they allowed for the plant to open, they said, if you don't implement the implementations of the committees that have been set up, then we will shut you down. This judgment has proven to be very significant for environmental legal cases because it has produced several stances which are even celebrated today. The Supreme Court took a proactive role within 1 year to dispose the case and make sure fundamental rights are not violating by giving a wide connotation to what is called the right to life. The right to healthy environment also gets reiterated in the MC Mehta case. It was important for the court to actually address, after the Bhopal gas tragedy judgment, the UCC Kawait judgment, to reinstate that, okay, the judiciary is here to help you if there's an environmental disaster. And it was necessary to have such a strong, clear, crisp judgment so that people could be punished for their actions. See, the MC Mehta case in itself is a very, very important because it sets the tone right. It sets the way we would look at it. It treated the right to live in a pollution-free environment as a fundamental right. So the fact of the matter is, the right to live in a pollution-free environment is a fundamental right under Article 21. Now just imagine the impact of this, from diesel vehicles to odd even, to say stubble burning, to say promotion of EV and tax benefits. This is the crux of it all. And this has been the intersection of the courts and Part 3, Part 4 and Part 4A with respect to environmental rights jurisprudence. When we go back to our original mind map, the laws and the agencies, they have to be done separately. NGT in itself is a very specific tribunal issue, but the core principles, the larger issues that can be asked from this perspective, is a combination of these two. We now move to the relationship between Article 14, 19, and 21, the Mehta Gandhi case, and the discussion of the Holy Trinity of rights, which leads to the due process of law argument, the next lecture on due process of law. Thank you. Hello and welcome to lecture number 8 pertaining to topic 8. And in this topic, we're going to be covering, in my opinion, two of the most underrated philosophies and interlinkages of the study of the Constitution of India. We're going to be understanding the journey which sort of begins from procedure established by law to due process of law. This journey from procedure established by law to due process of law is in fact a journey which has largely been done because of the Supreme Court of the country. But this journey has only been possible because of the underlying relationship between Articles 14, 19, and 21. And the backbone of both of these topics, in one form or another, has been a rather surprising case of Mehta Gandhi versus Union of India in the 70s. So when we study topic number 8, and I must warn you beforehand, it is going to be a rather long lecture. We will, of course, through this case, through these topics, also study the Maneka Gandhi case. Now, I must also tell you beforehand that both of these topics have not been asked in the exam in the last 10 years. But given the evolution of the exam, where they've started asking questions like constitutional morality, both in the pre and the mains, constitutionalism, constitutional government, they've started asking questions comparing the notions of equality between India and the United States. It is only a matter of time, sooner or later, that you would have to be answering a question on due process of law and the interrelationship between Articles 14, 19, and 21. Now, this becomes the primary interrelationship, but there are also other combinations of fundamental rights which have assisted in this evolution of the due process in India. So without wasting any more time, let's get into the substantive part of this lecture. To begin with, we must remember one very simple element in mind, that the word due process does not find any mention in the Constitution of India. So if you're in your prelims exam, if you have been given a question, according to the Constitution, due process of law is under 14, 19, 21, and none of the above, the answer is going to be none of the above. Because the word due process of law does not find any mention in any article, in any text of the Constitution of India. It is something which has been created and integrated into the Indian ecosystem, primarily because of the actions of the Supreme Court. What is in fact mentioned in the Constitution is Article 21. And under Article 21, you will see it says, no person shall be deprived of his life or personal liberty except according to procedure established by law. So the journey is from procedure established by law to due process of law, which we will of course be paying adequate attention to. So we must remember at the very beginning that from a very textual point of view, this is where we are at the moment. Now, let us start by understanding the evolution of the due process of law. See, this may get slightly legal, and I can understand that this might seem a little heavy. But you must also understand that this is a very, very pertinent and a very probable question in the years to come, because of the nature of questions that the UPSC has been asking primarily in the mains exam. Now, let's start with a little bit of an introductory remark, because you may get a mains answer on it. You may even get an essay on it, given the fact that this is such a diverse topic. So when we start with our introductory remarks on this particular topic, let us first understand the context of it. Let us set the context of it. The context is the history of democratic countries, once studied, once understood, tells us something very simple, that all democratic countries, eventually in one way or another, are chasing the ultimate end of the realization of justice. Now, that justice could be political, economic, social, cultural. It could have as many manifestations as possible. But the fundamental premise is that realization of justice is the ultimate goal of democratic countries. Now, why is this important? Because it sets the context of what is going to follow. Now, obviously, the realization of justice would depend on the quality of the legal system. It would depend on the efficiency of the legal system, and there are no two doubts about it. And the quality of the legal system is fundamentally understood by how committed the legal system is to the broader principle of rule of law, the fairness of law, and its respect for human rights. Ladies and gentlemen, the Second World War has compelled the international community to think across the world in a very serious manner about the promotion and the protection and the implementation of human rights. Because human rights leads to fairness of law, leads to rule of law, and leads to ultimately the realization of justice. And it almost became universal in nature, as we understood from our UDHR times, that fundamental rights are therefore the cornerstone for the success of any democratic country in the world. India, being a democratic nation, has been committed to the rule of law, and it cannot be any indifferent to the promotion of human rights. You cannot say that we are committed to the rule of law and say that we may not have the same status, or we may not recognize human rights in the form of fundamental rights in the way that we should. In fact, the greatest heritage of democracy to mankind is the most primary element of personal liberty. The right to personal liberty is the greatest gift of democracy to mankind. You can see all other forms of rights available in all other forms of government. But what truly, from a rights perspective, makes a democratic country also desirable is the right to personal liberty. And there are no two doubts about it. The right to life and liberty is one of the most important rights amongst all human rights, because of the existence and the protection of life is the very precondition, is the absolute essentiality for the enjoyment of the rest of the rights. Your right to equality, your freedom of expression, your secularism, your exploitation protection, untouchability protection will not mean anything in the world if you do not have the right to personal liberty. It is ultimately your choice. And the importance of right to life and personal liberty can, in fact, in the Indian context, be measured that despite constitutional provisions providing for a system of a national emergency, a state emergency, the one fundamental right that cannot be violated under any circumstances is Article 21. You can temporarily suspend the enforcement of it during the period of the emergency. You can say that till the time the emergency is going on, the courts may not entertain fundamental rights matters. But if a fundamental right has been violated during an emergency, if Article 21 has been violated during an emergency, after the emergency is over, the courts will be allowed and will always get into the examination of it. That is the fine legal print. The fact of the matter is, for UPSC, generalization is very clear that the one right that cannot be violated, the one right that cannot be taken away under all circumstances, is the right to life and personal liberty, even during a constitutional crisis as that of an emergency. Now, it also then makes us understand from an international perspective, from a comparative constitutionalist perspective, as to the whole ecosystem of rights. Now that we're talking about procedure established by law, we're talking about the process of law, let's understand what is it that we're referring to. See, the Constitution of the United States of America very clearly and explicitly mentions due process of law in the text of their constitution. Whereas the Constitution of India 1950 does not have any familiarity with that expression. The 4th and the 15th Amendment to the US Constitution had inserted due process of law to the US Constitution. You may not want to remember this, but the 4th and the 15th Amendment to the US Constitution had done so. So even in the US Constitution, due process of law was not a part of the original text of the Constitution, but by the action of the US legislature, you were able to insert this in the Constitution through a constitutional amendment. Now, of course, due process of law has undoubtedly given great powers to the American judiciary, to the American legal system to understand disputes, to resolve disputes. And due process of law has truly empowered the American court system over the American central and state legislatures. Procedure established by law very simply means as long as the law has been passed in the right manner, the law is perfect. There's no problem with it. Due process of law, on the other hand, means irrespective of the law being passed in the right manner, is it being used for the right intention? Is it being used for the right reasons? Is it serving the purposes for which the law was passed? See, the judiciary in India still cannot get into legislative intention. They cannot get into whether the parliament had the right intention in place to pass a law. But once the law is being implemented, is it being implemented to ensure that the reason why it was being implemented is for the right reasons? So, for example, Section 66A of the IT Act, which was struck down in the Shreya Sehgal case, from a procedure established by law is incredibly perfect. There's nothing wrong with it. But from a due process of law is a problematic provision in the IT Act. Because Section 66A of the IT Act was inserted in the IT Act to prevent the spread of communal hatred. How it was being used by the governments of the day was to suppress dissent. So there was a mismatch of why you were implementing it and why did you have the law in the first place. It is almost like a self-introspective question that you worked so hard to clear this exam and you're doing something questionable in the course of your career. And you have that introspective question, is this why I got into the civil services in the first place? That in a way is a very bare-bone application of what is called due process of law. Now, the makers of the Indian Constitution, the Constituent Assembly of India, deliberately, and we will get into the Constituent Assembly debates also, deliberately did not insert due process of law. And despite this, the Supreme Court through Articles 14 and 21 have tried to integrate due process in India through multiple judgments, ultimately our star judgment being the Mehta case. So, does India have due process of law as a principle for the courts to examine certain actions? Yes, they do. Is it explicitly mentioned in the Constitution? No. It is derived from Articles 14 and 21, and then, of course, other combinations such as 14, 19, 21, and so on and so forth. So the Indian judiciary has acquired a vast power to supervise or invalidate any state action, whether it's the central action or the state action, by any public authority, to be arbitrary, to be unreasonable, and the courts can simply strike that down because of due process of law. And the process of this realization of justice, that the courts are saying you are implementing this law for the reasons which are wrong from the reasons you passed this law in the first place. Your heart is not in the right place in the way you're implementing it. You're abusing the powers, let us say, in sedition, for example, if it comes out later in a court. And this process is ultimately towards the realization of justice. The government is making a law, or a public authority or a government body is taking an action which is arbitrary and unreasonable because it is unjust. And therefore, the courts over a period of time have sort of transformed the crude, the plain, the basic procedure of law into a refined and a civilized ecosystem, which is due process of law. And due process of law indeed has sort of strengthened the procedure of law or procedure established by law by making procedure established by law also within the larger ecosystem of due process of law. So when we look at equality and fairness as principles of due process of law, for example, it would include the concepts and the ideals of procedure established by law. So those are my introductory remarks to begin with. Now, post my introductory remarks, we'd like to also look into a small historical context of the history of due process of law, because there seems to be a fair bit of confusion across several textbooks and sources. So our next topic is to understand the history of due process of law. And let's understand what this history is. Due process of law has its origin in the rule of law theory, which you will remember in our earlier lectures, was by a gentleman called A.V. Dicey. And Dicey's rule of law, which was a classic characteristic of the English constitution. I mean, there wasn't a constitution, but classic understanding of the UK constitutionalism, is where due process of law begins. And the basic concept of rule of law is that no man should be punished or can be lawfully made to suffer unless there is a clear violation of the law. And this has been established very clearly in the courts of the land. In very simple words, rule of law is different from every other system of government, which is based on any person having an authority which is discretionary, which can be arbitrary. So if you think about it, Dicey's rule of law is nothing but a very early version of due process of law before the world knew about due process of law, which again comes from the customary origin of common law. See, due process has a very ancient history, which to my mind could be traced from the world's first rights document called Magna Carta in the year 1250. Now, Magna Carta was not a law. Magna Carta was merely a treaty between King John and the enraged sort of upper classes who felt exploited or abused by the British Crown. And though this is not technically important for you, but because I've read the entire Magna Carta, I can tell you section 39 of Magna Carta of 1215 has actually laid the foundation of the terminology of due process. I don't remember the section in its entirety, but the section said, no free person can be taken or imprisoned or exiled or in any manner destroyed unless there is a lawful judgment by the law of the land. This is the basis of due process. See, the due process in common legal system is over a period of time shaped through certain customary practices. But the American Constitution, the US Constitution, truly went a step ahead. And the US Constitution gave statutory recognition to due process by inserting it in the US Constitution itself. The terms law of the land or due process of law were actually transplanted to England, were exported to England by the very English colonies that they were actually exported to US. Sorry, they were exported to US by the same English colonists who eventually led to the independence of the US in 1776. So very interestingly, America gave birth to a very distinct concept of due process of law by taking it from the US, from England, via the same colonists who were stationed in America. The US Congress, which is the US Parliament, incorporated the human rights in the Constitution of the US by the first 10 amendments. This is also called what is called the Bill of Rights. The first 10 amendments are called the Bill of Rights, which is the US's version of fundamental rights. They don't call it fundamental rights. The Fifth Amendment to the US Constitution is the most important, as we were discussing before, because the Fifth Amendment adds a person's life, liberty, and property would not be deprived without due process of law. So life, liberty, and property cannot be taken away by a person, from a person, unless because of due process of law. And the history of the Bill of Rights clearly shows that the people who authored these amendments wanted to apply this only and only to central laws of the US and not state laws, which is why the 14th Amendment happened, where due process of law would be applicable not only to central US laws, but also to state US laws. So US has also had a distinct journey with respect to what is called due process of law. Now that we understand this, we must now understand the meaning and the kinds of due process of law before we get into the due process revolution in India. I'd like to call it a revolution because it's nothing less than that. So, when we look at the meaning and the kinds of due process of law, let's understand this. Due process has derived its meaning from the word law of the land, which is being used in section 39 of the Magna Carta of 1250. That is the origin of it, the law of the land. Due process is the principle that the government must respect all the legal rights that a person has according to the law. Due process keeps the government subordinate to the law of the land, which is exactly what rule of law is, and it protects the people from excesses by the government. And therefore, due process of law can therefore be procedural, and it can also be substantive. In India, procedural due process of law is called procedure established by law. So that's the context of it. Procedural due process of law very simply means whether a government entity has taken an individual's life and liberty without fair procedure required by statute, by the law. If the law has given you a fair procedure and given the powers to the government to take a certain action, and the governmental entity has not followed that procedure to the T as it is written in the law, then it is a violation of procedural due process of law. So, as per statute or as per law. Now, when the government harms a person without following the exact course of the law, it in itself is a violation of due process. It in itself is a violation of the ecosystem that the law has established. Now, that is why it would lead to, say, an examination of the law itself. It could lead to judicial review. It could lead to the review of the general fairness, whether this is actually a fair procedure or not. as the law commands it to be. Substantive due process, on the other hand, means the judicial determination of the compatibility of the substances of the law with the Constitution. Is the law in sync with what the Constitution of the country is? Is it supporting what the Constitution aspires the laws of the country to be? So it looks at a compatibility of the law with the Constitution, which in itself you will see will lead to things like judicial review, judicial activism, Article 32, 226, special powers given to the courts for suo motu, for doing anything in the interest of justice. All of it comes from a safe space of due process of law. So in substantive due process of law, the court is concerned with the constitutionality of the underlying rule rather than the fairness of it. Should this exist or not in the first place? Is it constitutional in nature? Section 66A of the IT Act, is it in sync with what our constitutional understanding of freedom of speech and expression is? So Section 66A is violating Article 19, and that cannot happen, and therefore Section 66A has to be struck down. So procedural due process of law and substantive due process of law essentially work in the same sync. And therefore, every form of review, other than that which involves a procedural due process, is a substantive review. Unless you're looking at a very specific procedure that the procedure was not followed properly, you didn't arrest properly, you didn't give a notice, you did not issue a penalty, show cause. Most kind of judicial reviews in India, most kind of judicial interventions are usually substantive due process. Procedure established by law is a very limited component because the law is generally fair. It's how it's implemented is a problem, and more importantly, the essence of the law cannot be biased. Now, this interpretation that there's something called procedure established by law and there's something called due process of law, this has been understood and accepted by legal experts all across the world. But due process of law, meaning procedural due process and substantive due process, has often been criticized a little bit because it seems very similar to the principles of natural justice, which in a way it is a free and a fair trial, the ability of a person to not be forced to be a judge against them, the removal of bias. That's essentially what principles of natural justice are. This interpretation of due process of law has often been looked at from a very commanding perspective, that the government cannot be unfair to people. There are several countries in the world which recognize a different form of due process. And often the specifics of those countries are not very clear. See, the process of government, which deprives a person of their life and liberty, must comply with the due process clause. Now, you must understand that due process as a term does not have a clear definition. And the nature of the procedure depends on many, many factors, which is why it is one of those open-ended systems that become very difficult to put together, put in one place. Having said that, we now move to the Indian experience of what the due process revolution has been. How has India understood the concept of due process? How have we evolved? A few points on that front. See, the due process principle in India primarily functions on two basic concepts. First, procedure established by law under Article 21 where you are requiring it to be fair, just, reasonable, because of its interactions with 14, 19, and 21. Second, the interrelationships between Articles 20, 21, and 22. This is the one which is least talked about. On one hand, you're saying life and liberty. On the other hand, you're saying preventive detention. On the other hand, you're saying retrospective application for civil law is allowed, criminal law is not allowed. So, due process of law will always be a combination of both of these, dominantly this, and to a limited extent, 20, 21, and 22. Your earlier cases of A.K. Gopalan were essentially on 20, 21, and 22. Mehta Gandhi is a classic example of 14, 19, and 21. To understand this again, the concept of procedure established by law under Article 21 is required to be just, fair, and reasonable. Just, fair, and reasonable is nothing but 14, 19, and 21. Because the principles of 14, 19, and 21 is just, fair, and reasonable. Second, of course, is 21 and the larger ecosystem of 21, under which 20 and 22 exist. See, although Article 21 does not prescribe any quality or any standard for the procedure, its general placement in the criminal justice system has a certain impact on provisions like Article 20, 22, 14, 19 for justice issues. 21 in itself does not have a quality component, does not have a efficiency component. But 14 and 19 do. So, for example, let's stick to the same example. Section 66A, no doubt it has been passed properly. The procedure was followed by the government and the police to arrest those people in the Shreya Singhal case. But it ultimately was affecting a person's freedom of expression. And why was that person only arrested for making an allegedly objectionable post about the city being shut down on the death of a political leader? So it was a classic intersection of 14, 19, and 21. These are the reasons why the due process of law in India has taken so much time. We had to understand the relationship with 14, 19, and 21, which made us understand that India has always believed in the process of due process. And at the back end, the criminal justice system is the closest that we come to due process. Because when you arrest somebody without just cause, you do not give them the basic dignity and the information for being arrested. You preventively detain somebody without adequate reasons and safeguards. What fundamentally gets a question is due process of law. And with this, we must now understand the Constituent Assembly debates. See, what is Article 21 today was Article 15 in the draft constitution. So the debates that happened of Article 15 of the draft constitution, which today becomes Article 21 in the original text of the constitution. In the draft constitution, it was Article 15. So let us now begin and understand this in the right manner. Our Constituent Assembly debates have shown that the members of the Constituent Assembly were fairly divided over the issue. Let's understand why and how that was the case. So when we are trying to understand the Constituent Assembly debate on what Article 21 today is, is actually Article 15 of the draft constitution. To understand the larger concept of due process of law, this is what it means. See, Article 15 of the draft constitution, which is Article 21 today, said no person shall be deprived of his life or personal liberty except according to procedure established by law, nor shall any person be denied equality before law or the equal protection of laws within the territory of India. So the article number 15 of the draft constitution of 1948 had a concoction of Article 21 and Article 14 put together. Now, having said that, it was then transformed into a simpler article called Article 21. And therefore, it is pertinent to understand the debates around due process of law and the relationship between 14, 19, and 21 from a Constituent Assembly perspective. So, a gentleman by the name Qazi Sayyid Karimuddin, who was a Constituent Assembly member, had contended that if the words according to procedure established by law are retained, it would open a sort of a very narrow and a very regressive chapter in the history of constitutional law. The Advisory Committee on Fundamental Rights, which was appointed by the Constituent Assembly, had a very specific and a concurring view with respect to Sayyid Karimuddin. Said that we should look at framing Article 21 on very similar lines to the Fifth Amendment to the US Constitution, which includes due process of law in the life, liberty, and property fundamental right. Mr. Karimuddin had also very specifically cautioned that if the words according to procedure established by law are enacted, then there will of course be a larger opportunity for the government to get away with discretion, to get away with arbitrary exercise of power. Because once the legislature has laid down the procedure through enacting a law, and such procedure is complied by the authority, then procedure established by law in itself is satiated and therefore sufficed. Then the courts cannot question the decision over the authority, largely because the decision has been taken in compliance with the law, and whether it was done through a malevolent intention or the original intent of the law was broken cannot be examined by the court. And that is why he had very categorically suggested that the words except according to procedure established by law should be replaced by the words due process of law. So one could therefore very clearly say that procedure established by law versus due process of law was a very heavily contended discussion within the Constituent Assembly. On the other hand, B.N. Rao, who was the constitutional advisor to the Constituent Assembly, believed that due process of law would give excessive powers to the courts and almost give them an open hand to therefore interfere into the original competence of the legislatures and the lawmakers. He also said, for example, 40% of the litigation in the United States Supreme Court during the past 50 years, and this is the discussion which is happening in 1948, had been centered around due process. And due process meant only what the court thought due process meant. And therefore, to keep a conservative stance and to keep powers within the democratic temples of the country, Dr. B.N. Rao was very clear about not wanting to have due process of law explicitly mentioned. See, the words without due process of law have been taken from the American Constitution, and they have come to acquire a particular connotation. The term due process of law has a necessary limitation on the powers of the state, both executive and legislative. And therefore, it has to be done in the appropriate manner and in the right amount of extent and detail. Now, let's understand this. The doctrine which is implied, which says without due process of law, has a long history in Anglo-American law. It does not lay down a specific rule of law, but it implies a fundamental principle of justice. These words have nowhere been defined, either in the English Constitution or in the American Constitution for that matter. See, due process of law can only be understood by reading the decisions on which due process of law has been applied. Due process simply means that the substantive provisions of law are fair and just. They're not repressive, they're not oppressive, they're not capricious in a way of manner of speaking or arbitrary. And this means the power has been given to the judiciary to review legislations, which of course would have an objection to a conservative outlook who believe that the powers must remain within the legislature. See, due process phase or the due process idea is to guarantee a fair trial both in procedure and in substance. The procedure should be in accordance with the law and should be appealable to the civilized conscience of the community. The various decisions of the American Supreme Court, when analyzed, will stress the four fundamental principles. The first is a fair trial must be given. Second is the court or agencies which take jurisdiction in the case must duly be allowed an opportunity to present their sides of the case. Thirdly, the law which is being applied must be done in the right manner, in the right depth, in the right jurisdiction. And fourth, you must give assistance to people who are in trial. These are the four basic fundamentals which constitute what is called a fair trial in substance. We don't have to worry about it. This is just to make you understand what a fair trial is. Another member of the Constituent Assembly, Shri K.M. Munshi, also supported, said due process of law because it would strike the balance between individual liberty and social control. In fact, Krishna Swami Iyer also was in support of due process of law. Z.H. Lari was also an absolute support, not just in the interest of individual liberty, but also to ensure that the legislatures are working towards a larger good goal. In fact, the great man, Dr. B.R. Ambedkar, was himself, he confessed that he was in a somewhat difficult position with regards to the words procedure established by law versus due process. One point of view was that the due process of law must be there in this article, otherwise the article becomes a hollow one. The other point is you're giving too many questions unanswered. It's opening a Pandora's box of litigation and may make the life of the legislatures difficult. Now, due process of law is also one of the primary conflicts between the legislature and the judiciary. A lot of people do not understand and do not imbibe the fact that due process of law is essentially an aggressive sort of a contradiction in a manner of speaking to separation of powers. Because the judiciary is essentially getting into the righteousness of things. And in a federal constitution, whether it is the US or anywhere else, it is always open to the judiciary to decide whether a particular law passed by a legislature is beyond the powers which have been given to the legislature. And therefore, a very clear and a very, very distinct opinion had to be taken. A final form view had to be taken. And while the members were divided, ultimately, the members chose to retain the phrase, procedure established by law. The Article 15 was broken up into Article 14 and 21 in the final text, where you have equality before law and equal protection of law as Article 14 and life and liberty under Article 21. And that is essentially how the current Articles 14 and 21 came about. They came from a common origin, which is what most people don't know. Now that we understand this, we must now therefore understand what has the judicial interpretation of procedure established by law been? And once we've understood what the judicial interpretation has been, we'll understand the post-Menka Gandhi sort of tenure. So let's look at the judiciary and procedure established by law, because ultimately it's about that. Our next discussion becomes judiciary and procedure established by law. the expression procedure established by law means the procedure has been laid down by the statute or the procedure prescribed by the law of the state. The Supreme Court, immediately after the Indian government adopting the Constitution of India, had sort of faced the task of implementing the words in Article 21. The story actually starts with the A.K. Gopalan case, wherein the words procedure established by law were thoroughly examined. In the A.K. Gopalan case, the validity of the Preventive Detention Act of 1950 was challenged. Preventive detention is if it could reasonably be suspected that you are going to cause a law and order problem and chaos in society, then the police, through an appropriate authority and power, can detain you until they're sure that you will not cause any such nuisance in society, of course, with adequate safeguards in place. So what has essentially happened was A.K. Gopalan was detained, was arrested in a manner on the grounds that his detention was affecting his Article 19, Clause 1, because the restrictions that were placed under the Prevention of Detention Act were unreasonable. Preventive detention does not find any mention as the reasonable restriction under Article 19.1, which is in 19.2. It mentions security, sovereignty, integrity, and all of that. It does not mention preventive detention. So when somebody has been detained, their right to movement has been curtailed. So Article 19 Clause 1 has been violated. And because Article 19 Clause 1 has been violated, right to movement has been detailed. So right to liberty has been detailed. So has been curtailed. So it becomes a question of 21. And therefore, this became a question of 19 and 21. And majority of the judges held in a very narrow way that Articles 19 and Articles 21 are independent of each other. They're exclusive, and there should not be a relationship between the two. And that in itself had to then be reviewed later in the Mehta case. The court said there is a doctrine which is absolutely relevant for UPSC prep. We use it in constitutional law called the doctrine of the directness of legislation. That the law has to be clear, concise, and precise. Don't make assumptions of what everything else could be connected to, because ultimately everything is connected to everything. A legislation that does not directly violate an article, but indirectly encroaches upon any of the articles of the Constitution, does not make the legislation itself invalid. It has to be very clear. You're saying preventive detention takes away freedom of movement. Is it written under Article 19.2 that preventive detention cannot be a reasonable restriction? And that in itself became a question mark. Nowhere does the law say that preventive detention cannot be a reasonable restriction. It could be a function of territory. It could be a function of sovereignty, integrity of the country. The only true approach that the A.K. Gopalan case thought of was that you have to consider the directness of the legislation and not what the result of the detention is going to be. Was the Preventive Detention Act of 1950 clear, concise, simple, and precise? The answer to that question was absolutely yes. Once the majority of the judges arrived at a conclusion that Article 19 cannot be applied to Article 21 because there is no direct correlation, they said it doesn't matter what follows after. And it was a very literal interpretation of procedure established by law. Was the arrest made following all procedures, all safeguards, notices, intimations, presenting the person before a certain authority, or was all that taken care of? Yes, it was taken care of. So the procedure is fine. Procedure is no problem at all. So, as a result, A.K. Gopalan looked at an attempt that was made wherein due process actually meant procedure established by law. It was a part of it all. Now, why do we say so? Because the word law under Article 21 does not merely mean law which has been enacted, but it also means that principles of natural justice have been incorporated. The reasonableness of the law of preventive detention should only and independently be judged by Article 19. And the expression procedure established by law is essentially introducing the American concept of procedural due process. So procedural due process is procedure established by law, and procedure established by law is procedural due process. So therefore, when the Supreme Court made an attempt to read due processes into procedure established by law, it said very clearly, in a very orthodox manner, that the word law under Article 21 should not be equated to the principles of natural justice. These are great arguments. They sound amazing, but don't do it. Keep a very clear, keep a very textual way of life. And if you incorporate such vague principles, such as principles of natural justice, principles of rule of law, principles of reasonableness, principles of correlative fundamental rights, then you will end up being in a circle and almost everything will come to court and you would be able to challenge it. So therefore, the law should be looked at from the point of view of what the law is, not what the law has a deeper layer as. Of course, it was not a unanimous judgment. There were judges who had dissented, but it didn't matter eventually. So what basically happened was, because of this, the Supreme Court delinked Article 19 from 21 to 22. And this view has been the view for a very long time. Not only in the A.K. Gopalan case, but also in the Kharak Singh case, which is India's foremost post-independence privacy case. In this case also, if you remember our lecture on privacy, the court had struck down an administrative direction wherein the police could have domiciliary visits at odd hours at the residence of Kharak Singh because he was a habitual offender. The court in Kharak Singh followed the A.K. Gopalan approach and said, we're not going to get into Article 19(1)(d). It doesn't matter. It is ultimately a question of 21, and we understand it is a violation of 21. But nothing else. You cannot say that just because 21 is being violated, it also means 19 is being violated. So therefore, it became a very interesting sort of a trend. Now, slowly, we see some improvements in this ecosystem. Though the case is not particularly relevant, it's a very minor case, but I still find a very interesting correlation here. The judgment is called the Satwant Singh Sohne judgment versus Union of India. It is a 1967 judgment. The Satwant Singh Sohne versus Kharak Singh versus Union of India judgment. The minority view of Kharak Singh, which is where Article 19 and 21 should be together, becomes the majority view in Satwant Singh Sohne. This case essentially dealt with the withdrawal of passport and travel privileges of an import-export businessman called Satwant Singh Sohne. Ministry of External Affairs had impounded the passport on the ground that he had violated the conditions of what is called, the import license. And therefore, there was an investigation going under the Export-Import Act, and therefore the person could not be traveled. And this gentleman, Satwant Singh Sohne, challenged this action, saying that you are not only violating 21, but you're also violating 14 by singularly taking me out. The Supreme Court, of course, invalidated the government's act of impounding the passport on the grounds that it violates both 14 and 21. So in this case, we see some sort of a growth in the Satwant Singh Sawhney case of 1967, wherein 14 and 21 were linked. You're not allowing a person to travel, liberty is a question. And only this person's travel restrictions have been stopped. Everybody else who's under investigation, they have not been stopped. And this trend, which began, sort of got to be witnessed in a lot of larger actions that were taken. The Cooper case, as we know it to be, the Cooper case, which is the R.C. Cooper versus Union of India, which we will look into from a directive principles, fundamental rights perspective, where the banks were nationalized in 1969. And in the R.C. Cooper versus Union of India case of 1970, the bank nationalization of 1969 was challenged. And in this R.C. Cooper case of 1970, where bank nationalization was challenged, in an absolute miracle, the Supreme Court quashed the Bank Nationalization Act as violative of 14, 19, and 31. Because we were taking away the right to have property, because banks obviously had to be on land. And this set up the foundation of what is called the new interrelationship between fundamental rights. So look how far we've come. We started with 19 and 21 have nothing to do with each other. Then we say, we started with we started with 19 have nothing to do with 21 to 22. Then we moved to how 19 and 21 have nothing to do with each other. Then we moved to 14 and 21 having a relationship with one another. Then we moved to 14, 19, and 31 through the R.C. Cooper case. And it was only a matter of time that we would be looking at a complete change of the way we would look at things. This bank nationalization case said that the manner in which you had done it, the reasons for which you were making banks a nationalized entity in the country were flawed. You were in effect violating core fundamental rights. And this ratio of Cooper then saw a more detailed application in fundamental rights. And such impeccable progress is when people try their luck a little bit. And an off case, a case which is not particularly very important, is called the Jagmohan Singh case. And in the Jagmohan Singh case, this gentleman, this case goes back to 1973. In this case, the validity of Section 302 of the Indian Penal Code was challenged. That death penalty or life imprisonment for murder violates 14, 19, and 21. And this discretionary power given to judges on whether death penalty should be given or life imprisonment should be given is uncontrolled. And this violated the right to equality. This was completely rejected by the court, but it, of course, it started a new approach of looking at things. We were finally at 14, 19, and 21, which is the golden triangle or the holy trinity of fundamental rights, which brings us to the Menka Gandhi case. And the Menka Gandhi case is the start of the new approach. The case is called Menka Gandhi versus Union of India, 1978. And this case finally takes us from procedure established by law to due process of law in its entirety. It is such a landmark case in the history of the Indian legal system that you can now look at a pre-Menka Gandhi and a post-Menka Gandhi era. What had basically happened was that the constitutional validity of Section 10, Clause 3, Clause C of the Passports Act of 1967 was being challenged, largely because it empowered the passport authority to impound the passport of a person in public interest. And that's exactly what had happened to Menka Gandhi. What had happened to Menka Gandhi in this case, and the facts are actually very simple. She was a journalist whose passport, which was issued in 1976 under the Passports Act of 1967, in 1977, the Regional Passport Office of New Delhi had ordered the petitioner or ordered Menka Gandhi to surrender the passport by a letter which was sent out to Menka Gandhi. When Menka Gandhi asked for the reasons about the confiscation of her passport, the Ministry of External Affairs declined to give any reason, said it is in the interest of general public. As a result, a writ petition was filed under Article 32, saying that seizing her passport was a violation of 14, 19, and 21, which led to the Holy Trinity, as we understand it to be. Now, Menka Gandhi said that the Section 10(3)(c) of the Passports Act of 1967 gives discretionary power to the authority to impound the passport without being heard, which is an unjust process, and it is a violation of the right to equality and the right to personal liberty. The 7 judges bench of the Supreme Court upheld the arguments that were made by Menka Gandhi, said that the procedure established under Article 21 should be just, fair, and reasonable. And such a procedure should be tested under 14 and 19 as well. And Justice Krishna Iyer, who had a massive contribution in this case, said that the law which prescribes the procedure for deprivation of life and liberty could not be any sort of procedure, but it has to be one which is arbitrary, which is neither arbitrary nor unfair or not unreasonable. And due process of law is read under Article 21 in the context of analyzing a judgment. So no doubt, as an outcome of Menka Gandhi, we had 2 major impacts. 14, 19, and 21 have a relationship with each other. And due process of law is inbuilt under Article 21, under the provisions of procedure established by law. You can look at the conservative text of Article 21 and say procedure established by law means procedure established by law and nothing else. But if you apply the American doctrine of due process, which is what was applied here, you have to look at the concept of due process towards analyzing government and executive action. And therefore, when we look at all of this, it then opens up a new era of judicial interventions, from a higher degree of PILs to speedy disposal of criminal trials, restricting solitary confinement, liberalization of bail procedures, relaxation of the principles of lucus standi, what is your relationship with the case, procedures for arrest, legal assistance to needy people, avoiding death sentences in the rarest of the rare cases. That has been the impact of due process of law. And that is why due process of law is a very, very important element of the entire ecosystem of 14, 19, 21 and the relationship between the 3. And this development in constitutional law till today has a very, very strong role to play when we look at modern day issues of privacy. We look at privacy to be a violation of 21 primarily, and 19 and 14. We look at gender issues we look at sexuality issues, we look at orientation issues. All of these will have 14, 19, 21. The reason you're able to have all of these is because of the Menka Gandhi case. And that's it for this lecture. Thank you.